आवाज भी नहीं आ रही है।
Yes, we are about to start the conference in next 1 minute, and please do not unmute yourself until you have asked for. आप लोग unmute ना करें please जब तक आपसे नहीं पूछा जाए.
Good morning and namaskar to one and all present here. It's a great pleasure to have you all here today at the National Conference on Emerging Issues in Law, Economic and Business, which is organized by SNS Law College, Research Foundation of India and JHERF in association with the colleges under the aegis of IMI Group of Institutions, Indore Management Institute and Research Center, Sapient Institute of Management Studies, IMI, and IMI Business School. Being a part of SNS Law College and as a coordinator of today's conference, I, Assistant Professor Abhiraj Singh Chauhan, feel immensely grateful to introduce all the eminent guests and speakers for today's conference to take this event forward. I welcome Chairman and CEO RFI, Dr. Saurabh Jain sir, Honorable Director, IMI Group of Institutions, Mrs. Ankita Gupta ma'am, CMD RFI, Dr. Ashok Kumar Gupta sir, our respected management head, Mrs. Nikita Pandey ma'am, VP Academic Affairs, Mrs. Ayushi Gupta ma'am, President North South Board RFI, Dr. Priyadarshini Agnihotri ma'am, President Central India Board RFI, Professor Ajay Jain sir, Principal IMIRC, Dr. Sanjay Sharma sir, Principal Sapient Institute, Dr. Sarika Jindal, Organizing Secretary and HOD Management, Dr. Parul Sharda, HOD Commerce, Dr. Reena Gupta, HOD Law, Mr. Rahul Joshi, and all the participant faculties and the students. It is my great pleasure to welcome our guest of honor, Honorable President, IMI Group of Institutions and Senior Advocate, MP High Court, Mr. A.K. Sethi sir, who is about to join us in some time. Principal, Government New Law College and Dean Academics, Dr. Inamur Rahman sir. Our chief guest, Dr. Archana Raka ma'am, Department Head, School of Law, DAVV. Our special guest, Professor Dr. Debashri Mukherjee ma'am, Professor and Head, Department of Law, Sister Nivedita University, New Town, West Bengal. Our special guest, Mr. Manmohan Joshi ji, CEO, Kautil Academy, Indore, and founder, Vidik Shiksha. And keynote speaker, Supreme Court Advocate, and Global Chairman, International Human Rights Advisory Council, Dr. Anthony Raju. It is wonderful to see such a great panel of speakers for today's conference who are here to enlighten us with their intellect and make this event a greater learning experience for all the participants. Dear participants, due to the ongoing situation of COVID-19, I wish you all are safe and vaccinated, and hence, to remain the same, we organized this conference using this digital platform of Google Meet. Research inculcates scientific and inductive thinking, and it promotes the development of logical habits of thinking and organization. The role of research in almost all fields has been greatly increasing every day. The main purposes of research are to inform action, gather evidence for theories, and contribute to the developing knowledge in field of study. Although there are various reasons which makes research so significant for us. As we understand that research is a tool for building knowledge and facilitate learning. It's a means to understand issues and increase public awareness. It also helps us in succeed in business and various different fields of life. It allows us to disprove life and support the truth. It is a mean to find, gauge, and seize opportunities. It promotes love and confidence in reading, in writing, analyzing, and sharing valuable information. It provides nourishment and exercise for the mind. Now, keeping all those reasons of facilitating research in mind, when we look at IMI, we witness a great institution in making. Historically, educational institutes of repute have always been given due importance to holistic branding, which in turn helped enhance their reputation and standing as institutions' brand. At Indore Management Institute, for over 13 years, we have diligently strived, uphold, and enhanced our reputation and standing with a view to attract talented students, accomplished faculty, and professionals, and also reputed organizations for placements and lifelong executive education. IMI has always kept its focus on providing.
Abhiraj sir, you are on mute.
Am I audible now, ma'am?
Yes, sir.
IMI has always
Sir,
kept
mic खोलिए, open your mic.
IMI has always kept its focus on providing the best possible opportunities in the field of research, not only for the faculties, but also for the teaching fraternity and for the students of the research. In a in a in a span of less than a year, IMI Group has organized 3 virtual faculty development programs, 2 international conferences, and 1 national conference. It is definitely appearing as a hub and a leader for facilitating research and continuously enhancing education quality. The main organizer of today's conference, SNS Law College, is a sister concern of IMI Group of Institution. SNS Law College is one of the fastest growing law college of Central India, which is dedicated to achieve excellence in educating professionals, serving the public, and fostering justice. We aspire to prepare lawyers to serve their clients, to serve the judicial system and the public with high level of accomplishment and commitment to highest ideals of legal profession, and we hope to continue doing that in the coming years. Moving forward, I would now like to firstly invite a very charismatic and dynamic personality of IMI family, who is also the organizing secretary of this conference and who is head of the management at IMI, Dr. Parul Sharda ma'am. Over to you, ma'am.
Thank you so much, sir. I hope I'm clearly audible to everyone.
Yes,
And,
ma'am.
a very warm welcome once again from my side, being the MP Secretary of Research Foundation of India and also serving Indore Management Institute, the IMI group of institutions, as a associate professor and head of management department. So today I'll be introducing you about the Research Foundation of India. RFI is strictly working for the social upliftment and higher education quality and Indian research promotions in the form of events like international and national conferences, seminars, workshops, symposium, and other activities. RFI works for the integration of intellectual ideas across the globe to fulfill the thirst of innovation of humanity. Research Foundation of India is concerned with improving the educational process by encouraging scholarly inquiry related to education and practical application of the research results. Research Foundation of India is working for the research and development of higher educational institutes and the top universities from India like Symbiosis, AIT, Sage University, SKDU, Apex, Eklavya, B.R. Ambedkar Central University, Atal Bihari Hindi University, Gujarat University, IMI group of institutions, and many more. RFI members are faculty, researchers, graduate students, and other distinguished professionals with rich and diverse expertise in educational research. RFI does not take any financial sponsor from any government body. Research Foundation of India has organized 500 plus international conferences and workshops, FDPs, symposias, etc. all over the world. Now RFI is having 87 chapters in India and 18 chapters in Asian and other countries, and categorized in 5 boards: West, East, South, North, and Central Zone. Well, introducing about the team, the vibrant team of Research Foundation of India, I would take the opportunity to start with our leader, Dr. Saurabh Jain sir, who is the chairman and CEO of Research Foundation of India, followed by Professor Dr. Ashok Kumar Gupta sir, who is the Chief Managing Director of Research Foundation of India, Dr. Reshu Jain, President RFI, Professor Ajay Jain, President Central India Board, Research Foundation of India, Chairman and CEO Dr. Saurabh Jain, North Board India President Shri Amit Chand, New Delhi, North South Board President Dr. Priyadarshini Agnihotri ma'am, Central India Board President Ajay Jain sir, North Board India President Dr. Devdutt Indoria, West Board India President Professor Abhinish Karosia sir, National Convener Dr. Rajat Sharma sir, MP State President Dr. Manish Dubey, MP State Convener Dr. Sanjay Prasad, Vice President CIB Dr. Sangeeta Baruka ma'am, Joint Secretary Central India Board Dr. Subrato Dev, Joint Secretary Indore Zone Ranjana Razak, President World Virtual Conference Forum Dr. Prakashani Tiwari, MP State Vice President Research and Innovation Wing Dr. Dipali Ambe Prasad, Dr. Indira Dikshit Joint Secretary Student Zone, Dr. Seema Agrawal Joint Secretary RFI MP State, Dr. Piyush Soni President Bhopal Zone, Co-Chapter Head Indore Zone Professor Yashashri Dubey, Vice President World Virtual Conference Forum Dr. Priyanka Chawla, Vice President Research and Innovation Indore City, Professor Nikita Sharma, Convener Indore Zone, Dr. Gaurav Malhotra, Co-Chapter Head Indore Zone, Dr. Manisha Pandey, Central India Board Office in charge, Ms. Priyanshi Dubey, all chapters, all officers, Madhya Pradesh Research Foundation of India. I beg the pardon if I have missed out any of the names from the Research Foundation of India. Technical Head and Program Assistant, Mr. Yuvraj Pashle, sir. Moving ahead, introducing our Chairman of Research Foundation of India, Dr. Saurabh Jain. Dr. Saurabh Jain is now a Chairman of Research Foundation of India. Has also been appointed as a Vice President of World Federation of Science and Technology and President of Engineering Research Foundation. Dr. Jain also involved in Research Foundation of India consultancy unit named Educational Research Analyzers Private Limited. Along with, he is also involved in a number of companies like ISSI Consultancy Services, Edu Academic Incorporation, ARGA, ERF, Ascent Tech Private Limited, Blueprint Publication Delhi, and Black Pearl International Publication, and many more. He has been awarded as a gold medalist in Master of Technology from Government Engineering College, and he did his first doctorate in Power System Engineering and second doctorate in Control System Engineering. Dr. Jain has organized more than 500 national and international events like conferences, FDPs, workshops, and talks in multidisciplinary areas. He has published more than 100 research articles in national and international journals. Along with, he has published 35 research and edited book, authored book in multidisciplinary areas. On the name of Dr. Jain, 5 patents and copyrights has been published from India. He is an expert of solar and renewable energy concepts. I request Dr. Saurabh Jain to shower his words of wisdom with us. Over to you, Dr. Saurabh Jain.
Thank you, Dr. Paru Sarda and Mr. Abhiraj Singh Chauhan. First of all, I would like to congratulate all the participants and dignitaries to successful national conference on emerging issues in law, economics, and business, organized by S&S Law College Indore. I would like to congratulate to Chairman of S&S Law College, Principal, Head of the Department, and all the officers and professors of S&S Law College Indore. As we know very well, this conference based on emerging issues in law, economics, and business. As everyone know about this, we are facing the problem of COVID-19. So definitely COVID-19 affected to Indian economy. So this title also is focusing for the what is the economics and business is affecting by the COVID-19. Also, I would like to thanks Mrs. Nikita Pandey, CEO IMI Group of Institution, Dr. A.K. Sethi, Senior Lawyer, MP High Court Bench Indore, President IMI Group of Institution, Dr. Inamur Rahman, Principal Government New College Indore, Dean Devi Ahilyabai University Indore, Dr. Archana Raka, Department Head School of Law, DAVV Indore, Professor Dr. Devshri Mukherjee, Professor and Head of the Department of Law, Sister Nivedita University, Newtown, West Bengal, Mr. Manmohan Joshi, CEO Kotil Academy, Indore, Madhya Pradesh, Dr. Anthony Raju, Supreme Court Advocate and Global Chairman, International Human Rights Advisory Council, Mr. Abhiraj Singh Chauhan, Assistant Professor S&S Law College, Dr. Pallavi Mane, Mr. Rahul Joshi, and Dr. Paru Sarda. Special thanks to our Chief Managing Director, Professor Ashok Kumar Gupta, Dr. Priyadarshini Agnihotri, North Board President, Central Board India President, Professor Ajay Jain, all President, Chapter Head, Vice President, and all officers of Research Foundation of India Wing. So again, congratulate to all the participants to have a good look for souvenir with related to international conference. So thank you very much. Over to you, Dr. Prasad. Thank you.
Thank you so much, sir, for your words of wisdom. And Abhiraj, sir, please proceed. Abhiraj, sir, please proceed.
Yes, ma'am. Am I audible?
Yes, sir.
Thank you, sir. Thank you, ma'am. Well, any organization works smoothly when there is support and there is direct involvement of the management. And where there is such a management, it definitely means that it comprises of great leaders. We at IMI always feel lucky to have one such personality who is our driving force. With these lines, now I'd like to invite one of the most charming and inspiring personality of IMI, our respected management head, Mrs. Nikita Pandey ma'am, to please join us and share her thoughts for today's conference.
Thank
Over
you
to
so
you,
much,
Nikita
Abhiraj
ma'am.
sir. Thank you so much. Thank you for these valuable words. I don't know how much I fulfill of these words or not, but yes, thank you. Really, thank you so much for this. So, a very warm good morning to all of you. Once a great man said, "Education is that whole system of human training within and without the schoolhouse walls, which molds and develop men." With these words, I am feeling grateful to address this national conference of SNS Law College Indore. It's a big day for SNS Law College Indore. We have maintained our legacy of continued education and research in this tough time too, with the help of Team RFI. Today, we all are gathered here for our national conference, which emphasizes on the importance of research. I congratulate Conference Organizing Committee, Dr. Saurabh Jain, Chairman RFI, eminent speakers from being a part of this intellectual gathering. I welcome all the eminent speakers and all the participants from across the nation. SNS Law College has world class infrastructure that facilitates excellence in teaching, research, consulting, and other professional activities. We have a long standing reputation for innovation. Our desire to do things differently lies in our foundation. Even though, if I'll talk about our president, Mr. A.K. Sethi, who is a senior advocate in Indore High Court, his motto behind this college is to develop these type of students who can be a future lawyer and who can contribute in the law field. We believe that students are the center of this whole education system, and to nurture them is our prime responsibility. Every year we develop new certification programs according to the recent trend in legal industry, and in fact we do lots of collaboration in order to increase the overall value of the education system, and also which focus on the developing critical thinking, writing and presentation skills, as well as strong background in the field of law. Students are given an opportunity to develop their character and sensitivity through various activities and extracurricular programs. However, we know very well that we have made only a beginning. Though we are very proud of what we have achieved, we are aware too that we cannot realize our vision simply by trying to provide the best teachers or by providing the best courses unless our students become active learners and pursue their studies and research independently. We know only too well that realization of the vision depends on active participation of learners and educators. We therefore strongly hope that our student will become active learners and education could be well trained to build a strong base for students and grow into global leaders which creative and independent minds who will be able to cross national as well as disciplinary boundaries. At the same time, we sincerely expect our students to become men and women of character who are genuinely concerned with social justice and human rights. At the end, let's hope and pray that this pandemic shall end soon and we'll get on our normal life soon. Will it be the new normal? Till then, I request everyone to follow all the COVID guidelines, wear masks, wash hands frequently, and maintain social distancing. Thank you and stay safe. Over to you, Abhirat sir.
Thank you so much, ma'am. And as expected, you always fill us with energy, great energy. And we hope that we'll keep those words true. And now I would again request Dr. Parul Sharda ma'am to please invite for the words of blessings and appreciation CMD Professor Dr. Ashok Kumar Gupta sir.
Thank you
Over
so
to
much.
you, Parul ma'am.
Thank you so much, sir. So, introducing our CMD Professor Dr. Ashok Kumar Gupta sir, who is a Chief Managing Director of Research Foundation of India. He is having BE, PGDM, DMS, LLB, and PhD degrees. He has published more than 50 research papers in national and international journals. He is having a rich 40 years of experience, around 30 years in industrial field and 10 years in educational field. Recently, Professor Dr. Ashok Kumar Gupta has visited USA and visited various renowned universities like Northeastern University, Boston, USA, Harvard University, Manchester's Institute of Technology, Boston University, etc. As far as association with RFI is concerned, he is considered as one of the founder member of RFI, and looking to his dedication and hard work in RFI, he is now promoted as Chief Managing Director at Research Foundation of India. We are seeking your words of blessing, sir. Over to you, Dr. Ashok Kumar Gupta, sir.
Thank you, Dr. Parul. Hello, everyone. This is Professor Dr. Ashok Kumar Gupta, CMD RFI. I feel honored to be invited to this national conference on emerging issues in law, economics, and business. This conference is organized by S&S Law College, Indore, Research Foundation of India, and JHRF in association with World Virtual Conference Forum, Indore Management Institute and Research Center, Indore Management Institute, IMI Business School, S&S Law College, Indore, Sapient Institute of Management Studies, Indore. And this is sponsored by World Federation of Science and Technology, International Research Guide Federation, Academic Research Guide Association, and Edu Academy. Our experts shall discuss the various issues related to this seminar, such as law, human rights and development, law and health ecosystem, healthcare from the perspective of human rights, justice, and legal empowerment, access to justice and public legal awareness, legal empowerment and marginalized group, the law in emergency situation, economic development and inclusive legal system, etc. The main areas of law that are growing considered as cyber security, cannabis, labor, elder law, energy, IP, and health. These growth areas didn't only affect new lawyers who are interested in transitioning to these 8 fields. Legal issues are litigation, including cases relating to contracts, construction, constitutions, and employment issues like gender, race, age, disability, and civil rights, draft-related legal pleadings, and make court appearances in state and federal courts and at administrative hearings. Legal issues or issue of law is a legal question which is the foundation of a case. It requires a court's decision. It can also refer to a point on which the evidence is undisputed, the outcome of which depends on the court's interpretation of the law. The law deals with civil cases involving conflicts between people or institutions such as business, etc. A civil case usually begins when a person or organization determines that a problem can't be solved without the intervention of the court. Lawyers are people who have gone to law school and often may have taken and passed the bar exam. An attorney is someone who is not only trained and educated in law, but also practices in the court of law. Lawyer is anyone who could give legal advice. The definition of law is a set of conduct rules established by an authority, custom, or agreement. This is all about the theme of this seminar. As we know that the activities of the Research Foundation of India is carried out by a core group of academic and support staff and a large network of senior academicians in higher education globally. The real challenge before RFI is to expand capacities in higher education to keep ahead of the curve of rising domestic and global demand. Its mission is to improve the quality and standard of higher education. We at Research Foundation India are expanding our activities from India to abroad to become global players. As far as Indore Management Institute, that is IMI group is concerned, the institute was set up in 2008. Since the IMI is consistently creating history by giving its best to the students. Indore Management Institute has world-class infrastructure that facilitates excellence in teaching, research, consulting, and other professional activities. IMI has a long-standing reputation for innovation. The desire to do things differently lies in the foundation students are placed in companies like Jaro Education, PCS, DYJUS, Pascal, Value, Bajaj Finance Group, Axis Bank, Capital Trust, FinPay, Gati, KV, Vedantu, HDFC Bank, SAF, Small Finance Bank, and other such reputed organizations. Historically, educational institutions of repute have always been given due importance to holistic branding, which in turn helps enhance their reputation and standing as institution brands. At IMI, for over 13 years, they have diligently strived to uphold and enhance the reputation and standing with a view to attract talented students, accomplished faculty and professionals, and also reputed organizations for placement and lifelong executive education. It produces promising outcomes in the learning and teaching practices. Now, it's my honor and privilege to welcome the galaxy of dignitaries, especially Shri A.K. Sethi ji, who is Senior Advocate, MP High Court, Branch, Indore, and President, IMI Group of Institutions, Indore. I would like to welcome Dr. Inamur Rahman, who is Principal, Government New College, Indore, and Dean, Devi Ahilya University, Indore. I would like to welcome also Dr. Archana Raka, Department Head, School of Law, UTD DAVV, Indore. I would like to welcome Professor Dr. Devshri Mukherjee, Professor and HOD, Department of Law, Sister Nivedita University, New Town, West Bengal. I welcome Mr. Manmohan Joshi, who is CEO, Kautilya Academy, Indore, and founder, Vidik Shiksha. I would also like to welcome Dr. Anthony Raju, Supreme Court Advocate and Global Chairman, International Human Rights Advisory Council. My sincere thanks to Mrs. Ankita Gupta, MD, IMI Group of Institutions, Indore, Mrs. Ayushi Gupta, VP Law, S&S Law College, Indore, Mrs. Nikita Pandey, CEO, IMI Group of Institutions, Indore, Dr. Sanjay Sharma, Principal, Indore Management Institute, Indore, Professor Rahul Joshi, HOD, S&S Law College and Convener, Professor Abhiraj Singh Chauhan, Assistant Professor, S&S Law College and Coordinator of this seminar, Professor Aditya Narayan Mishra, S&S Law College and Coordinator of this function, Dr. Parul Sharda, who is the Organizing Secretary, Dr. Pallavi Mane, Assistant Professor, IMI College, Indore. A special thanks to Dr. Saurabh Kumar Jain, Chairman and CEO, RFI, who has granted permission for organizing this wonderful seminar in a short span of time. I am thankful to Professor Ajay Jain, Dr. Priyadashini Agnihotri, and all board members and chapter heads of RFI, along with the entire team, RFI members, and all the participants and management of S&S Law College, Indore. I am thankful to all who have given their input in this seminar and the participants who made this seminar a successful event. The participants are not those who are sitting here, but the content of the session shall be shared through electronic media and be available for everyone with the permission of the resource person. We have noted down the various queries raised by you in due course of time, and we'll answer those in a short span of time. For more information, you may contact through our official mail ID info@researchfoundationofindia.com and our website researchfoundationofindia.com. Thanks for your patience for listening to me. Thank you again. Over to you, Dr. Parul Sharma. Thank you.
Thank you so much, sir. You always motivate us to do more, and we are setting the benchmarks with your blessings. I request Professor Abhiraj Singh to proceed with the event.
Thank you, Dr. Ashok Kumar Gupta, sir, for your beautiful words and your continuous support. Well, another support and source of energy for us is one such personality who is a great scholar herself. Having studied in the premier law schools of India, she, with her great experience and innovative thinking, working continuously for the betterment of the law students of SNS Law College and the students of IMI. With these words, I would like to invite none other than Mrs. Ayushi Gupta ma'am, VP, Academic Affairs, SNS Law College, to please join us and share her thoughts for the day. Over to you, Ayushi ma'am.
Thank you so much, Abhirat sir, for your sweet words. And a very good afternoon to everyone. I welcome and congratulate all the participants, all the dignitaries from RFI and my team of SNS Law College, and all the other participants from all over the globe who graced us with their presence in this national conference. As the conference theme covers the discipline of law, and being a law graduate myself, I would like to throw some light on the importance of research in the field of law. Anybody who's even remotely related to the legal sphere can vouch for the fact that the phrase they hear most commonly is legal research. Legal research is an indispensable asset for every law student and every legal professional. Legal research is a process designed to help you check for legal precedents, and it can be used to find answers for various legal questions. It's very important to carry out legal research if you want to figure out if a legal issue has any precedent or not. It is needed for just about any type of case. If you want to be a lawyer, if you want to study, if you want to go for internships, it is very important that you are good with your research. Once a great man said that research is to see what everybody else has already seen and to think what nobody else has thought. This is exactly legal research put in very good words. Research methodology includes understanding the different types of research that can be undertaken, derivation of a title from a topic, ethical considerations, art of citation of all, which are imperative in writing a good research paper as well as a good case brief. Last but not the least, it increases your knowledge and makes you a better legal professional. This is all from my side. There are a lot of people here who have a lot of things to share. So thank you for your patient listening, and stay safe, everyone. And congratulations to Team IMI for conducting this conference. Thank you so much, sir. Over to you, Abhirat, sir.
Thank you so much, ma'am. Whatever you have said is definitely going to give us a better encouragement, and we promise you to deliver more such events in the coming future. And now is the time to call upon the chief guest of today's conference. And I feel very privileged to introduce our chief guest.
Abhirat, sir, sorry to
Dr.
interrupt. Yeah,
Yes.
if is it's about Mr. A.K. Sethi, so he'll be joining in few minutes. We'll
Uh,
just confirm once he'll available.
right,
Actually,
ma'am.
yeah, I think you have already
Ma'am,
got the information about it, right?
I'm inviting our chief guest for today, Dr. Archana Raka, ma'am.
Okay,
And
sure. Carry on.
uh, ma'am, I beg your pardon in advance if I miss out anything in your introduction, because your introduction is full of greater achievements. And as I know, as I have studied under your self, I understand that and you keeping time for this conference is a great privilege for us. Well, for all the participants, Dr. Archana Raka ma'am possesses over 23 years of teaching experience in various law subjects. She is also having corporate experience of working in Grasim Industries Limited. She completed her PhD in law from DAVV in the year 2000. She was a gold medalist in LLM from DAVV. She was also awarded. She was also accredited with various awards, like she was awarded with Vidhi Shiksha Ratan Award by Socio and Legal Research Foundation, Banaras Hindu University in the year 2020, and recently in 2021 she was awarded as with Research Recognition Award by Devi Ahilya Vishwavidyalaya for her outstanding contribution in legal research for the year 2020. She has also published 2 books under her name. First one is Public Utility Laws, and the second is Fundamentals of Reviews of Literature. She has also published over 45 papers in various international and national journals, and she has also presented over 40 papers in various seminars, international conferences, and national conferences. Presently, she is the head of the School of Law Department, UTD, under Devi Ahilya Vishwavidyalaya, and she is also in charge of the legal cell of Devi Ahilya Vishwavidyalaya Indore. And with these words, I feel greatly honored to invite Dr. Archana Raka ma'am to share her great thoughts regarding research and this conference, which is organized for the first time by SNS Law College. Over to you, Raka ma'am. Namaskar, ma'am.
Good morning to the guest of honor, Shri A.K. Sethi, Senior Advocate, Madhya Pradesh High Court, Dr. Inamur Rahman, Dean, DAVV, and Principal, Government Law College, Indore. Special guest, Professor Dr. Debashri Mukherjee, Head of Department, Law, Sister Nivedita University, West Bengal, and Mr. Manmohan Joshi, CEO, Hotel Academy, Indore. Keynote speaker of this session, Dr. Anthony Raju, Supreme Court Advocate, New Delhi, and the organizers and all participants present here for the inaugural session of this national conference on emerging issues in law, economics, and business, organized by Research Foundation of India and SNS Law College. SNS Law College is always focused around holistic development and have recently successfully completed a 1-week long FDP on research techniques. I give my heartfelt congratulations for organizing this conference. Today's conference theme is very pertinent and relevant, especially in the times of pandemic. I would like to highlight certain issues in relation to emerging trends in law, economics, and business, with special reference to COVID-19. Firstly, the pandemic has shifted our entire offline transaction to online, be it education or litigation, banking, business, etc., raising serious cybersecurity concern and breach of data privacy. Still, the data protection bill has not seen the light of the day, and thus all of us need to understand the importance of prevalent cyber crimes and take measures to not become a victim of the same. Secondly, online business must also take into account the development of online dispute resolution techniques and implement the methods so that disputes can be settled effectively. Thirdly, contractual obligation in business have come to a standstill as the terms of the contract could not be enforced due to a force majeure clause leading to frustration of contract. It is the lockdown due to virus that has made it impossible for airlines, hotels, caterers, and other service providers to deliver as promised, contractors to complete real estate and infrastructure projects on schedule, among others. Under such context, the promising party is justified to use the force majeure clause. However, this does not imply that the promiser is excused from fulfilling conditions attendant to the use of force majeure clause. Finally, issues related to vaccine nationalism. It is a phenomena in which government quote higher prices to pharma giants to prioritize the vaccination of their population. This practice does not ensure equitable distribution of vaccine across the globe, and the same is opposed by the majority of pharma IP owning countries like US, UK, China, etc. A similar instance was in October 2020 when TRIPS waiver proposal initiated by South Africa and India was opposed by developed countries. The task of getting these IPR hurdles out of the way to prevent millions of avoidable deaths remain an uphill battle for civil society. One sector which has had a positive impact due to COVID-19 is the IT sector because the growth has been incredible. Now, these IT companies, through their schemes under CSR, must incorporate measures to empower the underserved communities in India. The need of the hour is a public policy that serves the society and is best suited to cater the interest of all participants in the society. All of us present here need to think over these issues and come up with potential solutions in this endeavor of the national conference. I congratulate once again to the organizers for such a theme which is very relevant in the present time. Thank you for your patient listening and thank you for inviting me. Thank you.
Thank you so much, ma'am. It's always been an honor to share any platform with you, and your words of encouragement and wisdom are always going to be a guiding light for us. Thank you for joining and sparing time from your busy schedule. And with that note, I would like to move on to the address by Principal IMIRC, Dr. Sanjay Sharma, who himself is known to be a great researcher. He has published more than 50 research papers in various international, national journals. And he's one such person who always guides all the faculties, all the students, and motivates them to put forward and to bring on their best. And also, he is the one who is contributing a lot in the field of the research, whether it's a management or law or economics or any other subject. Dr. Sanjay Sharma has completed his PhD in management and about to complete his PhD in commerce. And it's a great privilege and honor for all of us to have him as our principal. And Dr. Sanjay Sharma, sir, over to you, sir. We are eagerly waiting to hear for your words.
Thank you, sir. Thank you very much for your kind words. Good morning to all the respected and distinguished guests and all the participants from different institutes. This is a good platform for the researcher provided by SNS Law College and Team RFI. But this is a very good initiative in the sense as many of the participants are our law students. Here our objective of conducting this conference becomes successful as we divert our young generation towards the research. So this is, I think, this is very good start. As a first conference, we have not only invited a guest from a different galaxy of uh, institutes, all the participants from different institutes, but also motivate a young generation for the research. Big congress to HOD Law and SNS Law team, RFI team, and I am very also thankful to Dr. Parul Sharda for coordinating and cooperating from both the sides, RFI and our institute. Thank you. It is over to you, sir. Thank you very much.
Thank you so much, Dr. Sanjay Sharma. Well, I don't want to make it an excuse, but I've been running through bad throat and fever also. But I wanted to be a part of this conference very desperately. I never wanted to miss this chance when the SNS Law College is organizing such a conference, a national conference, for the very first time. And it has been it has become possible in this tough situation in this pandemic times, and we are utilizing this digital platform. I never wanted to miss this chance. So somehow I just wanted to have this great opportunity to to join all the eminent personalities from academics and from the field of research. And with this, I would I would like to move on to our guest of honor, addressed by our guest of honor, Dr. Inamur Rahman sir, who is principal of Government New Law College and who is Dean Academics, Devi Ahilya Vishwavidyalaya, and he's also a resource-centric person for all the researchers in the field of law, and he has been serving in this field from more than 3 decades. And with his vast experience and his greater personality, it's always great to listen to him. So, Dr. Inamur Rahman, sir, over to you, sir.
Abhiraj sir, there is some medical contingency at his end, so he might not be joining the conference. And if he joins, we will make his session at the end. Kindly proceed.
All right, ma'am. All right. All right. So, as Parul ma'am just informed, Dr. Rahman sir is he has not yet joined, but we are joined by our special guest for today, Mr. Manmohan Joshi sir. And now I would like to call upon Mr. Manmohan Joshi sir, and a very warm welcome to you, Manmohan Joshi sir. And for all the
Thank you very much.
Namaskar sir. And for all the participants, Mr. Manmohan Joshi sir is also known as MJ sir, and he's an advocate by profession, a teacher by passion, a renowned scholar of law, a very renowned author of law books, and a great motivator, a thinker, a blogger, a YouTuber, an educationist, and an entrepreneur. There are not enough words to describe all the qualities of Mr. Manmohan Joshi sir. He is having academic qualifications of BSc, LLM, MBA, PG diploma in cyber laws, and PG diploma in human rights. He is currently working as CEO of Kautilya Academy. He's also a founder of Vidhik Shiksha, a YouTube channel which is having more than a million subscribers, 1.3 million subscribers. And as an author, he has also published more than 25 books in various subjects. He is also a research scholar, and till now he has published 25 research papers in various national and international law journals. He has always been called upon as a keynote speaker in various universities across the country. He is known for his legal awareness. He's known for his thoughts on law, legal education, women empowerment, and he has delivered many such lectures and speeches over these topics regarding personality, career, stress management, time management, and whatnot. He Wherever he has been into, he's like he has reached on the top of that, and because of it, he has also been given many awards and accolades. He was also awarded in Oxford University for his work in the field of legal education and awareness. In the year 2019, he was awarded as the most inspirational personality of India by WPI and India Today Group in uh, year 2019. He was awarded with Education Excellence Award 6 times in a row from 2014 to 2019. He was awarded with Teachers Excellence Award in 2017, Education Icon of the Year 2018, Best Teacher of Law in 2016. He was also appreciated by the Governor of Madhya Pradesh for one of his books on SC/ST and Prevention of Atrocities Act 1989. He also received Yuva Vyaktitva Samman by Yuva Sansad. He was Star of the City by Yashika News, and he received Utkrishт Lekhan Samman and various other awards for all his works. A great personality and a person who always inspired the students to do their best, to work on their potential. And I have also been a keen listener to him, and it's a privilege to have him today on this national conference organized by SNS Law College. Mr. Manmohan Joshi sir, I welcome you, and we all are eagerly waiting to listen to your words, especially the students of SNS Law College who have already listened to you once. And sir, over to you for your address.
Thanks a lot, Abhiraj sir, for this beautiful introduction. Guest of honor, Mr. A.K. Sethi sir, Dr. Inamur Rahman sahab, Dr. Archana Raka ma'am, Debashish Mukherjee ma'am, and Dr. Anthony Raju, and prominent jurists, those who are the part of this conference, honorable respected teachers, and my dear friends. Research is an essential part of academics and it has to be. मैं आपको बताऊं, बहुत सारे कॉलेजेस ऐसे हैं जहां पर में रिसर्च पर ध्यान ही नहीं दिया जा रहा। एसएनएस लॉ कॉलेज का ये इनिशिएटिव जो है, ये बड़े ही काम का है। मुझे लगता है कि इससे रिसर्च में जो जाना चाहते हैं स्टूडेंट्स, उनको बड़ा अच्छा एडवांटेज मिलेगा, एक अच्छा प्लेटफॉर्म मिलेगा। 2019 में आपको बताऊं, न्यू एजुकेशन पॉलिसी का जो ड्राफ्ट आया था, उसमें रिसर्च के लिए बात की गई है। स्पेशली अराउंड 20,000 करोड़ रुपीस का एक फंड बनाया जाएगा, इस बारे में बात की गई थी। लेकिन जब रिसर्च की बात करते हैं तो रिसर्च के बारे में मैं कुछ बातें करूंगा आज, और इमर्जिंग जो इश्यूज हैं लॉ के फील्ड में, उस पर भी मैं बात करूंगा। एंड इफ आई हैव मच टाइम देन डेफिनेटली आई वुड लाइक टू
sorry to disturb sir. Joshi sir, sorry to disturb you. Sir, your voice is fluctuating, sir.
It may be due to network issue.
Yes, sir. Sir, it is fluctuating. Somewhere it is very low, somewhere it is high.
Actually, it's on very lower side.
Yes, 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 sir.
Am I audible enough now? Hello.
Still, it is slow. Can you use the mic, sir? The earphones,
Whether my voice is clear? Abhiraj sir, Parul ma'am.
Yes,
sir,
sir.
your voice is clear, but it's a bit low. If you can adjust the mic, I guess.
Hello, am I audible enough? मेरी आवाज साफ आ रही क्या आप लोगों को?
So now it was better when you spoke in Hindi. सर थोड़ा सा आप अगर अपनी बुलंद आवाज में बोलेंगे तो डेफिनेटली ये प्रॉब्लम भी दूर हो जाएगा।
Or I guess you can just use the audio system of laptop.
I'm receiving no response from any of you.
Sir,
I think he
voice is
cannot-
very low.
Yeah.
Joshi sir, can you hear us?
Yeah, clearly.
Yes, sir. Sir, voice is very low from your side.
Am I audible now?
Sir, it is very low. It is audible, but it is very low.
Very low.
If you can come a bit near to the audio.
यस सर, हेडफोन लगा के आप बात करेंगे तो आएगी।
हाँ, मैं ईयरफोन लगा लिया मैंने। अब बताइए, अब क्या आवाज साफ आ रही है?
Yes,
It's better, sir.
it's better.
Is it better now? Hello.
सर वॉल्यूम बढ़ाइए थोड़ा।
Sir, please increase the volume.
हाँ, अब बताइए क्या अभी आवाज ठीक है?
Yes, sir.
Shall I start? Shall I continue?
Yes, sir. Please continue.
So nice of you. Thank you, ma'am. Extremely sorry for the inconvenience. I think there is a
No,
network
no,
issue.
no. It's okay,
And,
sir.
and actually, we are talking about the digital India. But in this digital India, we are unable to develop such infra that we can connect online without any hindrance. And the things are developing day by day, and we hope that sooner or later it will be what appropriate up to the mark. So I was talking about the research. When we talk about the research, I was when my voice was fluctuating, I was talking about that in the year 2019, when Government of India introduced a new education policy. In that particular education policy, there was a scope for research. And as I remember, 20,000 crore rupees fund was there. The Government of India was talking about कि research के लिए ये दिया जाएगा. और मैंने एक ड्राफ्ट बनाकर भेजा था। मैम आपको बताऊं कि जिन लोगों का रिसर्च, ये मैं सारे स्टूडेंट्स की तरफ से भी बोल रहा हूं मैं, क्योंकि ये स्टूडेंट्स के फेवर में रहता हूं हमेशा। तो जिन स्टूडेंट्स का रिसर्च सिलेक्ट होता है, मुझे लगता है कि हमको उनको एक एडवांटेज देना चाहिए, खासकर उनकी फीस नहीं लगनी चाहिए। अगर कोई रिसर्च पब्लिश कर रहा है, जैसे एग्जांपल दूं कि मैं एक स्टूडेंट हूं और मैं अपना एक रिसर्च पब्लिश करवाना चाहता हूं, तो मुझे तो उस रिसर्च को करने के लिए फंड मिलना चाहिए। उस रिसर्च को करने के लिए शायद कई तरह की फैसिलिटीज मिलनी चाहिए, सो दैट द रिसर्च कैन बी बेस्ड ऑन प्राइमरी डेटा। जिन लोगों ने अभी रिसर्च किया है वो उनको पता होगा कि दो तरह के रिसर्च दो तरह के डेटा पर बेस्ड है, प्राइमरी डेटा एंड सेकेंडरी डेटा। आज की डेट में हो ये रहा है कि मैक्सिमम जो रिसर्चर्स हैं वो सेकेंडरी डेटा पर ही अपना रिसर्च बेस कर रहे हैं। उसका रीजन ये है कि सेकेंडरी डेटा के लिए हमको ना तो बहुत ज्यादा फंड चाहिए, ना बहुत ज्यादा टाइम चाहिए, ना बहुत ज्यादा रिसोर्सेज चाहिए। गूगल पर बैठकर आप कीवर्ड्स डालें, डेटा सामने आ जाता है, उसको बेस करके एक रिसर्च पेपर तैयार कर लें, प्रिपेयर कर लें। और अगर वो बिल्कुल थोड़ा सा यूनिक है, उसमें जो है किसी भी तरह का डेटा आपने कहीं से लिया नहीं है, कुछ अपने आइडिया आपने डाले हैं, तो वो आपका सेलेक्ट हो जाता है और पब्लिश हो जाता है। इससे क्वालिटी की रिसर्च हमारे पास नहीं आ पा रहे हैं। सेकेंडरी डेटा पर बेस्ड रिसर्च बहुत ज्यादा क्वालिटी का नहीं होता, ये हम सबको पता है। लेकिन प्राइमरी डेटा पर अगर रिसर्च बेस करना होगा तो डेफिनेटली स्टूडेंट को अपने फील्ड से बाहर जाना होगा। हो सकता है शहर से बाहर जाना पड़े, लेकिन इतना तो सही है कि उसको कॉलेज से बाहर जाना पड़ेगा, अपने घर से बाहर जाना पड़ेगा और उसको डेटा कलेक्ट करना पड़ेगा। इट विल टेक टू मच टाइम, टू मच रिसोर्स एंड यस एक्सपेंडिचर। थोड़ा इस पर अगर ध्यान दिया जाए, गवर्नमेंट ध्यान दे, कॉलेजेस ध्यान दे, तो शायद बढ़िया हो पाएगा। क्योंकि आज की डेट में लॉ के फील्ड में लीगल रिसर्च की बहुत जरूरत है, सो दैट द न्यू व्हाट आई कैन से चैलेंजेस कैन बी फेस्ड। जैसे हमारा आज का टॉपिक ही है इमर्जिंग इश्यूज इन द फील्ड ऑफ लॉ। और आज की डेट में जो मुझे समझ में आता है कि साइबर क्राइम सबसे बड़ा इशू है। क्योंकि मैं कुछ डेटा पढ़ ही रहा था तो मैंने देखा कि इन द मंथ ऑफ मे 1,90,000 साइबर अटैक्स पर वीक वाज रिकॉर्डेड। हम इंडिया की बात कर रहे हैं जहां पर अभी साइबर क्राइम से निपटने के लिए, उससे डील करने के लिए ना तो हमारे पास बहुत ज्यादा रिसोर्सेस हैं, ना ही साइबर पुलिसिंग जो है बहुत ज्यादा इक्विप्ड है। और ना ही इन सब के लिए हमारे पास हम कहें इफेक्टिव लॉज तो हैं, लेकिन इम्प्लीमेंटेशन के तरीके नहीं है। आईटी एक्ट 2000 आ गया हमारे पास में, देन आईटी एक्ट 2008 से उसको अमेंड कर दिया गया। पनिशमेंट भी ठीक ठाक ही है, अगर कोई आपकी आईडी हैक कर ले तो उसको 2 लाख रुपए तक का फाइन हो सकता है, 2 साल तक की सजा हो सकती है। ठीक है, सारी चीजें अपनी जगह हैं। ये इम्प्लीमेंट कैसे होगा, इसके लिए बहुत जरूरी है रिसर्च की। रिसर्च करने के लिए स्टूडेंट्स को बाहर जाना होगा, पुलिस स्टेशन में जाना होगा, पुराने डेटा देखने होंगे, कितने साइबर क्राइम हुए, साइबर क्राइम रिकॉर्ड कैसे हो रहे हैं। और हम में से मुझे लगता है कि जितने लोग आज यहाँ कॉन्फ्रेंस में जुड़े हुए हैं, मैक्सिमम ने कभी ना कभी कोई साइबर क्राइम फेस किया ही किया होगा। आईडी तो बहुत फ्रिक्वेंटली लोगों की हैक हो रही है। लास्ट टू लास्ट मंथ जो है मेरी खुद की फेसबुक आईडी हैक हो गई थी, और अभी बीच में ही शायद 7 डेज के पहले मुझे आईफोन पे, जो बहुत सिक्योर माना जाता है, एक मैसेज आया मेरे कैलेंडर और व्हाट्सएप मैसेंजर्स में। लिखा था वहां पर में कि योर फोन हैज बीन हैक्ड एंड द डेटा कैन बी शेयर्ड पब्लिकली। तो ये मैसेजेस कैसे आ रहे हैं, कहाँ से आ रहे हैं, किससे आप कंप्लेंट करेंगे, कैसे होगा। तो ये इमर्जिंग जो इश्यूज हैं, जिनमें की सबसे बड़ा इशू आज की डेट में लीगल फील्ड के सामने, लीगल फ्रेटर्निटी के सामने जो है, वो है साइबर क्राइम और साइबर स्पेस को लेकर है, क्योंकि अवेयरनेस लोगों के पास नहीं है। और एक डेटा ये कहता है कि जो साइबर क्राइम करने वाले लोग हैं, उसमें अराउंड 70% प्लस जो लोग हैं वो टीनेजर्स हैं, वो स्कूल गोइंग, कॉलेज गोइंग स्टूडेंट्स हैं। ये बहुत बड़ा थ्रेटनिंग ट्रेंड है, आपको ये समझना चाहिए। और इसमें भी जो सबसे बड़ा जो डेटा ये कह रहा है कि जो ऑफेंसेस हैं वो साइबर क्राइम के, उसमें थेफ्ट तो है ही है, अपार्ट फ्रॉम दैट चीटिंग इज द बिगेस्ट क्राइम। और इन दोनों से ज्यादा आगे चलते हैं तो पोर्नोग्राफिकल कंटेंट अपलोड करना, उनको शेयर करना, उनको डाउनलोड करना, ये जो ऑफेंसेस हैं ये बहुत ज्यादा आज की डेट में दिखाई पड़ रहे हैं साइबर स्पेस में। अपार्ट फ्रॉम दैट साइबर टेररिज्म एक बड़ा चैलेंज है आज की डेट में, क्योंकि इस कोई भी कहीं से भी कनेक्ट हो पा रहा है और किसी भी जगह बैठ करके कंप्यूटर सिस्टम को टारगेट करके ऑफेंसेस किए जा रहे हैं। तो आने वाला समय, आने वाला टाइम, क्योंकि जो है वो साइबर एरा का टाइम है। हम सब ये जो आज हम कॉन्फ्रेंस कर रहे हैं, मुझे लगता है कि फ्यूचर में कॉन्फ्रेंस ऐसे ही होंगे और ऐसे ही इसका ट्रेंड होगा। ये बात और है कि हम बेटर इक्विप्ड होंगे, चीजें ज्यादा अच्छी होंगी। लेकिन ऑनलाइन लर्निंग, ऑनलाइन शॉपिंग, ई कॉमर्स, ई गवर्नेंस और ई लर्निंग, ई टीचिंग के एरा में हम साइबर क्राइम को नहीं ओवरलुक कर सकते। तो रिसर्च इस फील्ड में बहुत ज्यादा डिमांड करती है, और मैंने जैसा बताया ये रिसर्च प्राइमरी डेटा पर बेस्ड हो तो शायद बहुत अच्छा होगा। और उसके लिए कॉलेजेस को और आप लोगों को ही इंस्पायर करना होगा। एसएनएस लॉ कॉलेज बहुत बढ़िया काम कर रहा है इस फील्ड में, कि आज ये कॉन्फ्रेंस उन्होंने ऑर्गेनाइज किया है। इससे पहले भी ह्यूमन राइट्स पर एक आपने कॉन्फ्रेंस किया था जिसमें मेरा आना हुआ था। तो एक जो एरा मैंने बताया, चैलेंजिंग जो इश्यूज हैं वो है इस फील्ड में साइबर क्राइम के, और दूसरा जो मेरी स्टडी कहती है वो है ह्यूमन राइट्स के फील्ड में। अभिलाष सर, मेरे पास 2 मिनट और हैं बोलने के लिए।
जी जी बिल्कुल सर,
ठीक है।
प्लीज सर।
दूसरी जो फील्ड है वो ह्यूमन राइट्स की फील्ड है, क्योंकि आने वाला टाइम, क्योंकि हम हर एक ह्यूमन अपने राइट्स को लेकर अवेयर हो रहा है। अगर हम एक डेकेड पहले की बात करें तो बहुत ज्यादा अवेयरनेस नहीं था, लेकिन ये कोविड का टाइम जो है, जहां लोगों को टेक्नोलॉजी से, एक समय था जब टीचर्स स्टूडेंट को कहता था कि मोबाइल जेब में रखो, अब वही टीचर स्टूडेंट को कह रहा है कि मोबाइल बाहर निकालो। ये जो कोविड का एरा है, इसने हमको ऑनलाइन दुनिया से जोड़ दिया इन अ पॉजिटिव वे। इससे पहले बहुत कुछ नेगेटिव वे में था, लेकिन अब जो ऑनलाइन की दुनिया है, जो साइबर की दुनिया है, इसका यूज किया जा रहा है लर्निंग के लिए। और आज की डेट में जब ह्यूमन राइट्स को लेकर लोग अवेयर हो रहे हैं, तो रिसर्च की डिमांड यहाँ भी है कि क्या लोगों के ह्यूमन राइट्स प्रोटेक्ट हो रहे हैं। ह्यूमन राइट्स लॉ तो हमने इनेक्ट कर दिया 1993 में, यूडीएचआर आ गया 1948 में, लेकिन क्या इम्प्लीमेंटेशन हो पाया है। जैसा कि हमारा फैक्ट्री एक्ट 1948 ये कहता है कि जो फैक्ट्री वर्कर्स हैं उनको एक वीक में 40 आवर्स काम करना चाहिए, means 8 hours a day, then 5 days a week, 5 4s are 80, 5 8 40 hours, so 8 5 are 40। तो 40 आवर्स अगर काम करेगा वर्कर तो ही वो ह्यूमन है, अदरवाइज वो इनह्यूमन है या ह्यूमन राइट्स का वायलेशन है। अब इसके लिए हमको करना ही होगा, फैक्ट्रीज में जाना होगा, वहां से डेटा कलेक्ट करना होगा, और ये पता चल पाएगा कि कितने लोगों के ह्यूमन राइट्स प्रोटेक्ट हो रहे हैं। या दूसरा एक इंपॉर्टेंट ह्यूमन राइट से बताऊं मैं आपको, जिसे कहा जाता है राइट टू मैरी। यूडीएचआर 1948 के आर्टिकल 16 में हम जाएंगे तो राइट टू मैरी की बात ये कहती है कि एक जो एडल्ट मेल है या एडल्ट फीमेल है, इंडिया की अगर हम बात करें, तो ये आपस में आपसी कंसेंट से मैरिज कर सकते हैं। कहीं नहीं लिखा कि सोसाइटी की, पेरेंट्स की, परिवार की मर्जी चाहिए, और वो भी इर्रेस्पेक्टिव ऑफ कास्ट, रेस, रिलीजन, नेशनलिटी। क्या ये ह्यूमन राइट्स, बेसिक ह्यूमन राइट्स लोगों को मिल पा रहा है? इस पर भी बहुत ज्यादा रिसर्च की जरूरत है। और मुझे उम्मीद है कि ये जो स्टूडेंट्स हैं, जो आने वाला फ्यूचर है लॉ की, ये ये आने वाले टाइम में इस पर जरूर काम करेंगे। और आपने जो मेरा इंट्रोडक्शन दिया उसमें एक चीज और रह गया था, वो था लर्निंग। आई एम स्टिल लर्निंग एंड थैंक्स a lot for giving me the opportunity to speak to your students and this stuff. Abhiraj sir. If anyone has any question to ask, if I can take questions, it will be better. Or as you say.
Sir,
Abhiraj sir. Yeah.
sir, as you said that most of the people are doing the research in secondary database. So, can you tell me what are the areas which can be explored? Because I am partially belongs to the law domain. So, can you tell me what are the areas one can do the research in law domain in the primary using the primary database?
Ma'am, for example, just I'm pursuing my PhD. You are already a PhD one. I'm learning just. So my topic of PhD is the critical analysis of domestic violence law in empowering women in India. Now, when I took the topic, it is a very challenging one because in order to do research in this particular field, I have to go to each and every woman. If I am taking 100 women, those who are the part of society, and what kind of protection they are getting from the laws enacted by the parliament, I have to check. और मैं आपको बताऊं ये बात कि अभी तक जो मेरा रिसर्च है तो उसमें ये बात आ रही है कि मैं अगर ये 100 लोगों की बात करूं तो इसमें से मैंने क्लासेस डिसाइड कर रखे हैं। कुछ लोग जो हैं अफ्लुएंट सोसाइटी के हैं, कुछ जो हैं वो ऐसे हैं जो वर्कर, जो फैक्ट्री वर्कर्स हैं वो सोसाइटी के हैं, कुछ विमेन हैं जो कि डोमेस्टिक वर्क कर रही हैं वो हैं, कुछ जो लॉ फील्ड के हैं। और आपको बताऊं 94% प्लस, सिर्फ इतने, मैंने जो 100 लोगों का ग्रुप लिया उसमें सिर्फ 6 लोगों को ये पता था कि व्हाट आर दी लॉज, कि हाँ कानून भी बने हैं विमेन एम्पावरमेंट के लिए। 94 को तो यही नहीं पता कि कोई लॉ बना हुआ है। सो आई एम कलेक्टिंग प्राइमरी डेटा इन दिस फील्ड। जैसा कि मैंने आपको एक एग्जांपल दिया, अगर हम ह्यूमन राइट्स पर कर रहे हैं तो फैक्ट्री वर्कर्स के ह्यूमन राइट्स वायलेट तो नहीं हो रहे हैं, ये चेक करने के लिए स्टूडेंट्स कैन गो टू 1 or 2 फैक्ट्रीज और 10 फैक्ट्रीज जहां वो डेटा कलेक्ट कर सकते हैं, उनका इंटरव्यू ले सकते हैं कि क्या आपको पता है कि आपके ह्यूमन राइट्स ये हैं और आपको समय पर टाइम पर आपको सैलरी मिल रही है क्या। जैसे हमारे पास एक बड़ा अच्छा UDHR 1948 को फिर मैं कोट करता हूँ, आर्टिकल 24 में लिखा हुआ है कि जो वर्किंग आवर्स होंगे वो डिसाइडेड होंगे 40 डेज इन अ वीक, टाइम बाय टाइम उनको सैलरी मिलेगी। और टाइम बाय टाइम का मतलब है इक्वल इंटरवल्स में, मींस मंडे टू मंडे मिले, 7 डेज में मिले, फोर्टनाइटली मिले या मंथली मिले। अपार्ट फ्रॉम दैट उनके कुछ राइट्स और हैं, जैसे एग्जांपल के लिए मिनिमम वेजेस, जो मिनिमम वेजेस गवर्नमेंट ने डिसाइड कर रखा है उनके उससे कम में वेज ना मिले उनको। फिर उनके जो मेडिकल ट्रीटमेंट है उसका इंतजाम जो है वो एम्प्लॉयर, जो फैक्ट्री का ओनर है वो करे। ऐसी बहुत सारी चीजें हैं जो उनको पता ही नहीं होती। हम एक रिसर्च ये प्राइमरी डेटा पे कर सकते हैं कि क्या उनके ह्यूमन राइट्स वायलेट हो रहे हैं, और यकीन मानिए निकल कर ये आएगा कि हाँ ह्यूमन राइट्स वायलेट हो रहे हैं, बिकॉज नो वन इज अवेयर ऑफ देयर लीगल राइट्स। दिस इज द रीजन। बट पारुल मैम, व्हाट वी आर डूइंग, जैसे मैंने बताया, अभी अभिराज सर ने बताया कि 25 रिसर्च पेपर्स मेरे खुद के पब्लिश हुए हैं, और मैं ये बता रहा हूँ आपको, बिल्कुल जिम्मेदारी से ये बात कर रहा हूँ कि उसमें 21 रिसर्च पेपर्स जो हैं मैंने सेकेंडरी डेटा पर बेस करके ही तैयार किया। और मुझे ये समझ में बहुत बाद में आया कि सेकेंडरी डेटा पर रिसर्च बेस करना, इसका सीधा सा मतलब है कि वी आर नॉट डूइंग एनीथिंग न्यू। अगर सेकेंडरी डेटा पर बैठकर रिसर्च बेस करना है तो आप बताएं, मैं तो हर एक महीने में एक रिसर्च पेपर प्रिपेयर कर दूं। आप इस बात से अवेयर हैं और मैं इस बात को बड़ी जिम्मेदारी के साथ कह रहा हूं, क्योंकि प्राइमरी डेटा बहुत टाइम टेकिंग है। मतलब हर किसी के पास जाना, उसका इंटरव्यू लेना, फिर वो जो सामने, जैसे मान लेते हैं आप किसी फैक्ट्री में जा रहे हैं, हो सकता है आपको एंट्री ही ना मिले फैक्ट्री में, हो सकता है फैक्ट्री का जो ओनर है वो आपको बाहर से ही भगा दे कि आप ये क्या कर रहे हो, हमारे जो एम्प्लॉइज हैं इनको आप डरा रहे हैं या उनको आप अवेयर कर रहे हैं। या जैसे मैं बताऊं, मैंने जो 100 लोगों का अभी इंटरव्यू किया, विमेन के बारे में बात कर रहा हूँ, उसमें से बहुत से को मैंने ये कहा कि ये जो बातें हैं आप अपने घर में शेयर ना करें। उसका रीजन है कि हस्बैंड कहेगा अच्छा ये सब सिखा के जा रहा है, ये क्या पता कहीं पकड़ के मुझे मेरी कुटाई हो जाए। उसका रीजन ये है कि हमारा जो डोमेस्टिक वायलेंस प्रोटेक्शन एक्ट 2005 है, उसका सेक्शन 3 ये कह रहा है, सुप्रीम कोर्ट का एक जजमेंट है मैम, जहां पर में ये कहा गया, अ हस्बैंड कैन नॉट ऑर्डर हिज वाइफ बिकॉज वाइफ इज नॉट अ सर्वेंट, एंड इफ अ हस्बैंड इज ऑर्डरिंग हिज वाइफ टू डू एनी वर्क, he is committing the offense of domestic violence. What a law! और हस्बैंड क्या समझ रहे हैं? वो समझ रहे हैं कि हमने अपनी ये वाइफ तो गुलाम बनकर आई है। और जो लॉ के स्टूडेंट सुन रहे हैं, मैं उनको बता दूं, मेरी रिसर्च का ये पार्ट है पारुल मैम, दैट हस्बैंड इज अ वेरी डेरोगेटिव वर्ड। हस्बैंड का मतलब हिंदी में हम समझे तो होता है जानवर को पालने वाला, पशुपालक। गूगल करके देखिए, एनिमल हस्बेंड्री इज अ ब्रांच ऑफ साइंस। एनिमल हस्बेंड्री का मतलब ही है पशुपालन हिंदी में। और क्योंकि हमको पता नहीं है, महिलाएं मिलवा रही हैं मीट माई हस्बैंड। या एक शब्दावली में और बताऊं, मैंने इन वर्ड्स पर बड़ा अच्छा रिसर्च किया है। एक शब्द हमारे पास हिंदी में पति शब्द है। अगर कोई लाख का पति है, कोई करोड़ का पति है, कोई अरब का पति है, तो महिला का पति कैसे होगा? जस्ट इमेजिन। क्योंकि पति का मतलब है द ओनर ऑफ द प्रॉपर्टी। एंड वी आर यूजिंग सच डेरोगेटिव वर्ड्स आउट ऑफ नॉन अवेयरनेस और इग्नोरेंट। सो ये सब चीजें होंगी जबकि स्टूडेंट्स बाहर आएगा और बाहर जाकर के वो काम करेगा। कोई क्वेश्चन मेरे पास में आया, शायद मैं देख नहीं पाया। अभिराज सर, अगर आपके पास दिखाई पड़ रहा हो तो प्लीज बताइए।
So the question is, if you can please brief about primary research in artificial intelligence.
देखिए, जब हम आर्टिफिशियल इंटेलिजेंस की बात कर रहे हैं तो आर्टिफिशियल इंटेलिजेंस तो बिल्कुल ही नई दुनिया है आज की डेट में। और आर्टिफिशियल इंटेलिजेंस पर तो बड़े रिसर्च चल रहे हैं। एप्पल जैसी कंपनियां और टेस्ला जैसी कंपनियां आर्टिफिशियल इंटेलिजेंस पर बड़ा काम कर रही हैं। आपकी जानकारी के लिए, हमारे पास में आर्टिफिशियल इंटेलिजेंस को चेक करने के लिए या आर्टिफिशियल इंटेलिजेंस पर रिसर्च करने के लिए कोई प्राइमरी डेटा मुझे नहीं समझ में आता कि हमारी सोसाइटी में कहीं मिलेगा। इसके लिए तो बिल्कुल आपको रिसर्च इंस्टीट्यूट में ही जाना पड़ेगा जहां इस पर वो काम कर रहे हैं कि किस तरह से सॉफ्टवेयर के बेस पर आर्टिफिशियल इंटेलिजेंस को डेवलप किया जा रहा है। और मेरा ये मानना है कि इन फ्यूचर, भविष्य में हर एक जगह आर्टिफिशियल इंटेलिजेंस होगा। सिर्फ एक फील्ड है जुडिशरी, जहां आर्टिफिशियल इंटेलिजेंस काम नहीं कर पाएगा। मेरा रिसर्च इस पर यह कहता है कि क्योंकि जब हम बात कर रहे हैं डिस्क्रिशनरी पावर, एक शब्द हमारे पास में है लॉ के फील्ड में, जिसे हम कहते हैं विवेकाधीन शक्ति, द पावर इम्पोज्ड बाय द लॉ टू थिंक। जैसे मैं आपको एक एग्जांपल देता हूं। एक केस है, अगर आपको याद हो, मीठू वर्सेस स्टेट ऑफ पंजाब। इस केस में हुआ ये कि हमारी इंडियन पीनल कोड में एक सेक्शन है 303 which talks about the punishment of an imprisoned person who is serving life imprisonment. अगर वो ड्यूरिंग लाइफ imprisonment कोई ऑफेंस करता है तो उसको डेथ पनिशमेंट है if he attempts only to commit a murder of any person and inflicts any harm. Section 303 read with section 307 paragraph 2 Indian Penal Code says that. और सुप्रीम कोर्ट ने मीठू वर्सेस स्टेट ऑफ पंजाब में 303 को इनऑपरेटिव कर दिया। उसका रीजन सिर्फ इतना था कि 303 आईपीसी कहती है द पनिशमेंट इज ओनली डेथ पनिशमेंट, मींस द डिस्क्रिशनरी पावर ऑफ द कोर्ट वाज टेकन आउट बाय दिस पर्टिकुलर सेक्शन। और कोर्ट ने कहा कि जब तक डिस्क्रिशनरी पावर नहीं होगा, मींस हम डिसाइड करेंगे डेथ पनिशमेंट देना है या लाइफ इंप्रिजनमेंट में देना है, या लाइफ इंप्रिजनमेंट देना है या 10 ईयर्स तक का इंप्रिजनमेंट देना है। अच्छा, जैसे हम बात करते हैं सेक्शन 379 आईपीसी में 3 ईयर्स तक का इंप्रिजनमेंट है, अप टू 3 ईयर्स। means court can pass a sentence of 1 hour imprisonment to 3 years imprisonment. This is the discretionary power of the court. तो जब हम लॉ की बात करते हैं, अगर आपने कहा कि एक आदमी ने चोरी की, समझिए एक आदमी 2 रुपए चुराता है, एक आदमी 2 करोड़ रुपए चुराता है, एक आदमी 50 करोड़ रुपए चुराता है। जो 2 रुपए चुराने वाला है उसकी सर्कमस्टेंसेस कुछ और है। जो 5 करोड़ का थेफ्ट कर रहा है, ही इज स्टीलिंग प्रॉपर्टी, उसके पास एक गैंग है। क्या हम सबको एक समान पनिशमेंट दे सकते हैं? आर्टिफिशियल इंटेलिजेंस यहां जाके फेल हो जाता है, क्योंकि आर्टिफिशियल इंटेलिजेंस काम करता है डेटा पर। एक डेटा आपने फीड कर दिया, उस डेटा पर वो रिजल्ट निकाल देगा। जैसे आज की डेट में ज्योतिष आर्टिफिशियल इंटेलिजेंस पर बेस्ड हो गया है पूरा का पूरा, या मिमिक्री आप देखें आर्टिफिशियल इंटेलिजेंस पर बेस्ड है पूरा का पूरा। आज की डेट में जब एडिटिंग हो रही है, एडिटिंग पर आर्टिफिशियल इंटेलिजेंस इतना ज्यादा हावी है कि वो लिप सिंकिंग करके निकाल कर ला रहा है, पता ही नहीं चल रहा है ये आदमी बोल रहा है या किसी और की आवाज है। और सॉफ्टवेयर और टेक्नोलॉजी इतनी ज्यादा जल्दी से ग्रो कर रही है कि आर्टिफिशियल इंटेलिजेंस आने वाले समय में हर एक चीज पर बेस्ड होगा। इसके लिए प्राइमरी डेटा कैसे कलेक्ट करेंगे, ये मुझे समझ में फिलहाल तो हमारी सोसाइटी में कहीं नहीं दिख रहा, क्योंकि हमारे पास सेकेंडरी डेटा ही अवेलेबल है। जैसे मैंने बताया, जो रिसर्च कर रहे हैं एप्पल और टेस्ला बड़ा रिसर्च कर रहे हैं, मैंने बताया, और उनके पास प्राइमरी डेटा है, क्योंकि वो सेकेंडरी डेटा कहाँ से लेकर आए। हम कैसे कलेक्ट करेंगे, मुझे खुद को एक बार रिसर्च करना पड़ेगा। डेफिनेटली आई वुड कम टू यू, आई वुड लव टू कम टू यू। अभिलाष सर। Thank you, Rupali. Thank you very much.
Sir,
Thank
can you
you.
give me an sir?
Sir, I guess there is another question.
Yeah, please do ask. Shravani.
Sir, can you give me any brief explanation about public health aspect? How can I take a primary data in this field, sir?
In which field, Shravani? Sorry, I could not hear you completely.
Public health and law related aspects, sir.
Public health. Okay, okay. Public health related to law. Basically, when we talk about public health care, अभी तो बहुत बढ़िया बात ये हो गई है कि कोविड के टाइम पर people are aware about the health care. And when we talk about the laws related to public health care, there are certain laws. For example, laws related to pregnancy, pregnancy termination of pregnancy, law related to negligence death. Certain laws are there. So in order to collect the primary data, number one, you have to do one thing. You have to go to a police station and you have to take out some FIRs. जैसे मैंने आपको एग्जांपल दिया, फीमेल फिटिसाइड बहुत बड़ा ऑफेंस है आज की डेट में. देन अबॉर्शन एक बहुत बड़ा ऑफेंस है. अगर आप आईपीसी में जाएं तो सेक्शन 312, 313, 314, these sections are talking about that. अगर मैं बात करूं टर्मिनेशन ऑफ प्रेगनेंसी की, तो ये इलीगल है अपने आप में. एंड 304A इंडियन पीनल कोड का बात करता है, आपको बताऊं मैं, अबाउट द नेग्लिजेंट डेथ कॉज्ड बाय हेल्थ केयर पर्सन. अब इसको ये कहां ये ऑफेंस हुए हैं, इसके लिए पहले तो हमको करना ये होगा, प्राइमरी डेटा के लिए हमको जाना होगा पुलिस स्टेशन. क्या इन सेक्शंस में कोई एफआईआर आए हैं? बिकॉज एफआईआर इज अ पब्लिक डॉक्यूमेंट, एनीवन कैन आस्क टू द पुलिस स्टेशन एंड पुलिस इज बाउंड टू गिव द सर्टिफाइड कॉपी ऑफ दैट. दूसरी जानकारी हमको मिल सकती है, प्राइमरी डेटा ये मिल सकता है कोर्ट में. अगर आप किसी भी डिस्ट्रिक्ट कोर्ट में जाएं तो वहां पर में एक डिपार्टमेंट होती है जहां से आपको जजमेंट की कॉपी मिलती है. तो आप वहां जाकर बात कर सकते हैं क्या पर्टिकुलर इस सेक्शन के बेस पर या ये इस लॉ पर बेस कोई जजमेंट किसी का कोर्ट का आया हुआ है. ये दो हमारे पास प्राइमरी डेटा है. द थर्ड थिंग, अगर हम इसके आगे और जाना चाहते हैं तो वो जो विक्टिम है उस पर्टिकुलर ऑफेंस का, जिसका जजमेंट या एफआईआर आपके पास में है, वी कैन go to that person as well and take an interview of that person कि क्या हुआ था, क्या प्रॉब्लम थी, क्यों आपको लगा कि ये ऑफेंस है. और ये इस तरह से हम प्राइमरी डेटा कलेक्ट कर सकते हैं. ग्रुप बना सकते हैं 10 लोगों का, 100 लोगों का, 200 लोगों का, जैसी आपकी कैपेसिटी है, जितना बड़ा आप रिसर्चर्स का ग्रुप है इस पर ये डिपेंड करेगा. बट दीज प्राइमरी डेटा, योर रिसर्च कैन बी बेस्ड ऑन दीज प्राइमरी डेटा एंड न्यू थिंग कैन कम आउट.
Thank you so much, sir. As always, you have not only cleared all the doubts, but you have definitely inspired many students of law so that they can think of research as their primary field and not a secondary option after completing their law. They feel like they should pursue research, and it will give them vast opportunities. बहुत बहुत धन्यवाद सर. आपने जो भी बातें कही हैं डेफिनेटली वो कंट्रीब्यूट करती हैं रिसर्च की फील्ड में, लीगल रिसर्च की फील्ड में. और
sir, still I am learning and I have one objection that you have mentioned my name as a guest. I am the family of SNS Law College.
Definitely sir, definitely. बिल्कुल, you are part of the SNS Law College family and you have been there since the very beginning, sir. You have been part of the SNS from the beginning of the college.
There is a law affair in between the SNS Law College and me.
Yes sir, definitely. Definitely.
I love to be amongst you people because आप जो काम कर रहे हैं, I just want to salute you all, क्योंकि स्टूडेंट्स के बारे में इतना सोचना ये आजकल कॉलेजेस नहीं कर रहे हैं.
Thank you
अगर
so much.
आप जो काम लगातार करते रहते हैं, मुझे बहुत खुशी होती है देख करके कि ऐसे भी प्रोफेसर्स, टीचर्स और कॉलेजेस हैं, those who are thinking about in the welfare of the students. Not only the education is not business for them, so you are one of them. So I definitely would love to salute you all. And
thank you sir, thank you. It's so nice of you. It's so nice of you, sir, for saying these things. And definitely sir, we have that objective of providing the best to our students, and not only to our students but all the students who belong to this field, who want to learn.
We can see that it is visible.
Yes,
your objective, your intention is visible, Abhiraj sir.
And that is also only happening because of the eminent resource persons and personalities like you who always come together with us whenever we call them. And to all those personalities who are here, who have joined us for this conference, we are deeply grateful to all of them. And thank you sir for your time. I know you you always have a busy schedule, but taking time for us, we are grateful for that.
Sir, always, but students are always in the priority, and SNS Law College,
Definitely.
मैंने बताया कि I'm always there for you. Thanks a lot for having me here.
Thank you, sir.
Parul ma'am, Ayushi ma'am, Abhiraj sir, and all the dignitaries and respectable honorable teachers and staff of SNS Law College. Thank you.
Thank you, sir. Thank you so much, sir. And with that, we are moving ahead with our another special guest for today's conference. And it's a great privilege once again for me to introduce a personality who belongs to the field of law. She is Professor Dr. Debashri Mukherjee. And with her introduction, Namaskar, ma'am. And for all the participants, Professor Dr. Debashri Mukherjee has completed her PhD in law from the University of Burdwan. She is a gold medalist at both postgraduate and undergraduate levels. She was awarded with Saroj Mazumdar Medal by BU. She is having 15 years of teaching experience and in PG level and 6 years of experience in practicing at High Court of Kolkata and over 2 years of research experience at ICFA Research Center. Professor Dr. Debashri Mukherjee has published around 25 articles in edited volumes and in various law journals. She has edited books on various aspects of law, and she has been a resource person at various FDPs and seminars organized by leading universities across the country. And she has interest areas including environmental laws, human rights, international law, and international relations. We are deeply honored to have you, Professor Dr. Debashri Mukherjee, on this platform of SNS Law College for this national conference. We are grateful to you for sparing your time, and we all now want to hear what you have to say, your thoughts on this conference, which is organized by SNS Law College today. Over to you, Debashri, ma'am.
Thank you, Abhiraj sir. I hope I'm audible.
Yes, ma'am, you are audible.
From morning to afternoon, it has been a wonderful session as we are going towards the afternoon hours with the inaugural session itself. But it has been a great learning experience to hear from such great speakers with whom you have arranged. First of all, I would like to thank the Research Foundation of India along with the SNS Law College Indore for organizing this conference on such a very relevant area. And the conference itself reminds us or tells us that yes, today the need of the hour is interdisciplinary research. And we cannot stop only by limiting ourselves to doing research only in the domain of law. But I think what is necessary today is whenever we think of undertaking any kind of legal research, the aim and or the objective should be that whatever outcomes, whatever solutions we come up with, they are something which help in bringing some kind of a utilization in the society. They bring about some kind of a reformation, whether it be in the domain of law, but they should actually help in the enhancement of the society's values, ethics, society's security laws, everything. So the sub-themes that you have chosen are really very relevant and contemporary, not only because of the pandemic, but today as we stand here, the study of human rights has gone a long way from the days of the Magna Carta. And we find today that we are in the third generation of human rights where we have discussions going on economic empowerment, we have discussions going on the right to development, the right to sustainable development. And also today in the days of the pandemic, one thing which has to be highlighted is we are not only talking of right to healthcare, but we are talking of adequate healthcare. That is also one of the very important and pertinent rights which we have understood more because of this pandemic. So discourses and deliberations at various levels on human rights, on development, on the interplay and the interface between human rights and development have been going on. But yes, legal research should aim to focus not only on the interface of law and development, but it should actually try to come up with much more adequate research being undertaken in areas where very emerging challenges are addressed. Like say suppose yes today we know even in India we have judgments coming up on the right to internet being delivered and Kerala being the first state to come up with such a law. But how far are we able to bring it into action? That is the most important point. And I think the major scale of research that is necessary to be undertaken today is not on devising or designing a law, but we need to understand the applied perspective of it to understand how far it is being enforced, what are the areas or the loopholes that are faced by the enforcement mechanism, and how we can solve those issues. That is perhaps the more important need of the hour if you really want to bring about a change in the lives of the people. So I hope that today's conference will actually have papers from the participants where these kinds of issues will be discussed upon, and these in turn will lead to more leads towards finer research being undertaken. And as Mr. Joshi has rightly pointed out, what is necessary today is definitely empirical research because that helps you to go deeper into the root of the problem and try to address it. So once again, I take this opportunity to thank the organizers, more especially Dr. Parul Sharda, whom I have been able to connect only through the faculty development program, but it has been wonderful to be associated with Research Foundation of India and IMI group of institutions, and especially SMS Law College. Thank you for having me here, and I wish the participants and the organizers great success and great learning outcomes from this conference. Thank you. Namaskar.
Thank you so much, ma'am, for your wonderful words, and your presence itself means a lot. And it has become possible only through this virtual mode, and we are deeply grateful to you for sparing some time and uh, sharing your words of wisdom with the participants and our students.
Thank you, sir.
Thank you, ma'am. And with that, now we have been joined by our guest of honor, and I have been given this privilege to introduce a personality which needs no introduction. I, along with the entire IMI family, is so proud to be led forward by a person who is one of the most renowned personality in the field of law. But not only that, he is known as an epitome in the same field. He first had the vision of having an institute like IMI for the society so that IMI can produce future leaders and serve the society in the best possible manner. And we every day work just to fulfill his dream, to make it true, and we do that by taking inspiration from his life. I can only hope to be half of that person, the person he is today, and it's a great privilege to be under his light. With these words, now I'd like to welcome President of IMI Group of Institution, Mr. A.K. Sethi sir, who is a senior advocate at Madhya Pradesh High Court bench Indore and one of the most renowned personality in the legal field in the entire Madhya Pradesh. I welcome you, Honorable President Mr. A.K. Sethi sir. And now I would like to request you to honor us with your words of wisdom. As SNS Law College is organizing this conference for the very first time, and nothing could have been made it better except your presence. So I welcome you, sir, and over to you, sir, for your address. Pardon, sir, your mic is on mute, sir. Yes, sir. Now it's fine, sir.
Hello, good afternoon, everybody. First of all, I would like to congratulate the entire team members of the college and the entire faculties for the successful conduction of 1 week faculty development program on innovative teaching, learning methods and research in law. It started on 2nd of August till 9th of August 2021, followed by the National Conference on Emerging Issues in Law, Economics and Business. We aim to achieve global accreditation for excellence in teaching standards, infrastructure, facilities, and learning process for delivering quality professional education based on high ethical values. The college is dedicated to achieve excellence in educating professionals, serving the public, and fostering justice. We aspire to prepare lawyers to serve their aliens, the judicial system, and the public with a high level of accomplishment and commitment to the highest ideals of the legal profession. We strive to provide a well-rounded legal education. This FDP and National Conference is making this vision possible by training our faculties for delivering quality education in the field of law. The COVID-19 pandemic has changed the people's life all over the world in many ways. In a sense, the pandemic has put a sudden break on many activities, especially in education field. But the National Conference is providing a great platform to bring their research work in front of the nation as an effort to bring some changes in the emerging issues in law, economic and business. We know very well that we have only made a beginning. We know well the realization of our vision depends on active participation of learners and educators. We therefore strongly hope that all participants will become active learners and educators and could be well trained to build the strong base for students and grow into global leaders with creative and independent minds who will be able to cross national as well as the disciplinary boundaries. To build a new generation, experienced and well qualified faculties are required that we have, who always strive to make the students succeed in their endeavors. I must say that I am blessed to have an excellent, passionate team of education with me who are serving in this noble cause of education with full enthusiasm and dedication. And in the best, I would like to congratulate in advance to all the participants for their research work. All the best. Thank you.
Thank you so much, sir, for your beautiful words of encouragement. I cannot express it in my words that how privileged we feel today, because your time is very precious. We understand that, and you took out your precious time for this conference. And, it means a lot for us, and definitely the vision which you have set forward for SNS Law College and IMI group of institutions, we definitely feel that in the coming years we are going to achieve all those objectives, and we will definitely stand on the national or international or wherever our students will take us. We will provide that support, and we will give that name to IMI and SNS Law College, which truly it deserves, with guidance and blessings of your kind self and the management under Honorable Director Ankita Gupta ma'am. Thank you so much, sir. We are deeply grateful. Thank you, sir. Thank you, sir. So that was a very special address by our guest of honor today, our President, Mr. A.K. Sethi, sir. And we are very privileged to have his words, because for taking time out, it is very difficult for him, but he made it possible today. So SNS Law College is definitely feeling very privileged. And now moving forward, I would like to just confirm from Dr. Parul Sharda, has Dr. Anthony Raju has joined for the session, Dr. Parul Sharda?
Sir, actually, I'm in touch with him. He is busy in Zoom court in Supreme Court session, actually. So as soon as he join, we will introduce him, sir.
Sure, ma'am. So with that, we should. I guess the technical session is also there, and if he joins at that time, we will take him, and we will have his address, because he is also a very eminent personality, and all the participants would like to hear from him. And with that, as all the speakers for today's conference have already spoken, I now would like to go with vote of thanks. To present a vote of thanks, it is definitely a privilege for me. Well, respected chief guest, guest of honor, special guests, patrons of Research Foundation of India, management of IMI group of institutions, coordinators, faculties, and all the participants. Good afternoon once again. It is my honor and privilege to extend a vote of thanks on this occasion. I, Assistant Professor Abhiraj Singh Chauhan, would like to thank SNS Law College, IMI, and RFI for providing me this opportunity. Today, my words are not enough to express the gratitude I feel. On behalf of Indore Management Institute and Research Foundation of India, I would also like to thank our distinguished chief guest, Dr. Archana Raka, ma'am, for joining us and enlightening us with her words of knowledge. Our guest of honor, Mr. A.K. Sethi, sir. It is always great to listen to him, and he's definitely the leading source and the personality with whom we all look up to. And his being a part of this conference makes this conference more special for us. Dr. Inamur Rahman, sir, who unfortunately could not join us for today's session, but who is one such person who is known for his contribution in the field of research, and with his experience and whatever he has brought us, we are thankful to him also. I am also deeply grateful to our eminent special guest, Professor Dr. Debashri Mukherjee, ma'am, for enlightening us with her words that how research develops deeper understandings. And thank you, ma'am, for letting us know what are the things which are important, and how we have to achieve them, and what contributions we can make towards the society through the research. And I also must mention my deep sense of appreciation for our special guest, Mr. Manmohan Joshi, who took out his precious time, and with his vast experience of different fields, he guided us with his words. And I'm confident enough to say that with your brilliance, you simplified every concept related to legal research in the best possible manner. Thank you, Manmohan Joshi, sir. And every person who has joined in this session, definitely, I believe they have developed a greater and deeper understanding, and it has happened because of all the speakers who have spoken on the importance and significance of the research in today's times. And they have also instilled us with confidence, so that the participants can able to take on the challenges which they will face while doing the research. And with that, I would like to extend my gratitude to Honorable Managing Director, IMI Group of Institutions, Mrs. Ankita Gupta, ma'am, our Management Head, Mrs. Nikita Pandey, ma'am, VP Academic Affairs, Mrs. Ayushi Gupta, ma'am, Principal IMI RC, Dr. Sanjay Sharma, sir. Your encouragement, support, and guidance means a lot to us, and it always helps us to carry out such important and knowledgeable events. It was not possible for us to organize this kind of event without the support you have provided us. Thank you, management and principal, for this opportunity. And I would also like to thank Research Foundation of India, its chairman, Dr. Saurabh Jain, Chief Managing Director, Professor Dr. Ashok Kumar Gupta, President Northern South Board, RFI, Dr. Priyadarshini Agnihotri, President Central India Board, RFI, Professor Ajay Jain. And special thanks to Organizing Secretary and HOD Management, Dr. Parul Sharda ma'am. You have made it all possible to collaborate SNS Law College with RFI to have this conference on this digital mode. We are very grateful for all the support, everything you have provided, and making this event possible. I would also like to thank HOD Commerce Dr. Reena Gupta ma'am, and obviously the head of Department Law, Professor Rahul Joshi, who is one of the key persons who was holding all the responsibilities of organizing this conference today and making it possible. Not only the conference today, but also the FDP, which happened from 2nd to 9th August. So it was all because of the efforts put in by HOD Law Professor Rahul Joshi. And along with that, all the faculties of SNS Law College and IMI, as they have contributed in every activity, and they made that possible, and the conduction of this conference becomes smooth because of how they have contributed. And I'm really thankful to all of them, and I'm also thankful to all the participants from across the country for joining us in this stream of knowledge which is flowing through SNS and IMI along with Research Foundation of India. So I would like to thank Team IMI for your contribution to make this event successful. Thank you for being a wonderful audience. We'll now move ahead with our technical session where there are various participants who will present their papers, their research papers on various topics, and I'm sure that session is also going to be a very informative and a great. It will provide a great opportunity for learning to all of us. Thank you once again. Take care of yourselves. And with that, I would like to call upon Professor Rahul Joshi sir and Dr. Pallavi Mane ma'am, who is faculty in IMI group of institutions, so that they can take over with the technical session. I'll also be a part of it. And I will also like to request the students to remain a part of this session, because now the time comes where you will get exposed to some brilliant research writings prepared by the researchers. Thank you. Thank you. That's enough from my side as of now. Thank you.
Thank you so much, Abhiraj sir. Am I clearly audible?
Yes, sir, you are clearly audible.
Now move ahead for our technical session. Technical session sequence of PPT presentation is already shared with you, all the participants. One by one, we inviting a sequence-wise person to express their paper. So first, Rupali Bajaj, Euthanasia, its legality in human rights. I'm inviting you. Please present your paper. Please express your topic. Rupali Bajaj, are you there?
We can move to next, sir, if she's not there.
Okay. Next is Aishwarya Naik, Atul Sharma, domestic workers related topic. Ishwar,
Hello, sir. Am I audible?
Yes, you are clearly audible, ma'am. Please.
Sir, just a second. Allow me to share my screen and PPT, and I'll
Sure,
start
sure.
after that. My screen is visible, sir?
Yes, ma'am.
Okay. Good afternoon, everyone. Myself, Aishwarya Naik, Assistant Professor, Department of Law, Prestige Institute of Management and Research. I'm here today to present my paper titled Domestic Workers Time to End Their Plight. It is an opportunity for me to present this paper in front of all the eminent panelists and in this national conference of emerging issues in law, economics and business. It is equally an opportunity for me to present it in front of all the fellow participants. So I'll be starting. Let me know. Okay, sir. So in this earth-shattering, unprecedented pandemic like spread of coronavirus, the quote survival of the fittest can be observed in its most real form. Those who can afford to maintain their finances as well as immunity can only survive this pandemic. But to sustain ourselves, our economies, we must not forget the domino effect which is present everywhere. Domestic workers, when we talk about them, which are said to be the backbone of our home and represent more than 45 lakh of our population, are left vulnerable and unrecognized. This paper analyzes the position of these domestic workers in society as well as law during this tough time, followed by some suggestions. I hope you like it. I'm starting the PPT now. So, firstly, there is no denying to the fact that there is a lack of sound legislation as well as safeguard policies for domestic workers. Domestic workers are unrecognized even when they constitute such huge number of population in our country. If we talk about what is domestic worker, task force set up by the government of India defines the domestic workers as a person who is employed for remuneration, whether in cash or kind, in any household through any agency or directly, either on temporary or permanently, part-time or full-time basis, to do the household work, but does not include any member of the family of the employer. In short, we can say all the people whose basic source of income is providing help in the household work, such as cleaning, cooking, babysitting. Yes.
Aishwarya ma'am, you are still on the first slide?
No, ma'am. I have changed the slide.
No, it is not reflecting on the screen.
It is not.
What do I do about it? I have to stop and again share. Just a second, ma'am. I'm not.
Yes, please share it again. It might be possible that there is a technical error.
Yes, ma'am. Just a second. Ma'am, it has stopped sharing. Give me just a second. Ma'am, now can you see the second slide?
No,
is it
still
changing?
the first slide in which your name is mentioned.
Oh my God, what do I do about it? You tell me.
Ma'am, if you can
share?
use full screen, if you can use F5 key so that presentation can be seen on full screen.
Sir, that I can do. I was doing the slideshow mode, but let me know if I'm sharing my window. Is it?
Ma'am, please share your entire screen.
Okay, ma'am. Okay. Just give me a second. Ma'am, now if it is visible, please let me know. I'm changing the slide.
Yes.
Yes, yes, it is
Please
visible now.
proceed.
Okay. In the last slide, we have discussed what actually is domestic workers. So in short, I'll explain again. Every person whose basic source of income is providing help in the household work, such as cleaning, cooking, babysitting, driving, etc. These all are included in domestic workers. Now, if we talk about the contribution of this class, although they form a part of unregulated sector, they maintain the balance between work life and personal life in dual income families in regular sector. And also, as per the survey conducted by UN, they are and ILO, they are increasing in numbers, and by 2050, age group of 60 plus will be so much in this particular sector. Just give me a second. Now, let us go and see what we have done for these. Before that, I must tell you, there is a plight that goes with them. Just a second. Yes, the unsung plight that we don't know about them. No agreement, they have no agreement, so there's no notice to termination of their services. There are lack of legislative beckoning to them, and they are left unorganized and vulnerable, especially in these tough times. Technological advancement also lead to their easy replacement and substitution. So they are constantly insecure about their jobs. And no sound legislation have been made, leading to lack of rights and protections for them. There are two basic laws which especially aim on domestic workers: Domestic Worker Conditions of Service Bill 1959 and the House Workers Conditions of Service Bill 1989, but it has majorly failed. The other one, Housemates and Domestic Workers Conditions of Service and Welfare Bill 2004, was introduced, and it has some heavy penalties, but it has not been enforced yet. So it makes no sense. Now, let us move towards other legislation which might or might not include domestic workers. In Minimum Wages Act, if you can see, till 2013, even after so many years of enforcement of this act, only 11 states have added domestic workers in their purview. So no difference has been provided between urban and rural minimum wages also there. And many of the domestic workers are working in rural areas, so there's absolutely no provision for them for bifurcation of these two classes. Also, the live-in domestic workers were not mentioned there. So the workers who are living in, they have no limited amount of working hours. That is also a huge loophole in this particular act. Now let's move towards Sexual Harassment of Women Act at Workplace, Prevention, Prohibition and Redressal Act. Now, this act establishes district level grievance redressal mechanism and all of it, but it has several loopholes, and it is inadequate. It has very many inadequate provisions, because even the existing provisions have largely remained unknown and unimplemented. What is the benefit of having a law which is easily manipulated or which is not implemented? Next one is Employees State Insurance Act 1948. In this also, in 2016, the Labour Ministry extended the application of Employees State Insurance ESI to domestic workers in Delhi and Hyderabad, only in Delhi and Hyderabad. Then it has limited medical benefits. Even if the domestic workers of Delhi and Hyderabad are included, they are not getting extended services like sickness benefit, maternity benefit, disablement benefit. So it is not working for every class. Also, domestic workers have been held to be under the category of self-employed workers, thereby failing to recognize the domestic space as a workspace. So most of the provisions does not fall because it has not been considered a workplace. The next law is Unorganized Workers Social Security Act 2008. It included domestic workers within the unorganized sector, but it has not defined it. And also one of the schemes under Act of 2008 is Rashtriya Swasthya Bima Yojana, a state-sponsored insurance scheme modeled as an alternative to universal healthcare, which provides some, only some, benefit to domestic workers. Some states have come forward, like Tamil Nadu and Maharashtra, and they have made their own legislations for domestic workers. Like this one, Tamil Nadu Domestic Workers Welfare Board in January 2007 and Maharashtra in the Maharashtra Domestic Workers Welfare Board Act 2008. These two states have came forward and given an extended benefit to domestic workers and recognized them as the workforce. The current scenario regarding these is that Ministry of Labor and Empowerment is considering to formulate a national policy on domestic workers, which is in the draft state. Okay, the salient features of the aforementioned policy is right to form their own associations, unions, minimum wages, access to social security, right to enhance their skills, etc. Domestic Workers Sector Skill Council has been established under Ministry of Skills Development to enable professionalization of domestic workers and enable their career progression. But this is only on paper. Nothing as such has been implemented. Nothing as such has been enforced. And also, I do not get it why there is so much need to implement any law like CAA, and but not even recognizing it is only in the draft stage, and nobody is even taking update on this domestic workers national policy. Now, in COVID-19, we can see domestic workers have actually faced a lot. They were not given wages. They were not allowed to go out, so they could not give their services, and hence they were not paid their wages. Many of them left their job. Many of them went back to their previous cities and villages, and this has left them very vulnerable. Some of them don't even have the capacity of buying their bread. So this COVID has impacted them. They were already asking for very meager wage. They were already working on very meager wage, and now that was also not available for us. What my paper is suggesting is that separate legislation as well as regulatory mechanism which is implemented to its core should be there. So I don't only suggest to make a separate legislature. I also want a regulatory mechanism so this is implemented. Also, introduction to some additional measures to remove the barriers in implementation should be done, and establishment of welfare board in every district for domestic workers, as was initiated by Tamil Nadu and Maharashtra, should be there. Mandatory registration of domestic workers and powers to board to impose fines on households employing unregistered domestic workers should be there. I mean, when we talk about mandatory registration, they might or they might not be able to register themselves. So this liability should be imposed on the employing sector. So whoever is employing them should register them, and without that, there will be a penalty that can be imposed. Domestic workers must be given social security benefits through board, and benefits of already existing applicable social resources schemes like RSBV, BY, which I just mentioned, must be consolidated and brought under the purview of the board. Now, my last suggestion will be nationwide skill training programs should be instituted by the government that could provide an alternative to domestic workers. And this is all from my side. I'm open to any questions. Thank you so much for listening so patiently.
Thank you so much, ma'am. Am I audible to you?
Yes, ma'am. Yes, sir, you are audible.
First of all, your topic is very impressive. It is a actual area where we definitely work. My question is, you suggest that we make new legislations related to domestic workers, but can you give a suggestion how to communicate with domestic workers, or how to spread awareness with domestic workers if we make a new legislation? As we all know, lots of laws are relating to women, but they are not aware. So how to connect with domestic workers? It is my question to you.
Sir, we can connect with the workers on the levels like unions and BPL cards are also provided. So we have data there all. But the way we can implement this act more is by putting this liability on the employers. If employers are registering their workers, there is an implied effect that all the rights of the workers they will get. So indirectly our purpose is fulfilling by that only. Also the awareness is there. We can create awareness. Obviously they first of all they do not have right only abhi, so we can't do it. And also they belong, most of them belong to very illiterate class. So what we can do about them is how we spread the health awareness about health. We can likewise spread this particular awareness to them, because this is the best way to interact with them. That is what my suggestion is.
Okay, thank you so much, ma'am.
Thank you so much, sir.
I have one
Yes.
question to Aishwarya, ma'am. That was a
Yes, sir.
wonderful topic you have chosen. Considering that
Thank you, sir.
when you address domestic worker, they are actually not even termed as worker; they are known as informal help, which is a very
Yes.
unfortunate situation. But
Yes, sir.
my question is, can you name any particular states from which large number of these workers belong to in India? Particularly, name of a few states.
Yes, sir. They belong. Yes, Tamil Nadu, Maharashtra, even MP. Most of, especially in the COVID crisis, we have seen so many people coming back to their homelands. So Bihar also comprises one of such states. Even when we see it on the larger number, na, domestic workers are present everywhere. And they are present in a very, very large amount. We cannot just ignore them. But the lack of legislation makes us think that their existence is very, very small. When we talk about numbers, Maharashtra, Tamil Nadu, even MP, Bihar, these states have so many of domestic workers, and we have heard about them all throughout in the news when we were dealing with the crisis.
Right, ma'am. But as the statistics by the government, which shows that mainly those domestic workers mainly belongs to the poorer states comparatively, like West Bengal, Jharkhand,
Yes, yes,
Bihar, such are the states
yes,
which produce large
yes,
number of domestic workers. And when you have suggested that there should
yes.
be a nationwide skill training program, that was mentioned in your suggestions. So don't you think that such skill training program should be organized by the state governments on their levels so that
Yes, sir, it will be.
it can be
Yes,
implemented more
I agree
effectively?
to this point. Yes, yes, it will be very, very effective if the states can come out and if the states can take this initiative, because they have the basic data, they have the all the means that they can find data if they do not have. So I also agree with you, sir. State government should come forward and take this initiative of spreading the awareness and training also. I
So
agree with
what,
this.
the one last question, what are the barriers in implementing such measures? What do you think that these are the particular barriers which are coming in
What's the
between
barriers?
implementation?
Yes, sir. One of the major barrier that is coming in between is the lack of implementation of the legislation. Like I have shown in the slide as well, there are few legislation which are present, but they are not implemented to their course. So one of the very major setback is the implementation. Also, the implementation is not very well because the domestic workers themselves are not aware of their rights. Like our HOD law sir, Rahul sir have rightly mentioned, they are not aware of their right. They don't even know if they can have the remaining amount of their salary as well. So many workers, they were locked down suddenly, so they were not even aware कि जो बचा हुआ salary उनने अभी तक कितना काम किया है वो भी उनको मिलेगा कि नहीं. And they were not even trying to go and get that salary. So awareness and lack of
Any social
implementation can be
barrier
two of
which you
the
can suggest, ma'am? apart from it is a
Social
legal
barrier
barrier
can be,
what you
sir,
have
mostly
suggested.
this.
Yes.
Yes, yes. Social barrier can be one thing, that these class is majorly unorganized, and they majorly belong to the illiterate group. They are not very literate. So there's obviously also, sir, socially, when we talk about them, we do not recognize them as a help. We are taking them as it is unki majburi hai to wo aa rahe hain. They are our help, so we should also treat them with due respect, that it is their work, whether it is cleaning, whether it is babysitting. They are actually contributing to the economy indirectly, but we are not recognizing it.
Exactly. That was a very
Yes.
good point made, ma'am. Thank you. That was all from my side.
Thank you so much, Aishwarya ma'am. Now move
Thank you,
forward.
sir. Okay.
Our next participant, Kabir Sharma, Dr. Kabir Sharma. Are you there with us? Dr. Kabir Sharma, are you there with us? After Dr. Kabir Sharma, Ananya Chatterjee, are you there with us?
Yes, sir. Am I audible and visible?
Yes, ma'am. You are clearly audible and visible too.
Yes. So, good afternoon, organizers, and I am Mrs. Ananya Chatterjee. I am Assistant Professor of Law, Sister Nivedita University, Kolkata. Our HOD was part of your FDP, and I am really privileged that my paper has been selected for today's conference. So I once again give my gratefulness to all the organizers that my paper has been selected to be presented.
Thank you so
Now
much.
let's quickly move on to my topic, and let me just share my screen.
Yes, ma'am.
I'm extremely sorry. I'm not. Is my screen visible?
Yes, ma'am.
Yes, ma'am. It is visible.
Visible, but
You
I
have to.
guess my
It's
but
zoomed in.
you know my screen has been freezed.
It's zoomed in, ma'am. You have to zoom out. Yes, now it's fine. And it's I guess it's slide number 4. You have to
But
go on one slide.
due to this, I'm not able to like change the slides because of some issues. My
Ma'am,
screen has
if you
been
can
freezed.
press escape button. So
Actually,
that
I'm presenting from my tab, so
okay.
yeah.
All right, it's
I'm
getting zoomed in
extremely.
and zoomed out.
If you just give me 5 minutes,
Yeah,
I
sure.
can quickly fix it, and let's move to another speaker. Then let's
Sure,
like
sure, ma'am.
join
Okay,
me
okay.
after
All right,
5 minutes. Yeah.
it's all right.
Okay.
Now move ahead. The next participant is Urvashi Sharma, ma'am. Urvashi Sharma, ma'am, are you there with us? A study of women empowerment and gender
Yes, sir.
equality.
Yes, sir.
Sonia Chatterjee, ma'am, please stop your screen sharing.
Ananya ma'am, please, I'm requesting you to please stop the screen sharing.
Yes.
Thank you, ma'am. Thank you. Please send your PPT.
Yes, sir, just a minute.
After Urvashi ma'am, Keshav Negi sir. And after Keshav Negi sir, Aditya Narayan Mishra sir, please ready with your PPT.
Hello.
Yes, Urvashi ma'am, please.
Sir, can you audible me?
Yes, Pallavi ma'am, you're audible.
Hello. Good afternoon to all of you.
Good afternoon, ma'am.
Good afternoon, sir and ma'am. My topic is study of women empowerment and gender equality. I assisted Professor Urvashi Sharma from S&S Law College. Introduction. Women empowerment is the process and the outcomes of the process by which women challenges gender-based discrimination in every institution and structure of the society. Women empowerment means freedom of women from the vicious grip of social, economical, political, caste, and gender-based discrimination. Women empowerment itself elaborates that the social rights, political right, economical strength, and all other rights should also equal of women. Objective: to know the need of women empowerment, to access the awareness of women empowerment in India, to understanding the level of equality among girls and boys in primary school and higher education, to know the gender equality and share of women economical participation and opportunity, to identify the gender equality and women accessibility of resources. Understanding gender equality, a lot of experience has been gained from effort the mainstream gender equality and from special intervention direction at the woman and girl over the past decades. Only few intervention has been direct specified at men. Past experience point to the importance of using clear definition where reforming the mainstream gender equality and women empowerment. But even more so, the lesson is emphasis that gender equality issue differ from the social context to the other. Gender equality mainstreaming in a process not to be end itself. It involves considering both men and women needs and experience in the design, implementation, motivating and evaluation of policies. The aim of gender mainstreaming in equality between men and women and realize of women rights and women empowerment. Needs for gender analysis. A, a preparation from the mainstream gender equality to understand how any way gender inequality are relevant to the work at hand and where to find cultural opportunity that support greater equality between men and women. Technically, women and men are each other equal is today academic world. Women are free to enter the field of research and education that interests them. The law forbidden discrimination but dispute the formal equality. The academic area in stream categorized by the numerous pattern of suggestion between the sex and the can be largely treated the gender mechanism and conclusion as women constitute almost the one half of India population. Without their engagement and empowerment, rapid economic progress in out of the question. For economic growth to be really inclusive, women empowerment is of utmost value. It is cultural for achieving sustainable economic development of our country, and even beyond. Still, a large part of women do not have sufficient automatically regarding the value of choice for their own life. The data also be relevant to their necessity to look beyond economic resources of material prospection and into cultural and social influences, which are playing a sufficient role in shaping the woman's autonomy and empowerment. Thank you, sir.
Thank you so much, Roshi ma'am.
Yes.
My question is for you: in which areas women empowerment is still needed?
Yes, sir.
When you talk about
Hello,
women
yes, sir.
empowerment,
Hmm?
in which new areas women
Yes.
empowerment is still needed? Can you explain?
New areas, sir. Panchayat, Indian Constitution based Panchayat Article 243 इज अ न्यू एरा। मतलब सर वहाँ पे ऐसा है कि मतलब रिजर्वेशन के रिगार्डिंग प्रोविजंस तो है, पर वहाँ पे रिजर्वेशन अभी नहीं है फीमेल्स के लिए। मतलब वुमेन एम्पावरमेंट की रिक्वायरमेंट वहाँ है, नीडेड है वहाँ पर।
Okay. Thank you so much, Urvashi ma'am.
Oh, thank you, sir.
Move forward. Keshav Negi sir, are you there with us?
Yes, sir. Am I audible, sir?
Yes, you are clearly audible, Keshav sir.
Sir, let me let me share my screen first. Sir, is my screen visible now?
Yes, sir.
Okay, ma'am. So, good afternoon, everyone. Myself, Keshav Negi. I will be presenting my topic: limited liability partnership in India, concept and its challenges. As we know, partnership is considered as the oldest form of business relationship, but it was still felt that this kind of relationship do lack certain elements, which was enjoyed by the limited liability company. Partnership were replaced by a limited LLC, limited liability company, as the demand to bring limited liability under the concept of partnership was growing. It finally fulfilled in the year 2008 by the Limited Liability Company Act 2008. In this paper, we will get to know about the concept of LLP and its challenges and how this new form is changing the current scenario of new business. So, moving forward with the concept of LLP, this concept found its root from the German company law. It was introduced in India by the Naresh Chand Committee. Limited liability partnership is a form of business organization combining the vital aspects of partnership firm and the advantage of limited liability company. It is a hybrid of company and partnership. The LLP is separate from legal.
Excuse me, Keshav sir, I'm sorry to interrupt. Uroshi ma'am, can you please mute yourself? Yes, Keshav sir.
Okay, sir. LLP is a hybrid of company and partnership. The LLP is separate legal entity which can continue its existence irrespective of changes in its partnership. This form of business organization was first introduced under Limited Liability Act 2008. It was passed on 7th of January 2008 and it came into force on 1st of April 2008. LLP can be incorporated under the Limited Liability Act with limited liability and perpetual succession. LLP is also suitable for small and medium enterprises and also for professionals like CS, CM, and others. Its silent features are limited liability. The LLP is a body corporate and a separate legal entity, and any two or more person can form a LLP for carrying a lawful business with a view to make profit. The LLP has a perpetual succession. The mutual rights and duties of partners of an LLP intersay, and those of LLP and its partners shall be governed by an agreement between the partners and between the LLP and the partners subject to the provision of proposed legislation. A LLP is a separate legal entity liable to the full extent of its assets, with the liability of partners being limited to their agreed contribution in the LLP, which may be tangible or intangible in nature. Every LLP shall have at least two partners and shall also have at least two individuals as designated partners, of whom at least one shall be the resident in India. LLP shall maintain annual accounts reflecting true and fair view of its state of affairs, a statement of account of solvency which shall be filed by every LLP with the registrar or every year. Uh, if they non-compliance, if they non-comply with this particular rule, they have to pay heavy penalties, which is a slight disadvantage for the LLP. Moving forward with the advantages of LLP, audit is not mandatory for LLP, and as in the other registered companies, it is mandatory. If LLP has a turnover less than 40 lakhs and a capital contribution less than 25 lakhs, it is not mandatory for them to get their accounts audited. LLP is not required for to file taxes. Only partners individually have to file their taxes. That means no dividend distribution of taxes and no minimum alternate tax have to be paid by LLP. The partners are not accountable for any error or negligence or any misconduct act of any other partners. There is no restriction as to the maximum number of partners while comparing to the traditional kind of partnership. There are certain issues in limited liability partnership, as it is a new concept. It is still not actually famous in the particular scenario. Still, people are not aware of the LLP, so that's why it is actually in its start. Most of the guidelines issued by the government is mainly focused on the company, but not on the LLP. As I have discussed, heavy penalties on non-compliance is actually imposed on the LLPs if they don't comply with these rules. Creditors also have trust issues. Limited liability benefits only the members of the partnership, but it is a big concern for the investors. No separate authority is made for the registration. MCA, that means Ministry of Corporate Affairs, is the responsible authority for the registrations. So to conclude my PPD, the prime need of the present man is freedom of speech, control over the activities he wants to get involved, and power of thought to act according to the passion he desires for. In the case of setting up a businessman strive to get all these freedoms and benefits, and the LLP is the kind of concept which offer most of these features. Fast and easy incorporation of LLP makes it more attractive. Tax benefits and other exemptions provided is also a plus point, which is making this concept more promising. At the present, this concept is facing a lot of challenges. There is a need for some improvement in the concept, which will be surely, I hope, improved as the time will pass. It is a very new and exciting form of business, attracting the young generations towards it. It will be too early to say if this concept is successful in India or not. So thank you so much.
Thank you, Keshav sir, and the questions will be followed afterwards. But before that, now we have been joined by our keynote speaker for today's conference, Dr. Anthony Raju, who is advocate from Supreme Court of India, and he has spared his precious time for us. So firstly, I would like to give a warm welcome to Dr. Anthony Raju sir for joining us on today's national conference, which is being organized by SNS Law College Indore. Sir, you are on mute. If you have just said something and it was not audible. Sir, if you can unmute yourself. Yes, sir.
Thank you very much. God bless you. Thank you very much.
Thank you for joining us, sir, and taking out your precious time. I understand it's really very valuable.
I'm always available. The only thing there was certain Zoom meeting was going on.
Right, sir.
Media, so I was little busy with that.
Right, sir. So I have we are undergoing our technical session, sir, for this conference. But for the participants and for all the dignitaries who are present in this conference, I would like to give a brief introduction about Dr. Anthony Raju, who is a very eminent personality in the field of law. He's an advocate in Supreme Court of India. He's a dynamic, dedicated, internationally known human rights activist. He's a peace ambassador and social worker, an inspirational speaker, and India is one of the foremost voices of human rights. Dr. Anthony Raju is an globally known peace builder, human rights defender, diplomat, an eminent social reformer, and environmentalist, a human right and constitutional rights activist, a motivator, change maker, a teacher, a trainer, a disaster management expert, a panel arbitrator in national and international level, a legal aid expert, an academician, a humanitarian worker, and there are not enough words to describe in this such a short time that his profile is so huge that I don't think time will allow me to give the entire description. But let me tell you that Dr. Anthony Raju is the global chairman of All India Council of Human Rights, Liberties and Social Justice, and ex officio chairman of various committees working under All India Council of Human Rights, Liberties and Social Justice, such as National Human Rights Advisory Council, National Legal Council, All India Consumer Protection Council, All India Anti-Corruption Council, All India Bar Federation, Asian Human Rights Council, Universal Mission for Peace and Harmony, National Council for News and Broadcasting, International Council for Human Rights, Asian Human Rights Council, and many such organizations, reputed organizations. Dr. Anthony Raju has himself seen a lot of struggle in his life, but uh, in in his life he has become an inspiration for many others. He has shown how to uh, uh, come up with all the struggles, and he has faced all those challenges, and now we are having him as a keynote speaker for our today's session. And I won't take much time because we are eagerly waiting to hear to his words, to listen to his words of wisdom, which definitely going to benefit all the participants, all the students who have joined us for this conference. And Dr. Anthony Raju sir, we are really very glad to have you on this platform. This digital mode has made it possible for you to attend this from New Delhi, and thank you so much for joining, sir. And I will now hand over the mic to you to give your address and make this conference uh, uh, a greater one. Over to you, Dr. Raju.
Thank you, Dr. Parul Shada, who was after me to come for 2 minutes, come for 2 minutes. So definitely, it's a great platform on which we really wanted to be part of it. And thank you, Mr. Singh, for inviting me and giving such a wonderful introduction of mine, which is not very mandatory, it is not required, in fact. Because we first of all we must think that we are the human being, and our life is very short. Life is very precious. We must give life to the people of this country with love and compassion, because, as I told you, that we are promoting human rights, and we reach to almost 140 countries. We are the largest organization in the country after the Amnesty International. And in a very short period, we reached to 140 countries. And unfortunately, I have requested one of the very close colleague, Dr. Junan. Dr. Junan is the international president of Women Wing, and very, very dedicated woman. So she's not well, so she didn't join us today. But the conference which we doing out right now, it's a national dialogue, and I hope this is on all legal process. I believe we are talking about. Am I right, Dr. Parul?
Absolutely, sir. Thank you so much for joining, sir.
आपने बहुत इंग्लिश बोल लिया, तो थोड़ा सा हिंदी में आते हैं. और I want that because even I requested a lot of people to join us. Or as far the law is concerned, or jurisprudence is concerned, or judiciary is concerned, I will not say much. But आपने देखा होगा अभी कल की एक बड़ी अच्छी स्टेटमेंट आई है जस्टिस एन वी रमन्ना साहब की, जिसमें उन्होंने कहा है कि ह्यूमन राइट को अगर सबसे ज्यादा थ्रेट्स हैं तो वो पुलिस स्टेशन से हैं। और अभी लेटेस्ट बहुत सारी जजमेंट आई हैं सुप्रीम कोर्ट की जो रिमार्केबल है। आई एम स्पीचलेस, जिसमें उन्होंने बोला कि हर पुलिस स्टेशन पे सीसीटीवी होने चाहिए। आई मीन दे आर ट्राइंग देयर लेवल बेस्ट, और मैं यही चाहता हूँ बीइंग एडवोकेट और एक क्रिमिनल एडवोकेट हूँ और लोगों की मदद करते हैं, जिस लेवल पर जब मदद कर सकते हैं जरूर करते हैं। वी ऑलवेज कीप ऑन ट्राइंग टू हेल्प द पीपल। सो जो लोग भी आपके यहाँ से लॉ कर रहे हैं या जो भी मैनेजमेंट के लोग हैं, they must understand the meaning of law. Law does not mean that you just reading the book, keeping everything in your mind. No, not at all. आपको अगर if you want to be a good advocate, either civil or criminal, whatever you are, but make sure that you have to come out from your house. कहते हैं ना, चार दीवारी से बाहर निकल के जब आप आएंगे तो पता लगेगा दुनिया बहुत बड़ी है। आपका सोशल नेटवर्क हैज टू बी वेरी वेरी स्ट्रॉन्ग। और आपको गूगल का कीड़ा नहीं बनना। यू डोंट हैव टू बी to attach to Google for everything. Now, we have to be a reader, like you have to read the books. So there are a lot of beautiful judgments the Supreme Court and High Court are giving nowadays, and you should go through those judgments. If you want to be a good advocate, good criminal advocate, or good social worker, or good management person, you have to be live, you have to be attentive to the different, website and maybe live.com or a lot of things are there. So I'll not talk much right now because I have another question. My good wishes are always there. Keep it up and enjoy yourself, and my good wishes for all the people. Thank you very much. God bless you all.
Thank you so much.
Thank you so much, sir. What you are doing for the society as a human right activist is cannot be put under the words, but we are really very thankful for you for your contribution, and also for making yourself part of this event. And definitely we'll take forward whatever you have said, whatever you have done. We'll take inspiration from all those things, and we'll look up to you. Thank you, sir, for joining and giving your precious time for this conference. All right, Rahul, sir.
Thank you so much, sir. Am I clearly audible? Abhiraj,
Yes,
sir, am I
Rahul,
clearly
sir.
audible?
Yes, you are clearly audible, Rahul, sir. I would request you to go ahead with the questioning, which was interrupted for Mr.
Keshav Negi,
Keshav
sir.
Negi, sir. Yes, sir.
Yes.
We'll continue from there only.
Keshav Negi, sir, are you there with us?
Yes, sir.
Your presentation is very good. And my question is, tell me the changes in rules or any issues regarding the LLP, please.
As we're
Keshav
talking
Negi.
about the issues, recently Ministry of Corporate Affairs had issued an office memorandum, sir, stating that LLPs cannot perform business in manufacturing and allied activities, since the object of an LLP is mainly for professional services and not for manufacturing activities. But this office memorandum was widely criticized by the experts in the industry itself. Then Ministry of Corporate Affairs declared that this particular office memorandum has been withdrawn with the immediate effect because it does not actually logical for everyone. It was very much criticized by the expert. That's why it has been withdrawn from the immediate effect after it has been applied.
Thank you so much, Keshav, sir. Ananya Chatterjee, ma'am, are you there with us?
Yes, sir. Yes, sir. Am I audible?
Are you ready with your PPT?
Yes, sir. I'm now ready.
Yes, you are clearly audible, ma'am.
Okay. Okay. So
Please go ahead.
extremely sorry for the inconvenience caused. Let me introduce me again. So I am Mrs. Ananya Chatterjee. I am Assistant Professor of Law, Sister Nivedita University, Kolkata. And I once again express my wholehearted gratitude to the organizers for choosing my paper to be part of this national conference. Now, quickly moving on to my paper. Is it visible, sir?
Yes, ma'am. Please continue.
Yes. Okay, okay. So as you can see, the name of my paper is Medicine and Law in the Times of COVID-19 Pandemic and Understanding the Interface. So as we are all, going through a very trying times, so health has been one of the very significant part and parcel from last 1.5 years. So my topic which I have chosen to present is basically is dealing with right to health. Now, as you can see here, that health is one of the very vital indicator of the human development, and which is, the basic ingredient of economic and social development in India. So right to health care and protection has been recognized since very early times. And being a founder member of United Nations, India has ratified various international conventions promising to secure the health care right of individuals in society. Now, if we go through the various, the provisions of the Constitution of India, then there is this Article 21, which is right to life and personal liberty, where, life here means life with human dignity and not mere survival or animal existence. So it has a much wider meaning, which includes even right to livelihood, better standard of life, hygienic condition in workplace and leisure. So right to health has been a very pertinent part of life with human dignity. And there are a lot other, like DPSPs, which are directive principles. Here I have mentioned Article 38, 42, 43, and 47, which I will discuss in my upcoming slides, like how it's related to the health of the people. Now, regarding the definition of health is concerned, WHO has, held that it is a state of complete physical, mental, and social well-being, and not merely the absence of disease. So, we are having a kind of mindset that, being healthy means like one who is physically healthy. But nowadays, the mental well-being and the social well-being, this has also become a very significant part of right to health. And especially here in this time when we are going through a kind of, situation that we are not able to move on, and it's kind of creating a huge impact into our mental condition. So from that perspective, mental and the social well-being is a very pertinent part of right to health. And the WTO has played the best supportive role in guiding the various health policies for the development and action at the global and national levels, and an overall objective of ensuring and attaining the highest standard of healthcare to all the people around the world. Now, regarding the various provisions of Constitution of India, as I already have discussed with you, that Article 21, which is one of the very significant provision regarding right to health is concerned. So I'm not discussing that part, but next is Article 23, clause 1, which prohibits traffic in human beings. So it is well known that traffic in women leads to prostitution, and which in turn is to major factor in spread of AIDS and HIV. Um, uh, Article 24, which relates to the child labor, it deals with that no child below the age of 14 years shall be employed to work in any factory or mine or engaged in any other hazardous employment. So this is also one of the articles which directs the relevance to child health. Now, next is Article 38, which imposes liability on the state that states secure a social order for the promotion of welfare of the people, but without public health, we cannot achieve it. So Article 38, 39, 42, and 47, these are the provisions which relates to directive principles of state policy. So even if these are the provisions which are specified by our constitution, but these are not, enforceable by law. So even if it is there in our constitution to make our state as a welfare state, but unless and until we take up all these provisions, so it has not been possible for us to make our nation a healthy nation. Now, some of the cases I have discussed here regarding right to health. That is, the first case is Pashchim Bengal Khet Mazdoor Samiti and others versus State of West Bengal and others, which held that in a welfare state, the primary duty of the government is to secure the welfare of the people, and moreover, it is the obligation of the government to provide the adequate medical facilities for its people. And the Supreme Court has also made certain additional directions in respect of the serious medical cases, like adequate facilities are provided at the public health centers where the patient can be given basic treatment and his condition stabilized. Hospitals at the district and subdivisional level should be upgraded so that serious cases be treated there. And proper arrangement of ambulance facilities should be made for transport of patient from the public health center to the state hospitals. There are some more judgments like Paramanand Kadara versus Union of India and others, which rule that every sector, whether it's a government or it's a private hospital, but they are having this professional obligation to extend his service with due expertise for protection of life. So no law or state action can intervene to avoid or delay the discharge of the paramount obligation cast upon members of the medical profession. There are some more other like judgments like CESC Limited versus Subhash Chandra Bose, that the health and the strength of worker is an integral facet of the right to life, and the aim of the fundamental right is to create an egalitarian society to free all the citizens from coercion or restriction by society and to make liberty available for all. And due to paucity of time, I could not incorporate the judgment. So these are some of the case laws which I found to be quite pertinent for discussing this right to health. Now, some of the legal frameworks, like some of the legislations, I just want to quote here. So as you can see that Indian Medical Council Professional Conduct, Etiquette and Ethics Regulation 2002, where there are some of the provisions where IMA, is following that the duties of the physicians, that the doctors to their patients and obligations to sick, and it clearly defines that no physician shall arbitrarily refuse the treatment to a patient. And section 212 of the above regulation ascertains that medical practitioner having any incapacity detrimental to the patient or which can affect his performance, the patient is not permitted to practice his profession. And the physicians, especially those engaged in public health work, should enlighten the public concerning quarantine regulations and measures for the prevention of epidemic and communicable diseases. Now, in today's day, we are seeing this Epidemic Disease Act 1897 because, the common people are, not aware about wearing their masks. Even if a lot of, requests are coming from the government, fines are being imposed, but still people are not, concerned about their health. So to make them aware, and to be able to control this pandemic situation, here we can see this implementation of Epidemic Diseases Act 1897, and which was invoked by the Indian government on March 11, 2020, which empower both the central and the state government to take the actions to prevent the spread of such disease. And some of the provisions of this act, the first three sections, if you just read it, then it elaborate measures to prevent and contain the spread of an infectious disease and pronounce the punishment for disobeying the government orders given under this act. And section 4 of this act is exclusively applicable to the healthcare professionals and provides legal protection to every person who does any action in good faith. So this section also provides immunity from legal action for any healthcare worker acting under the provision of this act. There is also this Disaster Management Act 2005, which is, to provide for the effective management of disasters and the lockdown situation which is going on. It is imposed under Section 6, subsection 2, clause 1 of this act as per the provision of the concurrent list of the Constitution of India. Now, how can we survive this pandemic, though we know that, we cannot say when this pandemic will be over, but I have here tried to incorporate some of the solutions, like how we can survive from this pandemic situation. So there are some of the questionnaires which I have set here, that can a doctor refuse treatment of COVID-19 patient? So here, as you can see, that I have incorporated some of the suggestions that medical practitioner who is qualified and has the basic infrastructure to treat a COVID-19 patient should not refuse unless his own health issues prevent him from doing so. And this is in concurrence with section 2.1 of Indian Medical Council Regulation 2002. However, in the best interests of the patient, the doctor can refer him or her to a higher center if necessary, but only after providing the first aid and ensuring the safe transfer. And refusal to treat a COVID-19 patient for any other reason will amount to contravention of Regulation 5.2 of this Indian Medical Council regulation, which states precisely that a physician should not abandon his duty during an epidemic and for the fear of contracting the disease. So would failure to adhere the government guidelines be treated as negligence? So my point is that the medical practitioner and the administration is duty bound to be prepared, and it is of utmost pertinence to stay abreast with the latest government guidelines and regional to deal with all the eventualities arising from admitting or treating a COVID-19 suspect or a positive patient. So failure to adhere the guideline would sure invite the wrath of the government bodies and adverse legal consequences. Now, regarding PPE kits and masks are concerned, also the medical professionals needs to be very much careful before treating any COVID-19 patient. Like as we have already seen that there was scarcity of PPE kits. So medical professionals' health is also a matter of really a matter of concern. So that also we need to take care properly. There is also one thing called nowadays telemedicine, which is being propagated and progressively adopted to prevent the transmission risk to both healthcare providers and patients. And Niti Aayog, and which has been amended by Indian Medical Council Regulation 2002. So these are the guidelines which are an attempt to provide, a standardized regulatory and legal framework for telemedicines in India. So in my conclusion, I just want to say that So in today's day, when a pandemic is going on, which is a dynamic situation and involving with regional variances, so it is here to stay, and many more may just be knocking at the door. So Indian laws, while imposing regulation on practice, does simultaneously provide provisions to safeguard the interest of the medical practitioner. So at the end, a balance of efficiency and innovation is a pressing priority, and it is the need of the hour to be mindful of the existing laws and our rights and duties in the era of current pandemic. So with this, I'm just ending my presentation. Um, hope it is worth of presenting. Thank you.
All right, ma'am. Thank you, Ananya, ma'am. That was a very nice presentation from your side. And you have covered almost all the aspects related to healthcare, including the legal framework currently in India and the constitutional provisions related to it.
Yeah.
Well, my question to you is, ma'am, do you think that the current legal framework, which is there to regulate or manage the healthcare in India, do you find it sufficient? Because I will just give you a fact that when a hospital gets established, it get covered under 125 different type of legislations.
Yes.
Which became applicable, and all those guidelines are to be followed by an hospital, but still we are aware about the reality, the condition of the healthcare in India, which we have witnessed in this pandemic recently. So what is your personal opinion on it? Do you think it is sufficient, or we should implement more laws? We should enhance the legal framework?
Sir, my personal opinion, if you ask that, India is having, I think, sufficient legislation. From legislation perspective, it is having proper amount of legislation.
Right.
But the problem is that, the percentage of economy which we spare for the other sectors, like, for a security purpose or for whatever, but we do not want to spend the same amount of money for the health sectors. Like research is very much required for today's time, as you have seen. Like vaccine is been one of the very important part of this COVID-19, but we have never thought of this situation, that this situation is going to come and how we are going to cope it up. So government have not been in that mindset that we should invest more amount of money for doing research in this health sector. So even if we are having lot of legislations, but I think there is lack of implementing those things, and people should be more now aware about it, and people should come up and do research more on this health sector. That is my personal opinion.
All right, ma'am. But considering that we are having world's second largest population, close to 1.35 billion people living in this country, and the other pressures also, as we are a developing nation, we are struggling with our economy also. So how much do you think, when you talk about providing money to this sector, how much money do you think is sufficient? Because I don't think it's ever gonna be sufficient, considering the load. Yes,
I think health is part and parcel of our life. So I do not think government has understood before this pandemic, like about the health situation. And even if it's a part of constitution, fundamental rights are there, but nobody was aware about this a whole lot of situation, because health is a sector where research plays, I think, the most important role. because unless and until you spend more amount of money in research, and this ICMR, I think they have also been saying this from a very long amount of time, that research is very much required in this particular sector. But
Right.
I think people have now understood, government have also now understood that how much required it is nowadays. So I think situation will definitely get changed, and we will surely get through this situation, I hope, because I'm a positive person. So I hope that we will one day definitely going to overcome
Obviously,
this.
obviously, ma'am, we all hope for that.
Thank you.
And
Yes.
thank you, ma'am, for your presentation.
Thank you so much. Thanks.
Thank you so much, Ananya Chatterjee, ma'am.
Yes.
And next is Aditya Mishra, sir.
Yes,
Are
sir.
you there with us?
Yes, sir. Yes, sir.
Please start your PPT, sir.
Good afternoon to all. Firstly, I share my screen. Is it visible, sir?
Yes, sir. It is visible, sir. Please go ahead.
Okay. Good afternoon to all. My topic is land consolidation as land reform in India. I, Assistant Professor Aditya Narayan Mishra, SNS Law College, present on this topic. Initially, the dispute related to land and realization of land revenue is covered under the civil law and is governed by the Jamindari Act, and its proceedings are executed according to the procedure established by the civil code. But after the MP Land Revenue Code, that is Madhya Pradesh Land Revenue Code 1959, all the proceedings related to the land and land revenue comes and governed by the MPLRC. Consolidation is an old concept and was practiced by the Bhumiswami since a very long time, and with the mutual consent of each other, and is logically accepted by the farmers, zamindars, etc., because they get their whole of the land at same place, and it's easy for them to cultivate at a large scale and to protect their land and crops too. The term consolidation means to unite or settle something together. So the term consolidation of holding means to unite the land together at a one place for the purpose of integrated cultivation. According to section 205 of MPLRC 1959, consolidation of holding means the redistribution of all or any of the land in a village so as to allot the Bhumiswami continuous plots of land for the convenience of the cultivation. Consolidation officer. Consolidation officer means a revenue officer not below the rank of Tehsildar, appointed by the state government for any district or districts to exercise the power and to perform the duties of the consolidation officer under this code. Now come to forward on initiation of the proceeding of consolidation. The initiation of the proceeding of consolidation is started by either of the following method: by the application or by the collector. After the application signed and given by the two or more Bhumiswamis of that village who are having land more than or equal to minimum land prescribed by the rules under section 221 of MPLRC. And second method is the collector of the district may also direct the consolidation officer for initiation of the proceeding by on motion. Now, preparation and confirmation of schemes for consolidation. If the consolidation officer admits the application, he shall start the proceedings according to the procedure laid down by or under this code. Then according to section 209 of MPLRC, there are two conditions. That is, first one is either the Bhumi Swami of that village may submit a scheme of consolidation of holding after mutual agreement and consent to the consolidation officer. Or second one is the consolidation officer shall make the scheme for the consolidation of holdings according to the manner laid down by this act in rules under section 221. And when the confirmation schemes for consolidation were prepared, thereafter the consolidation officer may examine it and if there are necessary, modify it and start the proceeding of consolidation. And when the scheme of consolidation is completed without any objection, then the consolidation officer shall submit it for the confirmation to the collector. After the submission of the report by the consolidation officer to the collector may either confirm the schemes or direct the consolidation officer for the modification, or he may also refuse to confirm it and after considering the objections. Now comes forward on the next heading is right of Bhumi Swami after consolidation of holding. What are the rights of Bhumi Swami after consolidation of holdings? The Bhumi Swami who gets the land after the proceeding of consolidation, and if they have not entered into possession allotted to them under the consolidation schemes from the date of entry as mentioned in the scheme, they shall be entitled to possession of the holdings from the commencement of the next upcoming agriculture year. And according to section 213 of MPLRC, the rights of Bhumi Swami is their holdings shall be transferable by exchange or otherwise, and no person shall be entitled to object to or interfere with any transfer made for the said purpose. Now, suspension of the right of Bhumi Swami. As per section 217 of MPLRC, when any application for the consolidation of holdings have been admitted under section 208, all the proceeding of partition of holding shall be suspended until the consolidation is not completed. And encumbrances of Bhumi Swami, according to section 220 of the MPLRC, if there is any charges or burden on the holdings of the Bhumi Swami, which is under the scheme of the consolidation with any lease, mortgage or any other encumbrances, then such lease, mortgage or other encumbrances shall be transferred and shall attach to the new holding allotted to him under the scheme. Now come to my conclusion part. Consolidation of holding is the arrangement of the land in such a way that all the holdings of one Bhumi Swami united at some place, at the same place, and the benefits of Bhumi Swami from this consolidation are as follows. The area of field is increased for the production of the crops. The irrigation facility is centralized. More yielding of crops is possible. Easy for cutting, harvesting, threshing, etc. And can take care of all the crops from stray animals at a time, as he don't need to go to a different farm. Consolidation proceedings are initiated and completed by the consolidation officer under guidance of collector of the districts with the mutual consent and agreement of the Bhumi Swami. So it is not any arbitrary action of government, but a positive initiative to integrate the field, which increase the cultivation or growing of crops. Thank you.
Thank you so much, Aditya sir. Very informative topic you chosen. My question is, Aditya sir, can you hear me?
Yes, sir.
So please explain the difference between the Bhumi Swami and the owner of land. What is the basic difference?
In MPLRC, there is a difference between Bhumi Swami and ownership. Ownership is the term ownership is talked under section 57 of the MPLRC, which stated that state has the ownership in all lands. All lands in the territory of the states belong to the state. And it includes water, mines, quarries, minerals, etc. But the term Bhumi Swami is defined under section 158, and every person at the time of coming into force of this code who hold a land under different region, that is Sironj region, Mahakoshal region, Bhopal region, Vindhya region, and Madhya Bharat region. If any person holds land under that region before coming into the force of this code, then that person is titled as a Bhumi Swami by state government. So we can say that ownership is a de jure exercise, but Bhumi Swami is a de facto exercise.
Thank you so much, sir.
Thank you, sir.
After Aditya Mishra, sir, Chandra Bhushan Singh.
Yes, sir.
Are you there with us? Please
Yes, sir.
present your PPT. After Chandra Bhushan Singh, Hashim Khan. Are you there with us? Please ready with your PPT. And then Nodi Bariagra, King David. Please ready with your PPT. Yes, Chandra Bhushan Singh, sir. Over to you.
Yes, sir. Just a minute. So is my screen visible?
Yes, sir.
Okay, thank you, ma'am. So good afternoon to all. Myself, Chandushan Singh. Today I'm going to present on the topic role of e-commerce in the usage of plastic money in India. So starting with introduction part, as we all aware of the facts that India since independence has been developing country. The whole country is under growing phase, and as the part of growth, there is several new trends and the business entered in the market recently. Among these new business, e-commerce in the business is at peak. Today, people are highly dependent on the business. Not only not only are the people dependent, rather love this business because such business is more efficient and convenient. It's growing day by day. We all also aware of the current scenario of the country is suffering from the pandemic, that is COVID-19, which the whole nation has to stay back at their home, which led to no business condition in the market. In this condition, e-commerce has played a great role, very great role. People also encourage such a business so that they would be less in physical interaction. Consumer has moved from the stores, supermarkets, shopping malls to the online portals to purchase products such a basic commodity to branded products. In this paper, we would focusing on how e-commerce has impacted the use of plastic money. So firstly, we have to understand what is e-commerce. As we all know, e-commerce stands for the electronic commerce, the negotiation of the goods and services through electronic media and the internet is called e-commerce. E-commerce involves conducting business with the help of internet and through uses of information technology such as electronic data interchange. It involves the website of the provider that sells or provides services to the customer directly from its portal. They use digital shopping card system and allow payment by credit card, debit card, or electronic fund transfer. Plastic money. So plastic money or plastic card are one of the most popular payment method. In reality, plastic card are unavoidable part of our lives. Cardholder offer a choice of cash and check for a easy and convenient payment of the goods and services of plastic. So credit card and debit card ATM card, etc., are used as an alternative to the money such as cash and check are made of plastic and also called plastic money. So there are two types of plastic money. Generally, first one is debit card and credit card. So debit card is a card. For example, if you have 5,000 amount in your bank account, you can use only up to 5,000 rupees to spend, and but not in the credit card. Credit card is a one type of benefit provided by the bank to the their customers. For example, if they have having great civil score or highly liquidity, so banks sometimes offer with the fuel charges कि you can spend more than amount you have in your bank account. For example, if you have zero balance in your bank account, but you are able to spend near about 20 or 50,000 rupees or 1 lakh rupees through your card, is known as credit card. So what are the impact of e-commerce on the usage of plastic money? As the rise of e-commerce in India drives consumer toward the plastic money rather than the putting cash in their wallet. According to the data from the RBI, financial year 15 increased debit card used by 16.3%. यहाँ पे here we can see there is increase in 16.3% in debit card and 21.3% in credit card. Increased uses occur not only the large city but also the in tier 2 or tier 3 cities like small towns and cities also. According to the data volume released by RBI by July, 236 million credit and 289 million debit cards were used by Indian consumer. HDFC Bank has issued more than 6 million credit cards and more than 22 millions of debit card, and these number are growing about 30% every year. Approximately 50% of transactions conducted in the form of online credit card and more than 40% of transactions are conducted in the form of debit card, and this proportion is increasing year by year. They are also providing several offers on the online transaction. Also, they expect that online transaction may grow up to 70%. Here in the chart, you can see the financial year 12, 13, 14, 15, and 16. I'm also trying to find current financial year credit card and debit card user, but I unable to find a valid report. So I have taken up to only financial year 16. Here you can see that year after year the uses of credit card and debit card are increasing. In financial year there are 322 millions of credit card users. In financial year 13 there are 399 millions of users. In financial year 15 there are 619 millions of users of credit card, and in the financial year 16 you can see the figure of 236. It's up to July, means it's a record of April to July of 2016. If you calculate the record of credit card users of financial year 16, it's around 900 millions people are using credit card. If you calculate, multiply it by 4 times. Okay, so moving ahead, here is my conclusion part. As per the above collected information, it can be clearly seen that e-commerce business is emerging business in the country and has the broad scope in future. People are accepting such business in their day-to-day life. The growth of electronic commerce has resulted in the plastic currency being more popular than the real cash. In recent year, with the rise of online shopping, the number of credit card and debit card users has also increased. Mobile wallet and can also help derive online sales, not only used in cities but even the second and third tiers classes. The uses of cards have been also increased. So it can be concluded that e-commerce has high impact of users of plastic money within the country. Thank you.
My question to you is, what are the drawbacks of e-commerce?
Okay, ma'am. So there are drawbacks of there are both E-commerce have their individual drawbacks and plastic money has their individual drawbacks. There are some common drawbacks such as uh, you can see site crash, security reasons, many if a person is not literate that much or illiterate, he has many confusion to use how to use plastic money or e-commerce, how to purchase from the e-commerce. And there are some individual drawbacks such as um, uh, loss, service charges, damage to card, debt trap. Sometimes the card user can't able to manage their do the cash management and trapped in the debt trap using credit card more and more in their daily activities. So these are some drawbacks which a person can face in this using debit card or e-commerce.
Thank you so much, Chandrabhushan sir. After Chandrabhushan sir, Hashim Khan, are you there with us?
Ji sir.
Are you ready with your PPT?
Ji sir.
Please go ahead.
Sir, my PPT is visible on the screen.
Yes, it's visible.
Good afternoon to all. Myself, Mohammad Hashim Khan, and I am from the LLB third year. And I would like to present my research paper through a presentation on the topic of development of right to life and personal liberty as a human rights. So let's start with the introduction. From birth to death, every man and woman in the globe has fundamental rights and freedoms. Human, since everything on this planet, in my opinion, has the right to live. The right to life is the most fundamental human right. They guaranteed equality to everyone without any discrimination on the basis of race, color, sex, language, religion, political, birth, or social rank. The aboriginal rights for the evolution of human nature are the right to life and personal liberty. If you have no life, you can't vote. If you have no life, you can't speak. If you have no life, you can't move. You can't just do anything you want with your life. So now I'm moving forward to discuss human rights. According to Nelson Mandela, to deny people their human rights is to challenge their very humanity. India is the world's largest democracy. Its primary goal to defend people's fundamental rights. Human rights are set of fundamental and freedom that all human beings are entitled to order to live with dignity, with full potential and without discrimination. In the next slide, human rights in Indian Constitution. The importance of human rights is expressed in India's constitution, not explicitly, but through several provisos, such as in preamble. When thinking about the preamble, words like secularism, socialism, democracy, justice, equality, liberty, and brotherhood come to mind. Now I'm going to the next slide to discuss right to life and personal liberty. According to the Article 21 of the Indian Constitution, clearly stated that no person except according to procedure established by law shall be deprived of his life or personal liberty. An individual's right to life and personal liberty is one of the first concepts to be protected by national courts. In India, the concept of the right to life and personal liberty as defined in Article 21 has been given a far broader application. Moving forward to the next slide and discuss sorry sir, there is some issue. Okay. Expanding interpretation of right to life and personal liberty. The original length of Article 21 is the shortest of all the articles. It protects the protection of life and personal liberty, declaring that no one's life or personal liberty may be taken away until legal procedures are followed. The Supreme Court has varied introduction of right to life and personal liberty. There are few examples: right to live with human dignity, right to livelihood, right to privacy, right to shelter, and etc. Finally, I would like to conclude my presentation with the conclusion. No one shall be deprived his life, personal liberty, except procedures established by law, says Article 21 of the Indian Constitution. Menka Gandhi's case was not only his watershed movement in the interpretation of Article 21, but it also gave a new perspective on the Chapter 3 of the Constitution. Article 21 solely safeguards the right to life and personal prior for Menka Gandhi's judgment. the origins and evolution of human rights in India, the definition of human rights and the right to life and personal liberty, and the growth of Article 21 in the context of the constitutions are the primary topics covered in the research papers. Thank you so much to all of you.
Thank you. Thank you so much, Hashim. Am I audible to you?
Ji, sir.
Hashim, your total research work is related to Article 21. So my question is, why interpretation of Article 21 is so broad?
Okay, sir. Sir, the interpretation of Article 21 is too broad because the judicial interpretation of Article 21 of the Indian Constitution and judicial activism on the part of the Supreme Court of India. It examines the reasons for the judicial creativity and justifies the role played by the Supreme Court of the India in protection right to life and personal liberty. Is the most cherished and pivotal fundamental right of the individual revolve which other rights of the individual revolve. Therefore, the interpretation and the study of right to life is indeed a study of the Supreme Court as a guardian of fundamental human rights. Thank you, sir.
Thank you so much, Hashim. Please stop screen sharing. Dr. Anita Gehlot, are you there with us? Dr. Anita Gehlot, are you there? After this, Nordi Variagra, King David, are you there with us? Nordi Variagra, King David.
Hello.
Yes, yes, ma'am. Yes, Anita Gehlot, ma'am.
Hello.
Yes, ma'am. You are audible, ma'am.
सर प्रेजेंटेशन मेरा कब है?
अभी मैंने आपका नाम लिया, मैम. Are you ready with your presentation?
Yes, sir.
Please go ahead. Anita Gehlot, ma'am, please start your presentation. I think there is some technical issue with Anita Gehlot, ma'am. Mrs. Nuranjani and Manjunath M.
Yes, sir. Yes, sir. We are there.
Yes.
Shall we present it?
Yes, yes, please.
Okay, sir. Okay, sure. I will share my PPT.
Sure, sir.
Can you visible? Hello, I'm audible, sir?
Yes, you are clearly audible and your PPT is visible, sir.
Okay, sir. Okay, thank you. First of all, I would like to congratulate the all organizing committee members to organizing such a wonderful conference in this period. And then I will straight away move on to presentation here. The topic is Indian banking in the era of globalization and information technology. We all are familiar with globalization, information technology, all those things. So today we are here, we are meeting with virtual conference only because of this information technology. That is only because of come from the result, or that is the result of globalization. So let us discuss the things. So today we are in the era of globalization. Multinational organizations worldwide have adopted the globalization as their first tactical choice. progress in technology has facilitated globalization to same hold factual to the banking sector also. So in this era, technology support is very important for each and every business organization that will be helpful to the successful functioning of the banking sector also. Information technology has been a major dynamic force of economic universal during last 2.5 decades. So this globalized era, technology support is very important for the successful functioning of the banking sector. So we all know. So during COVID-19 lockdown period, so almost all business organization has been closed, but we can see some only few industries were running around the clock. In that, we can see the banking sector also. So this is one of the basic sector. This is one of the basic need, as food, shelter, clothes. As like that, banking sector is also one of the need of the day. So here, basic objective or main objective of our study is to know the role of globalization on Indian banking, and then to analyze the role of information technology in Indian banking industry, and then to study the various emerging technologies in Indian banking sector. And then here is the research methodology. This based purely a descriptive type of study, because we don't have enough time to gather the primary data. That's why we are collecting some secondary data from various sources like journals, magazines, sites, and published data from various issues of RBI, and then different public sector banks, and then private sector banks, etc. So here is the globalization and Indian banking sector. So globalization, we know that meaning. Globalization is nothing but opening up the domestic economy into global economy. So India is generally taken to mean integrating the economy of the country with world economy. So the real thrust to the globalization process was provided by the new economic policy introduced by the government of India in July 1991. Then onwards, we can see we have a lot of development activities in our economy. This is only because of LPG, liberalization, globalization, and privatization, called New Economic Policy of India 1991. And then the financial sector reforms has brought about significant improvement in the financial strength as well as the competitiveness of the Indian banking system. The Indian banking sector has emerged as one of the strongest driver of the India's economic growth. Of course, banking sector is one of the basic sector in service sector. So because that service sector is going to contribute to a larger part to the GDP. So in that, we can see this banking sector is emerged as one of the strongest driver of India's economic growth. So information technology and Indian banking sector. So here, with the development of information technology, the world has become a global village. So I told that one, opening up the domestic economy into the world economy. So this is nothing but global as treated as a village. That means we can access anything from any corner of the country. It has brought out a revolution in the banking sector also. So the banks appears to be on fast track for information technology, which is based product as well as services. Deregulations and liberalizations in the financial sector has stimulated the financial innovations, so that opens the opportunities to the private sector banks. Then they were nationalized in two phases in Indian banking history. So in the last decades, almost all these sectors have gone for a massive investment in information technology. Today we can access any service from the bank on our finger. So this is one of the major areas of the economy that has received renewed focus in recent time, has been the financial sector. And within the broad ambit of the financial sector, it is banking sector that has been sunshine of academia and policymakers alike. So here is the various objectives of the computerized banking. So here it will help to provide improved service, improved customer service. So it helps to build a strong relationship with the customer through internet banking or other banking and mobile banking, and then SMS banking like that. It helps to better keeping housekeeping, and then faster decision making, and then increase the productivity, as well as that is helpful to the increase the profitability of the bank as well as the customers also. So here is the various emerging technologies in Indian banking sector in recent days. On the technology front, following delivery channels have been adopted by the banks, popularly known as electronic banking, which is really not on technology, but an attempt to merge several different technologies. Like the banks are going to offer various services to us. We can operate our account, we can access our account in our home or anywhere. We have the new concept that work from home. It is not work from home, it is the concept of work from anywhere. Like that, we can access our account anywhere. So if we have internet connection, today we have one more concept, rupee. So no need that internet connection also for our transaction. That they are the thing which were innovate in our modern days. So the personal computer banking, fintech services, innovative labs, UPI, and then digital wallets are the various platforms. So through we can operate our account with the help of internet. And then I want to conclude the things here. Overall, the Indian banking sector is stronger and healthier today than it was last 2 or 3 decades ago. So the recent focus of some of the banks on microfinance and lending small medium enterprises welcome changes both for the banking sector as well as economy and society as a whole. At the same time, technology had changed the way of people obtained financial service. It has also saved time. It is helpful to allow people to conduct banking efficiently, and then technology has helped with banking transformation from bulk paper and waste to paperless communication and means of transferring funds. Thank you, sir. Hello, I'm audible?
Yes, sir, you are clearly audible.
Thank you. Yeah, thank you, sir. Please.
Very nice presentation, sir.
Thank you.
Abhiraj,
So
sir,
much.
any questions for your side? Okay. My question is,
Yes, sir.
as you mentioned, the new areas in Indian banking sector,
Yes, sir.
and your topic is also related to information technology.
Yeah, of course.
Which laws are available in India relating to information technology?
No,
Which laws?
I don't aware about that much laws. So just I want to address about information technology, what we have, and then I'm going to write one more article related to how we can create awareness among our rural people, how we can literate our people in banking sector. I don't aware about that laws and all those things.
Okay, thank you so much, sir.
Yeah, sir. Thank you.
Mr. Manjunath,
Yes, sir. Yes, yeah.
I have one question.
Yes, sir. Sure.
Can you classify the biggest challenges faced today by the Indian banking sector?
Yeah, sir, of course. Today we have one of the biggest challenge is internet issue or security problem in banking sector. So we have to overcome from that challenge. So because we people are going to access our account on our phone or on our computer, laptop, etc. In that we have some problems like hacking, phishing, and then so many security problems were there. That is the biggest challenge.
Right.
At the same time, we are going to educate the rural people, not only literate the people. We are going to just literate the people in the form of creating account and then some operations in that account. But the thing is, we have to educate them instead of literate them. So regarding how they can save something, how they can access their account daily, and then how they can what are the benefits from the bank. All those things has to know by the customer itself or by the public itself. So that there is the biggest challenge to create some awareness among rural people, to educate the rural people regarding
Right.
banking sector. Even the educated people are also so-called educated people. They are not all aware about how I can access or how I can communicate with modern technology. They
Right.
are the challenges, sir. So that
Yes,
we have
yes, I got your
overcome those.
point,
Yeah,
but
yeah.
any other challenge you feel that which is a big threat for the Indian banking industry today?
Other than that, competition. That maybe one more thing is privatization. Today we have seen some privatization of public sector bank. That's one of the thing. But here, in what extent that is effective? That is one of the threat or a challenge. So we can see some public sector bank. At the same time, we can see some private sector bank. Private sector banks are going to provide better service than the public sector banks. How we can compare those two banks? That's one of the biggest challenge, I think.
But I feel that it is one of the biggest positives also
Yeah, of course,
when
it
we
is
look
the
at from the
positive thing.
consumer
It is the
point of view.
positive thing. Consumer point of thing, it is positive. In the ultimately, we can see what about the government? What about public sector? What are the various public sector companies or public sector plans we can see in our future days? All maybe privatized sector. So even we can, if you can, we can see some books like written by Karl Marx. He said that he's highly opposed that privatization or capitalism. This privatization may lead to the capitalism in upcoming days.
All right.
Thank you so much, sir.
I take your opinion. Although I was hoping to get the point on the biggest challenge, I believe, is the non-performing assets, or we say bad
NPA.
loans.
Yeah,
But
NPA.
it's fine. Your presentation was good. You
Yeah, sir.
presented it well.
Thank you so much, sir.
Thank you so much, sir.
Thank you.
After that, Reena S. Kumar.
Yes, very good afternoon, sir. I'm there.
Good afternoon. After Reena ma'am, Dr. Shamsuddin, and then Noor Sabah. Please ready with your PPT. Over to you, Reena S. Kumar ma'am.
Yes, sir. Just give me 2 minutes, sir. I'll be sharing my screen and then start. So is my screen visible for the PPT?
Yes, ma'am.
Very good afternoon to everyone present on this virtual platform, and I would say a special thanks to Parul ma'am for actually we have been associated for quite a long time on this online platform, and giving this opportunity and privilege to present my paper. And of course, our HOD also was a part of this conference, so it feels really, I feel very much elated over here. So the topic of my paper, actually, I'll just introduce myself in 2 minutes. I'm actually assistant professor, Department of Law, Sister Nivedita University. At present, I'm a research scholar also, pursuing my research work. My topic is nuances of development in the light of law and human rights. We all know that human rights are those basic rights which are actually necessary for the survival of people and their life. And these rights are inbuilt in people as soon as they are born. So these are the standards that recognize and protect the dignity of all human beings. Human rights are universal, inalienable, and indivisible. All individuals are equal as human beings and virtue of their inherent dignity of each human person. We know that every person and all people are entitled to active, free, and meaningful participation in and contributing to an enjoyment of civil, political, economic, social, and cultural development. And through human rights and fundamental freedoms, this can be realized. And states and other office duty bearers also have to comply with the legal norms and the standards which are enshrined in the Human Rights Instrument. Now, if we go on to the UDHR, that is the Universal Declaration of Human Rights, as we all are aware of. This was adopted in the General Assembly in 1948, and the first legal document to set out the fundamental human rights to be universally protected. It has basically main two covenants over here, that is the International Covenant for Civil and Political Rights and the International Covenant for Economic, Social and Cultural Rights. Now, the word itself, when we are talking about universality, we know that this principle of human rights is the cornerstone of international human rights law. And all human rights, as earlier stated, also are indivisible and interdependent. Now, Article 1 of UDHR, that is Universal Declaration of Human Rights, specifically states that all the human beings are born free and equal in dignity. And also in Article 2, it has been set out that they are free from discrimination, that is non-discrimination across all international human rights law. Then we come across to the history and development of human rights in India, because this is something which we have been seeing for a long time, which was there with the concept of Vasudeva Kutumbakam, which means that the world is one family. So this contains the soul of human civilization. And we have seen the history of human rights cover thousands of years, and it covers religious, social, philosophical, and legal advancements all through the recorded history. This philosophy of human rights have already occupied its place from the old Indian Brahmanical society, and we also know the reasoning of dharma, which of course did not have much scope of any religious discrimination. We had the teachings of Lord Buddha as well as Ashoka, who was a great leader, and they worked broadly for the protection of human rights. So basically, if we understand, our ancient Indian law stood for enlarging and empowering the human freedom, liberty, and equality for all the individuals. And it may be reviewed that from time to time, immemorial Indians have called their culture by the title of human culture, that is Manava Dharma or Manava Smriti, as we call it. Moving on to human rights involvement in India through judicial pronouncements, because we all know that judiciary, constitution, everything which is there in our law, we know that these things have been they have played a very important role in bringing the concept of human rights and trying to bring it in a whole way. So the Constitution of India, when was drafted, it was drafted with the deliberations keeping in mind the Universal Declaration of Human Rights, so that the framers of the Constitution were influenced by the concept of human rights. And the purpose of enumerating these basic rights were to safeguard them from the vicissitude of political controversy and to place them beyond the reach of the political parties, who by virtue of their majority may come to form the government either at the center or at the state. Now, in the matters of enforcement of fundamental rights, we can say the Constitution has provided concurrent writ jurisdiction upon the Supreme Court and the High Courts. And here it is very important to state that the judicial role is very important when it comes to safeguarding the individual's dignity and liberty, because it not only protects but also interprets the scope of fundamental rights. And therefore, we say that it is the guardian of the human rights of the individuals. There have been plethoras of judicial pronouncements or interpretations which have come as landmark judgments, which we can say. And by this, we can say, by virtue of Articles 32 and 226, the courts have greatly extended the ambit of the legal review and formulated modern strategies and techniques. Now, there was these cases of Satwant Singh versus Passport Office, where right to movement was elaborated and interpreted. In Golaknath versus State of Punjab, being a very important landmark judgment way back in 1967, the Supreme Court discussed the constitutional validity of Part 3, that is fundamental rights, and Part 4, the directive principles of state policies of the Constitution, in comparison with UDHR, that is the Universal Declaration of Human Rights. Then comes the glorious case of Keshav Nanda Bharti versus State of Kerala, where Supreme Court discussed about outlining the basic structure of the Indian Constitution. Then Justice P.N. Bhagwati, as we all know, he had embodied Article 21 as a constitutional value of supreme importance in a democratic society and characterized it as the procedural Magna Carta protective of life and liberty. This was highlighted in Maneka Gandhi versus Union of India. So we can see that there have been plethoras of cases and judgments wherein human rights have been highlighted and judiciary has played a very, very important role. Now let me highlight on the relationship between human rights and development. As we all know that we will not enjoy development without any security, we will not enjoy security without any development, and we will not enjoy either of them without respect for human rights. Now, the use of this development cooperation to promote human rights, that is, additional support to democratize the government, support to human rights, NGOs or decentralized cooperation received an increasing attention. And when this happened in 2000, that was when the Millennium Development Goals was an important achievement in establishing the relationship between human rights and development. These goals basically provided a framework for development cooperation institutions to work coherently together towards a common end. So the right to development, we can basically say, is rooted in the Charter of the United Nations, the Universal Declaration of Human Rights, and the two important international human rights covenants, as we know, we've earlier discussed. Development and human rights are intricately linked. So both development and human rights movement share the same enthusiasm and motivation to promote the freedom, well-being, and dignity of individuals. On the one hand, if we say human development improves the capabilities and freedoms of individuals, while on the other hand, we can say human rights provide the framework for a social arrangement that facilitates and secures capabilities and freedoms expressed by human development. Now, finally, I come to certain conclusions and then give my suggestions, because we all know that the entire nation has been gripped under the COVID-19 pandemic, and we have really seen plethora of incidents where violation of human rights was evident. If we see the cases of the migrant workers, they were exploited, they were humiliated, and we can say they faced a lot of problems and hassles. We can say that they were being displaced, and there was finally infringement of their fundamental rights. The marginalized group also, if we try to take the right to health, which was said that it should be given to each and every person, especially the marginalized group. But they faced the gruesome truth of being neglected, and they're being devoid of the necessary facilities. Being deprived of the basic fundamental rights, they are also deprived of their development. And if the development of their development is deprived, the development of a nation stops. Because with every individual developing, we know that an entire nation develops. So here I would like to quote what former UN High Commissioner for Human Rights Zaid Rad Al Hussein had stated, that when the fundamental principles of human rights are not protected, the center of our institution no longer holds. It is they that promote development that is sustainable, peace that is secure, and lives of dignity. So we need to empower institutions like National Human Rights Commission, the State Human Rights Commission, the National Women's Commission, even we have the Human Rights Court. So they have to be empowered to get the desired result. We are seeing new human rights interpretations are being introduced by upcoming new generations out of society's needs and necessities. And as we say that modern problems need a modern solution. So in this new trend of internet, everything is going digital, and with increasing developments, India needs to implement new rules and regulations to safeguard the interest of the public and their human rights. And with that, we can ensure the development for the individuals and the country. And we all know that, of course, challenges are always going to be there, but challenges only give you opportunities. And I hope that in the future, we will know that, yes, human rights have been properly maintained. And I think so each and every human being will be given equal opportunity and equal right. Thank you so much.
Thank you so much, ma'am. Your presentation is very well. And all the participants, please follow the guideline of time. We have only a 4 to 5 minutes for each participant. Ma'am, my only one question is,
yes, sir,
for you. We always discuss about the human rights. As per your opinion, what about the human responsibilities?
So human responsibilities are always there. If you see, sir, COVID-19 is a very big example, this pandemic. If you see our COVID barriers have, we can say that they have shouldered their responsibilities, I think, in a very gallant manner, I should say. But if you see their even human rights, there have been stages where we have seen that the COVID warriors, the COVID warriors also were not given proper, I think, measures or proper preventive steps were not being taken. Of course, at the later stage, of course, government took certain steps. But if we talk about our responsibilities, they're always taken properly, sir. But the thing is that we have to see that along with our responsibilities, the rights are also ensured. Because as human beings, as individuals, if you see, sir, even the case of migrant workers, the migrant workers they were at no, I think so, at no fault, but the way they suffered, what was their fault, sir, of suffering such horribly during the COVID-19 situation? I think each and every person in the world was, I think, crying on their pathetic situation. Human rights also interfered, but I think India was totally ignorant about that. That is the only word I should use over here.
Thank you so much, ma'am.
Yeah. Thank you, sir.
The next participant is Dr. Samshuddin. Are you there with us? Am I audible? Dr. Samshuddin, are you there?
No, sir, I cannot see him in the list. I think he's not there right now.
Move forward. Noor Sabha, are you ready with your PPT?
Yes, sir.
Please share your
I'm
PPT.
clearly audible? Yes, sir, sure.
Yes, you are clearly audible.
Is my screen is visible, sir? Is my screen is visible, sir?
Yes, it is visible now.
Okay, thank you, sir. Good afternoon to respected chief guests, respected principal, sir, director, ma'am, management head, ma'am, HOD department, and very good afternoon to all dear faculties and my batchmates. I am Noor Sabha from BRLB first year and a student of SNS Law College. Today I am going to present about legal dimensions of public health laws in India. The content of the topic is introduction, definition. Here the PHL denotes public health laws. So objectives, scope and importance of public health laws, problems with public health laws in India. Public health laws in India, major acts relate to the public health laws, and the last is conclusion. Let's begin the topic. What do you mean by public health law? For any country, for any nation, public health laws are very important in every aspect of community health. For improvement and protection of the health, an adequate health system is required. Here, Professor Lawrence Gustin said that public health laws are such legal forces and duties of an organized society by which condition for maintaining citizens' health and ensured. Now, moving ahead, objectives of public health laws. First objective is to protection and promotion of public health. Second is control the risks to public health. Third is promote the control of infectious disease in our country. And fourth is prevent the spread of infectious disease or communicable disease. And last is to recognize the role of government in protecting public health or the health of citizens of our country. Next is the scope of public health law. The scope of public health law is broad and wider because this is a range from narrow question of legal interpretation to complex matter, and it involves complex matters such as public health policy, social justice, ethics, etc. Now I'm going to telling about some importance of public health laws. It helps to follow the international health law, and although it is called national health laws, it helps for identification of government limitation in the area of health, making necessary financial provision for health, protection to consumer of health service. Here are some obstacle and problem with public health laws. The first is lack of awareness of the people or the public about the public health law. Second is social aspect related to the health and health matters of public. Third is various implementation problems in our country. Then long time taking in the prosecution. If we file the case against anyone who violate the public health law, it takes long time in the further prosecution. Then, of course, there is a practical problem further implement and enact public health law. After that, improper reporting towards the violation of public health laws. Last is there is a widespread corruption even in the field of health and wealth service. Next is public health laws in our country. So it is responsibility of our central and state government to make and implement various public health laws for the protection and promotion of health of its citizens. most of the public health laws enacted by the center or central government. The state have either accepted these law as it is or they made some amendment in the form of either law or by the law. Here I mentioned some acts related to the public health laws. The Pharmacy Act 1948, Environmental Act and Rules, Mental Health 1987, and many more. Now I conclude the topic. Public health laws is an important tool for making public health outcomes. The developing countries have to develop a model public health act, and modification and amendment, if and where necessary, could be made at appropriate time and level. The model state of public health act is aggressive and needed. Organizational structure and approach share similarities, complex. And the last but not least, uh, I acknowledge and I would like to express my gratitude to SNS Law College, RFI Research Foundation of India, and IMI staff who guide me throughout this research. And thanks for giving me this opportunity. As we all know, health is a state of complete harmony of the body, mind, and spirit. So please stay safe and stay healthy. Thank you so much for your attention.
Thank you, Noor Sabah. That was a good presentation. I have one question for you. Can you hear me, Noor?
Yes, sir.
Well, my question is that uh, what do you think the right to health, as we stated in our constitution also, the right to health is, do you find it justifiable in different constitutions of the world?
Yes, sir, it is justiciable, and the human rights to health is protected in Article 25 of Universal Declaration of Human Rights, Article 12 of International Covenant on Economic, Social, and Cultural Rights, Article 12 and 14 of the Convention of the Elimination of All Forms of Discrimination Against Women, Article 25 of the Convention of the Right of Person with Disabilities, and Article 12 of the International Covenant Human Rights. And the last is Article 5 of the Convention on the Elimination of All the Forms Racial Discrimination. That's it.
Thank you so much,
Oh,
Noor Sabah.
all right. Thank you.
Shivani Yadav, are you there with us?
Yes, sir, I'm there.
Please start your presentation. After Shivani Yadav, Anu Bagla, Aba Gupta, and Harshita Kadolia. Please ready with your PPT. Over to you,
Shall I
Shivani
start,
Yadav.
sir?
Yes, please.
Good afternoon, everyone. I'm Shivani Yadav, student of BLLB third year from SNS Law College. Today, I'm going to shed a light upon my research topic, access to justice and public legal awareness. Access to justice is indeed a human right as well as a fundamental principle of rule of law. The paper aims to show the variables that are contributing in making access to justice so challenging in India. This paper also analyzes the veritable practicality of the bookish laws and what factors can make the path of access to justice easier. So let's start with the presentation. So next slide, please. There is a saying which goes as, Keshav, sir, I guess there is some issue. So let me share. Sir, is my screen is visible?
Yes, yes, Shivani, it's visible.
There is a saying which goes as, access to justice is injustice. Justice is considered to be the foundation of existence. The term justice has been taken from the Latin word jangar, which means to bind or preserve. It stands for rule of law, absence of arbitrariness, and a system of equal rights. The Constitution of India itself in its principles of justice. Justice and access to justice are core tenets of a welfare state, which involves various fundamental principles. Access to justice is a basic right of an individual. But if one is getting it difficult to reach to justice, there must be some reasons behind this. And here are those stumbling blocks. The very first is economic factor. As per 2011 census report, 21.9% of India's population is below poverty line. And these people do not even have enough food to eat twice a day. Then how would they pay to access such costly justice in case of violation? Another one is social factor like discrimination based on marginalization and police insensitivity. Besides economic and social factor, there are drawbacks of administrative systems such as latency in justice. The data showing here is provided by the Supreme Court itself. In India, there is only one judge for approximately 50,000 people, which is enhancing the pendency. Due to such complex procedure, a considerable segment of population resist approaching the courts. Moving ahead to the next slide and heading, which is an underlying cause of low accessibility to justice, that is public legal awareness. Awareness of every individual concerning legal issues can be termed as legal awareness. This picture in the slide is showing why legal awareness is such crucial. See the first person speaking to the another to not to speak against the policies. And by responding, the second person stating his right of freedom of speech under Article 19. See, if one is aware of its rights, then no one can make them deprived from those. Lack of knowledge always creates a gap. Therefore, it is crucial to educate everyone in order to broaden the ambit of their legal consciousness. Moving further to the next slide, which discusses the practicality of legal aid provisions of Constitution. Legal aid is basically provide legal assistance to unprivileged ones. As like Article 14, the Indian Constitution encompasses numerous provisions that facilitates legal aid. In 1976, 42nd Amendment Act introduced Article 39A, which deals with legal aid. Now the question arises here, is the free legal aid really free? Well, the laws embedded promises to give completely free legal aid to needies. However, the practical aspect of such laws are far different from reality. The legal aid committees pay a very low amount to the advocates indulged in such services. As a consequence, they push their clients to pay specific sum for services. Therefore, people also believe that free service is clearly inconsistent with qualitative services, and hence they don't go for such aid services. The Supreme Court has given a landmark verdict in Husnaira Khatun versus Home Secretary Bihar's case by describing importance of Article 39A. As a result of aforesaid mentioned reasons, the legal aid movement has been failing to reach its goals. So, how to make the justice path accessible? See, bringing out reforms is the need of the hour, and it can be implemented in many ways. The pioneer thing is to recruit more judges to lower the pendency of cases. More courts should be built without a huge gap between constituencies. Upgradation of technology would be more productive for Indian judiciary. Additionally, for spreading legal awareness, a large-scale organizational for legal assistant camp should be organized. Current social strata are utterly unenlightened about execution of legal aid services. The concern is still over the question of realistic approach of existing laws. It seems a tough road to hoe. That means a difficult task to educate people about something they have never known of anyway, but it's not impracticable. Conclusively, because boosting access to justice is more about rendering qualitative justice. Thank you.
Thank you so much, Shivani. Here
That
you
was a very
discuss.
good presentation, Shiva.
Thank you, sir.
Here you discuss about the legal aid. My question is, which section of Criminal Procedure Code deals with the legal aid provision, and what does it say? In the Criminal Procedure Code, which section deals with the criminal procedure?
Section 304 of Criminal Procedure Act. Section 304 of the Criminal Procedure Act 1973 deals with the legal aid provision. Goes like that: courts shall assign a pleader for the accused defense at the expense of the state. Then seems it appear that the accused have not adequate means to approach a pleader.
Thank you so much, Shivani.
That's about Section 304. Thank you,
Thank you
sir.
so much. Anu Bagla, are you there with us? Abha Gupta, are you there with us?
Yes, sir. Am I audible?
Yes, you are clearly audible. Please start your
Okay,
presentation.
sir. Let me present my screen. Sir, is my presentation visible?
Yes, your presentation is visible.
Okay. Hello, and a very good afternoon to everyone present here. I am Abha Gupta and I am a second year law student from SNS Law College. Today I'll be delivering my paper presentation on the topic the law and emergency situation. Coming on to the topics which I'll be discussing today, I'll start with introducing emergency, followed by state of emergency, emergency laws in India, emergency of 1975, need for a health emergency, and lastly the conclusion. So basically, the term emergency refers to an unexpected and difficult situation which requires quick action and assistance to deal with it. Now, if any emergency occurs, the condition of unrest arises, and to control the unrest, government declares a state of emergency to restore control over the national danger, in which government suspends normal constitutional procedures and works as a unitary model. Emergency laws in India are special provisions of Indian Constitution. They are given under Part 18 of the Indian Constitution from Article 352 to 360. The three kind of emergencies which are provided in Indian Constitution are national emergency, state emergency, which is also known as President's Rule, and financial emergency. Here is a table for a better understanding of the emergency provisions. National emergency is given under Article 352. President's Rule under Article 356 and Financial Emergency under Article 360. For proclaiming any of these emergencies, certain grounds are specified. Article 352 can be invoked on the grounds of external aggression or armed rebellion. Article 356 on the grounds of failure of constitutional machinery. And Article 360 on the ground of threat to financial stability or credit of India. In all the three emergencies, approval of both the houses is required within specific time limit. And for the approval, majority is required, and a special majority is required in the case of national emergency. Fundamental rights under Article 19 can only be suspended on the grounds of war or external aggression. These emergencies, after proclamation, can be continued till the given time and can be renewed again. President of India can revoke emergency at any time. Now, emergency of 1975. In the contemporary history, emergency of 1975 was the darkest time for democracy. The emergency was declared by then President Fakhruddin Ali Ahmed on advice of Indira Gandhi. The emergency was declared on midnight of June 25, 1975 and lasted for 21 months. Indira Gandhi justified the emergency, giving various reasons like threat to India's stability, establishment of economic development, foreign involvement, etc. But the actual reasons were the verdict of Allahabad High Court, nationwide protests and movements which were forcing her to resign and many more. Emergency of 1975 gave birth to dictatorship in the veil of democracy. Press freedom was censored, fundamental rights were suspended, thousands of people were illegally detained, writs were suspended, mass sterilization program was conducted which violated the basic human rights of individuals. However, the emergency came to an end in 1977. Now, coming on to the next part, which is the need for a health emergency. Generally, health emergency is a situation which poses threat to public health and leads to death or serious health problems. In 2019, a novel coronavirus came which created a situation of emergency. Now, the question here is that how emergency provisions or laws are related to a pandemic. Looking back at history, when outbreaks like influenza and swine flu struck the world, we can observe that health emergencies have been occurring for a very long time now, but there is no accurate law to deal with them. The major law we have is the Epidemics Diseases Act, which is a 124-year-old law and is incapable of handling modern crisis. At present, there is no provision for health emergency. Initially, the term internal disturbance could have covered the health emergency, but it was replaced by armed rebellion in 44th constitutional amendment. However, it is ascertained that emergency change and varies with time, and a specific provision will be unable to cover every emergency. Concluding my paper, I noticed that the emergency provisions allow our federal government to work as a unitary model. However, the provision has been misapplied in 1975 and it brought down our democracy to its knees. A large number of human rights violation was witnessed. Nonetheless, major amendments in emergency provision were done to protect the nation's stability. In light of COVID, it has been seen that a law for health emergency is necessary. But it is also found that if not a specific health provision, a term could be used which can cover various extraordinary situations under one umbrella, and that is the need of our. Thank you.
Thank you so much, Abha. My question is, in one of your slide, you mentioned a special majority and the simple majority for
Yes, sir.
approval of bill. What does
Yes, sir.
actually mean, and what is the actual difference between the special and
Yes, sir.
simple majority? Please.
So, for proclaiming an emergency, approval of both the houses, that is Lok Sabha and Rajya Sabha, is necessary, and approval will be considered valid when it is passed by majority. In case of Article 352, special majority is required, which means a majority of the total membership of that house, and by a majority of not less than two-thirds of the members of that house present and voting. And under Article 356 and 360, simple majority is required, which refers to the majority of more than 50% of the members present and voting. Yes, sir.
Thank you so much, Abha.
Thank you, sir.
The next participant is Harshita.
Yes, sir, I'm present here.
Okay, Harshita,
Let
please
me share my
start your
screen.
presentation.
Yes, sir. Is my skin is visible to you, sir?
Yes, Harshita, your screen is visible, but presentation is not visible.
So now,
Yes.
a very good afternoon to all dignitaries. I am Ashita Kadulia, student of S&S Law College, with my topic Justice and Legal Empowerment. Here are yes, sir. Here are the outlines of my research paper. Moving ahead with the introduction. The law is meant to be just, fair, and aware the needs of individual groups and communities. Many people cannot obtain meaningful justice. Access to justice implies that individuals are fit for claiming their rights to ensure their livelihood, pay resources, and look for a cure for exploitation. And it is the capacity of a state where each individual can get legal review regardless of his money and different inabilities, and that too is in a reasonable, equivalent, and a fast way. Legal empowerment is a process through which the poor, women, minorities, and vulnerable groups become secured and are empowered to utilize the law to propel their rights and their interests. Now, the constitutional provisions. Legal awareness and legal literacy lie at the foundation of any work toward legal empowerment. Basic information on legal and constitutional provisions and processes combined with the abilities to utilize this information to acknowledge rights and privileges will enable individuals to demand justice, responsibility, and compelling remedies at all levels. Access to justice as a directive principle for the state is given under Article 38 and 39A, added by the 42nd Constitutional Amendment Act of the Indian Constitution. In the case Husainara Khatun versus Home Secretary Bihar, 1979, the Supreme Court held that Article 39A has met free legitimate help an unavoidable component of reasonable, fair, and just procedure, and the right is implied under Article 14. Fundamental rights, Article 14, Article 15, and Article 21 work as an instrument to accomplish access to justice. In the case of M.H. Hose Court versus the state of Maharashtra, in 1978, the Supreme Court ruled that free legal aid to the poor at the cost of the state, even an accused who could not afford legal services because of poverty was part of a fair, just, and reasonable procedure implicit under Article 21. Now, the rule of law. The rule of law depends on the principle that the law is supreme and everybody is equivalent before the law and responsible for their activities. Access to justice and equity is a fundamental precept of the rule of law. The rule of law encourages improvement through fortifying the voice of people and communities by giving access to justice, guaranteeing fair treatment, and setting up solutions for the infringement of rights. Legal empowerment goes beyond the past of the provisions of lawful remedy and supports better economic opportunities. Now, role of legal empowerment in justice. Legal empowerment and legal aid programs are the central component of strategies to enhance access to justice. It helps victims of injustices to address their justice issues. It protects poor people and marginalized communities from injustices like wrongful eviction, dispossession, coercion, and exploitation. Women are dependent on men in many nations. They are unaware of their rights and become victims of injustices. Legal empowerment ensures rights and empower women to fight for justice and their rights. It educates and aware people about their rights, privileges, and lawful remedy. It also offers promising new techniques to further develop access to justice and assemble general sets of laws that work for everybody. Now, here are some obstacles in the path of legal empowerment and justice. Lack of effective enforcement and judgments and decisions. Lack of awareness, lack of legal literacy, and extreme number of law expressed in foreign language. Significant expenses on legal action. Lack of experience in dealing with the formal justice institutions, and the process to get justice is complicated, time-consuming, and context-specific. To break these obstacles, some suggestive measures for legal empowerment and access to justice. Legal empowerment can try to boost the voice of underestimating local area of individuals in local administration and public approach. Widening the scope of availability of functioning of justice so the individual, particularly the minorities, does not take them as weak and discriminated groups and think about their privileges and remedies in the event of any infringement of those rights. Aware people, legal empowerment can aware people and show them the positivity and transparency of justice system. Numerous communities don't know about the established constitutional safeguards and other legal provisions. By increased campaigning regarding legal literacy and rights awareness raising exercise or activities, we can break this barrier. Here are some goals of legal empowerment. Legal empowerment aims to empower people and communities to know, use, and shape the law that affects their life in a positive way. The goal of legal empowerment efforts to aid awareness, elevating, and legal literacy program concentrated on women, consisting of rural women, on gender inequality to inspire and empower them to demand for justice. Legal empowerment intend to accomplish such objective as the reduction of poverty, ensuring individual rights, lawful certainty, and the protection from wrongdoing and government misuse, and reform of law and consistency in lawful methods. Legal empowerment in the perspective of human rights. Legal empowerment is established in human right-based way to deal with advancement, which perceives that poverty results from avoidance, partiality, and discrimination. In this way, legal empowerment cultivates improvement through enabling and reinforcing the voice of people and communities, beginning at the grassroots from the inside. The international human rights structure offer a far-reaching reason for for legal empowerment of poor people. Here is the conclusion. Our law is made to provide rights, justice without discrimination, uniformity and equal opportunity and freedom to all.
There are such countless obstacles in the road to seek justice. Legal empowerment breaks the barrier in accessing justice and provides opportunities to all. In this way, it plays a crucial role to access justice. Thank you.
Thank you so much, Harshita Kadolia.
Thank you, sir.
Only one question for my side. What steps were taken by the government to aware people about the legal literacy?
Sir, there are various steps taken by government, such as Kanun Ki Baat, a weekly public welfare awareness program is telecast regularly on Akashvani, Doordarshan and community radio. Legal literacy camp are held at schools, university and public places. There is a national legal literacy mission was launched by our honorable Prime Minister of India, Dr. Manmohan Singh, with the goal legal empowerment of all sections and all of the society. National Legal Literacy Day is celebrated on November 9. Yes, sir. That's it.
Thank you so much. Next one is Ashi Rajvedya, and then Ram Gurjar, and then K. Sarvani, and then Amruta Mary Lucas. That is a sequence. Please be ready with your PPT. Ashi Rajvedya, are you there with us?
Yes, sir. Yes, sir. Sir, is my screen is visible or not?
Yes, Ashi, your screen is visible. Please start your presentation.
Sir, am I audible properly?
Yes, you are clearly audible.
Okay, sir. Okay. Good afternoon, everyone. I am Ashi Rajved and I am the student of SNS Law College, Indore. I am so grateful towards my college that they have given me to that precious opportunity to present my research paper in front of the audience. My research paper topic is Economic Development and Inclusive Legal System. This paper investigates whether the legal system intended our economic development. Role of legal system in economic development. A legal system is a procedure or process for interpreting and enforcing the law, and implementation of legal system has proved to be good for the development of our economy. I have mentioned such existing laws and acts which helped our economy to grow and develop. The first one is Foreign Exchange Management Act 1999. The central government has enacted payments and cross-border trade into India known as the Foreign Exchange Management Act. FEMA was essentially introduced to deregularize and have a liberal economy in India. And FEMA has played a huge role in the development of the economy. The second one is MRTP Act 1969. MRTP Act was enacted to ensure the concentration of economic power in the hands of the few rich, and as a result the market is more capable of rapidly relocating resources, improving productivity and achieving a higher level of economic growth. The third one is Consumer Protection Act 2019. On 20 July 2020, the new Consumer Protection Act 2019 enacted into force in India, replacing the old one, Consumer Protection Act 1986. The new act includes strict penalties, include jail for adultering and false advertising. It empowers the consumer and helps them to protect their rights. Hence, the Consumer Protection Act 2019 is a progressive welfare legislation that ultimately benefits the consumer of India. It also plays an important role for the economy as consumption spending increases the economic growth. And the last one is Goods and Services Tax. GST streamlines India's tax structure, increase the tax base and create a single market for all states. This result in greater compliance, which helps in India's GDP growth. This taxation scheme shows significant promise for the India's long-term economic growth. Still backwardness of economy. As FEMA was replaced by the FERA because FERA was not effective so well, but it still has many disadvantages, such as FEMA not being involved in the community planning process. And in the Population Control Bill 2019 also has a negative impact in our economy because there is an interference with freedom and human rights. Ethical concerns, religious concerns, frustration introduction implies large financial burden for one generation, and it has directly negative impacts on economic development. As we have seen in previous slides, such a legal system has greatly assisted the economic development of India. But in the India, as we saw that still economic development is not happening in our country. Our government will have to bring such more effective legal system which will develop our economy more well. Thank you and have a great day.
All right, Ashi. Ashi, can you hear me?
Yes, sir. Yes, sir.
Ashi, can you tell me the name of the act which was there, which was applicable before FEMA?
Yes, sir. Yes, sir. Sir, the Population Control Bill and Right of Children to Free and Compulsory Education Act.
No. The FEMA replaced one act.
Yes, sir. FERA.
FERA, right.
Yes,
And another question, can you, what you were telling me some more laws which were there, which helped economic development. Can you name
Yes, sir.
a few more legislations?
Yes, sir. So there are many acts and laws such as Population Control Bill, Right of Children to Free and Compulsory Education Act, Right to Inform Act, and Limitation Act 1963, and many more.
All right. Thank you.
Yes, sir. Thank you so much, sir.
Thank you so much, Ashi. Ram Gurjar, are you there with us?
Yes, sir, I'm there.
Please
So
start
there
your
is some
presentation.
technical issue. Negi sir, can you please show my PPT? Negi sir.
Just a second, please.
Rahul sir, I have one question with Ashi. If till the time Ram is presenting the screen.
Sure, ma'am. Definitely.
Okay. Ashi, are you there?
Yes, ma'am.
Ashi, you have mentioned that in your conclusion that you are looking towards the government that more of such policies should be implemented for the economic development so that the inclusive legal system can develop in our economy. So being the citizen of country or being the responsible citizen of country, what do you suggest if you might get a chance to give one advice to the government? Ashi.
यस मैम आई जस्ट सजेस्ट दैट हमारी गवर्नमेंट को और ऐसे कुछ लीगल सिस्टम्स लाने पड़ेंगे जैसे कि जिससे हमारी इकोनॉमी और डेवलप हो और
Okay.
Sources, lack of clearly defined procedure and cumbersome rules and regulation. The MRTP Act wasn't as effective. But that's why the new act was enacted, the Competition Act 2002. Just like that, ऐसे कई amendment हमें करने पड़ेंगे. Yes, ma'am, done. Sorry.
Okay, no, it was good. Thank you so much.
Thank you,
Please
ma'am.
proceed. Thank you, sir.
Ram Gurjar, are you ready with your PPT? Keshav sir, the PPT, please.
Yes, sir. Thank you, sir. आप सभी को मेरा नमस्कार. मैं राम गुर्जर, स्टूडेंट ऑफ एसएनएस लॉ कॉलेज, एंड माय टुडे रिसर्च टॉपिक ई कोर्ट सर्विसेज इन फ्यूचर. इस रिसर्च में हम देखेंगे कि ई कोर्ट सर्विसेज है क्या एक्चुअली में और इसमें क्या क्या चीजें डेवलप हुई है. इंट्रोडक्शन की हम बात करें तो दुनिया के बढ़ते डिजिटलाइजेशन ने भारतीय न्यायपालिका को काफी सीमा तक डिजिटल कर दिया है. कोविड-19 पेंडेमिक के कारण दुनिया में तथा देश में सारी व्यवस्थाएं लगभग पूर्णतः बंद हो गई थी. ऐसी स्थिति में नागरिकों को न्याय से वंचित नहीं रखा जा सकता था, इसलिए हमने ई फॉर्म में कार्यवाहियां जारी रखी. हमारी न्याय व्यवस्था को ई फॉर्म में लाना और बेटर इम्प्रूवमेंट करना अत्यंत आवश्यक है. यदि हम पास्ट, प्रेजेंट और फ्यूचर की बात करें तो पास्ट में आजादी के बाद ई कोर्ट सिस्टम जो था वो पूर्णतः फिजिकल फॉर्म में चलता था. धीरे धीरे परिस्थितियों में सुधार आने लगा और व्यवस्था में परिवर्तन होने लगा और हम इलेक्ट्रॉनिक डिवाइसेस को भी कोर्ट प्रोसीडिंग्स में यूज करने लगे। करंट सिचुएशन में कोविड-19 पेंडेमिक के चलते कुछ समय के लिए कोर्ट सिस्टम पूरी तरीके से बंद हो गया था, बट नागरिकों को न्याय से वंचित नहीं रखा जा सकता। उन्हें न्याय प्राप्ति में और अधिक समय न लगे, इसलिए हमने ई कोर्ट सिस्टम को सुचारू रूप से संचालित किया गया। भविष्य में ई कोर्ट सेवाओं में विकास होगा और न्याय तक जल्दी पहुंचा जा सकेगा, सुचारू रूप से पहुंचा जा सकेगा। नाउ व्हाट इज ई कोर्ट? ई कोर्ट इज अ कंप्यूटराइज्ड कोर्ट सिस्टम जिसमें ई पोर्टल, ई प्रोसीडिंग्स, वीडियो कॉन्फ्रेंसिंग, ई केस स्टेटस, ई फाइलिंग, ये सारी सुविधाएं आती हैं। करंट डेवलपमेंट्स की यदि हम बात करें, सर नेक्स्ट स्लाइड प्लीज। करंट डेवलपमेंट्स की यदि हम बात करें तो करंट डेवलपमेंट में बहुत सारी इलेक्ट्रॉनिक सुविधाओं को विकसित किया गया है, जैसे कि ई रिकॉर्डिंग, ई प्रोसीडिंग, वीडियो कॉन्फ्रेंसिंग, ई पोर्टल, इंटरनल एंड एक्सटर्नल रिसोर्सेज एंड मेनी मोर थिंग। टेक्नोलॉजी के इंट्रोडक्शन ने कोर्ट के वेब एंड इंटरनेट टेक्नोलॉजी के रैपिड डेवलपमेंट में सपोर्ट किया है। टेक्नोलॉजी के यूज और स्ट्रेटेजिक टेक्नोलॉजी योजना के लिए कोर्ट प्रोटोकॉल्स के महत्व को कम नहीं आंका जा सकता है। कोर्ट रूम पोर्टल्स की हम यदि बात करें, सर नेक्स्ट स्लाइड। हेलो, जजेस एंड अदर पार्टीज को एक सेंट्रलाइज डेस्कटॉप प्रोवाइड करना मोस्ट करंट डेवलपमेंट प्रोजेक्ट का एक एम हो सकता है। दिस एरिया ऑफ डेवलपमेंट इज यूजुअली मेंशन एट पोर्टल डेवलपमेंट दैट इज ऑल की इंफॉर्मेशन कंपोनेंट्स एंड ऑर्गेनाइज्ड info on one point access for users. More importantly, the system automatically fingers of a customized desktop for users to support security and users profile. ई फाइलिंग एंड एडीआर की यदि हम बात करें तो कोर्ट में ई फाइलिंग सिस्टम आने के साथ ही अतिरिक्त कार्य क्षमता या एक्स्ट्रा फंक्शनलिटी का अधिकांश हिस्सा संभव पाएगा। ई फाइलिंग एक नेटिव इलेक्ट्रॉनिक फॉर्मेट के दौरान सामग्री की प्रारंभिक प्रविष्टि को अदालत में या कोर्ट में छोड़ देगी। यह सुनवाई प्रक्रिया से संबंधित डॉक्यूमेंट्स को सीधे कोर्ट रूम में ट्रांसफर करने की प्रक्रिया को सरल करता है, जो कि पर्सनल कंप्यूटर बेस्ड इंटरफेस के माध्यम से रिस्पेक्टिव जजेस के सामने सेंट्रलाइज्ड डेस्कटॉप पे सुलभ होगा। कंक्लूजन की यदि हम बात करें तो डिजिटलाइजेशन एंड टेक्नोलॉजी के बढ़ते विकास के आधार पर ई कोर्ट सर्विसेज का भविष्य में सुचारू रूप से संचालित किया जा सकता है। ऐसा माना जा सकता है कि टेक्नोलॉजी ई कोर्ट को बेहतर बनाने या ई कोर्ट सेवाओं को बेहतर बनाने में अहम भूमिका निभा रही है, जिसमें भारत और पूरी दुनिया ई कोर्ट सेवाएं न्याय तक पहुंचने में बेटर वे प्रेजेंट करेगी। थैंक यू सर। हेलो,
good presentation, Ram Gurjar. Are you thinking that e-court system is safer than we एक तरफ हम बात करते हैं इतने सारे इलेक्ट्रॉनिक ऑफेंसेस के बारे में और इतने सारे हैकिंग, फिशिंग, इन सभी चीजों के बारे में, तो क्या आपको लगता है कि इलेक्ट्रॉनिक कोर्ट सिस्टम भी हैक नहीं हो सकता या उसको प्रिवेंट करने के लिए और भी ज्यादा प्रॉब्लम्स और चैलेंजेस
हैक हो सकता है, लेकिन सर चैलेंजेस और प्रॉब्लम्स हर जगह हो सकती है। ई कोर्ट भी हैक हो सकता है, बट हमें ऐसे टूल्स और सिक्योरिटीज लानी होगी जिसमें हैकर्स उस पर डायरेक्टली अटैक ना कर सके, कोर्ट पोर्टल्स पे अटैक ना कर सके। हमें इतना ऑब्जर्वेशन या इतना टेक्नोलॉजी को यूज इनबिल्ड करना होगा। यदि हम कोर्ट रूम को भी ना बचा सके तो फिर हम किस प्रकार का कोर्ट रूम सिस्टम एस्टेब्लिश करेंगे या किस प्रकार का जस्टिस सिस्टम एस्टेब्लिश करेंगे? यदि वहां भी साइबर क्राइम्स या साइबर क्रिमिनल्स क्राइम कर दे तो फिर कोर्ट किस बात का?
Okay, thank you so much. Our next participant is
Thank you, sir.
K. Sarvani. Are you there with us?
Yes, sir. I'm here, sir.
Please, ma'am, start your presentation.
Sir. Sir. My PPT is visible, sir. Sir.
No,
Yes,
ma'am,
ma'am.
it's not visible yet.
Sure. So now it's visible, sir.
Yes, ma'am. Please start your presentation. Your screen is visible.
First of all, my heartfelt thanks to all the organizers. This is my first paper presentation, sir. I'm a research scholar in Padmavati Mahila Vishwavidyalayam, Tirupati. Sir, my topic is healthcare from the perspective of human rights. Healthcare from the perspective of human rights. First, we all have to know about what are human rights. Human rights. Human rights are the basic rights and freedoms that belong to every person in the world, from birth until to the death. They apply regardless of where you are from, what you believe, and how you choose to live your life. They can never be taken away. However, they can be sometimes be restricted in some cases, as we know, emergency cases, and also Article 19, right, which is given to the all people, citizens, but it can be restricted to some extent. There are some restrictions in the basic rights that are based on the shared values like dignity, fairness, equality, respect, and independence. All these are the basic structure of our Indian Constitution doctrine, which was held in Keshwan Bharti case. These values are defined and protected by law. The main aspects of human rights are interdependence and interrelatedness, which means these human rights are correlated with other so many aspects, which means there are obligations, which are rights. Rights and obligations are correlated with each other. These human rights are basically enshrined in Part 4 of our Constitution, which enshrines directive principles of state policy. It means directives principles, though not enforceable, these human rights are put there as they are so much given importance. But in my view, they should be put in Part 3 of the Constitution as a fundamental rights. In this paper, I am stressing about what are human rights, and we know all the legislations about the rights. As we are law students, we can know the legislations and sections of law from the books itself. But what to do for the implementation of these rights? That in that aspect, I am presenting my paper. Participation, equality, and non-discrimination. These human rights must be enforceable to all the people without any discrimination. Discrimination means they in Article 15 and 16 enshrines that there should be no discrimination, and but a protective discrimination is applicable, available to our people as enshrined in Article 15. Participation and inclusion. Every must should know what are the rights that are available to all of the citizens. Then only they can participate and they can go through with their rights. Accountability and rule of law. Rule of law is an English principle from which was derived from Dicey's rule from England. We should know that rule of law means equity, good consent, and justice. These principles must be enshrined when we are implementing these human rights. We all know on 10th December 1948 that the General Assembly of the United Nations adopted and proclaimed the Sir, I am visible, sir. I am audible, sir.
Yes, ma'am.
Sir. On 10th December 1948, the General Assembly on the United Nations adopted and proclaimed the Universal Declaration of Human Rights. In these, all human beings are born with equal and inalienable rights and fundamental freedoms. This was stated in the Universal Declaration of Human Rights, UDHR. On that day, we are celebrating human rights from that year. So many conventions are made to implement these human rights. So many treaties were made. All these treaties were adopted by our country, our constitution. But what are the in what aspect they are failed? Because the healthcare system. We in this topic we are dealing with human rights with the healthcare system. Healthcare system in India is universal. Healthcare between the states and the rural and urban areas can be vastly different because rural areas often suffer from physical shortages are there and disparities between the states. That means residents of the poorest states like Bihar often have less access to the adequate healthcare than residents of the relatively more affluent states. This was made because of poorest states. The state governments have to provide the healthcare facilities, which was enshrined in Article 39 of the 39A of the Constitution. There is a duty cast on the state to provide healthcare facilities and health education, while the central government offers administrative and technical services treatment in India. The lack of adequate coverage by the healthcare system in India, it means that many Indians turn to the private healthcare providers. This is an option generally inaccessible to the poor. The adequate coverage of healthcare is not adequate in India. Indians lack health insurance and out-of-pocket costs make a large portion of spending on medical treatment in India. There should be healthcare insurance policies which should be maintained from sanitary workers to the any employer which they are employing in a greater efficiency or not. There should be health insurance policy should be maintained from the employer side. If human rights need to have genuine meaning, they must be correlated with public involvement, and this participation should be preceded by empowerment of the people. So we have to empower the people about their healthcare facilities correlated with the human rights, and then only we can make the public involvement in the human rights with healthcare aspect too. The right to health is one of set of internationally agreed human rights standards as inseparable or indivisible from other rights. The right to health is inseparable. Article 21 in itself says right to health is an interdisciplinary part. In Hussain and Carton case, it was dealt, but it was indeed we have to look after that. Where is the health aspect? So I want to suggest this. Right to health must be enshrined in Part 3 of the Constitution. So it is the right time. This means achieving the right to health is both central and to the dependent upon the realization of other human rights: food, housing, work,
Please
education,
conclude.
information.
I'm sorry to disturb you. Please conclude, ma'am.
It has now become clear that the COVID-19 pandemic is putting significant stress on our already limited healthcare resources, because our public health services are understaffed and under-resourced. So I would say that one of most positive impacts of this COVID-19 epidemic has been that it has opened the eyes of the people to the importance of universal and robust public health services and need for everybody to covered by quality health care, or for health services to be accessible to everyone. So I consider the view that health care must be recognized as fundamental right, through which the citizens can vigilant, and then only they can then only the country may develop in all aspects. Thank you. Thank you, sir.
Thank you so much, ma'am.
Thank you, ma'am. I have one question for you.
Yes.
You have mentioned in your PPT that one of the main aspects of human rights is non-discrimination. But do you think that the healthcare facilities which are available in India, they are also biased? And when I'm saying this, I'm not talking about the infrastructural challenges which you also mentioned. I'm talking about the 5 bases of discrimination which are there in the Constitution. Do you think people are getting discriminated on those bases today itself, today also?
Sir, so many aspects are there, sir. Infrastructure is there, but there are a lot of staff, and also so many aspects. There is a lack. We have to meet that efficiency. We have to meet that. So many legislations are there. So many resources are there, but they are not utilizing in a proper way to meet the what the extent they are required.
Thank you so much, ma'am.
All right.
Thank you so much.
Thank you so much.
Amruta Mary Locos.
Sir.
Yes, sir.
Ma'am, are you ready with your PPT?
Yes, sir. I will
Please
just
start. Please start your PPT, ma'am. Thank you so much. After Amruta Mary Locos, ma'am, Manish Kumar, and then Dr. Jyoti Bhatia, and Dr. Binu Sui Kurian. Please be ready with your PPT. Over to you, Amrita ma'am.
Yes, sir. Sir, is my screen visible? Sir?
No, ma'am.
No,
It's not visible yet.
Okay. Sir, is this visible now?
Yes, ma'am.
Okay. Shall I start, sir?
Yes, please, ma'am.
Okay. Good afternoon, all. Thank you for this opportunity to present in this platform. So today my topic is green entrepreneurship charms and challenges. I am Amrita Mary Lucas. I am from Kerala. I'm a business consultant and a beginner in research. So moving towards today's topic, as First World War came, Industrial Revolution starts, and industrial goods usage increased because of the reduction in the cost of production. During the before decades, population explosion occurred and living pattern of people changed. Due to that, climate change.
Manish Kumar, sorry to interrupt. Manish Kumar, please stop your screen sharing. Manish Kumar. Yes, ma'am. Go ahead.
Okay. Due to the population explosion and the extensive use of industrial goods, climate change occurred. Pollution, environmental degradation, greenhouse gases, global warming, ice floods are some of the phenomena that can be seen in nowadays. So, green living is the need of the hour or conservation of natural resource along with the usage of the eco-friendly product. Burley in his book says, business opportunities that can save the earth and make you money introduce the concept of environmental preservation, recycling, and renewable energy. He also states, one man's garbage is another man's treasure. Therefore, Burley raises the discussion about green entrepreneurship for the first time. But green entrepreneurship is a relatively new and emerging concept, especially in developing countries like India, where it is not applied extensively. Entrepreneurship is the act of being an entrepreneur or one who undertakes innovations, demonstrate finance and business acumen in an effort to transform innovations into economic goods. This may result in a new organization or may be a part of revitalizing mature organizations. It is the term associated with a business which is concerned about environment-friendly business. In business sense, the term is related to eco-friendly products or green products. Green entrepreneurship gives more ideas to save the nature from the destruction. In an Indian context, the concept of going green is appreciated by very few companies. Green entrepreneurs have high risks in their career to implement their business and make them known to society. What are the characteristics? They should attract the customers. Green entrepreneurs should make the customer understand about the benefit of consuming the green products in the business. Many consumers will think about the green products will cost much to buy, but the green entrepreneurs should make note that they have to encourage the customer that purchasing the green products will give them positive impact. Next is renovation of knowledge. They should be updated as they have high risk in the market and also many competitive products. They have to develop themselves, like reading the new business articles, business news, attending the conference so that the new technology can be obtained, and taking lectures in seminars, etc. The green entrepreneurs have to give much importance to skill-based practices, skill development that makes them to be an effective entrepreneur in the green business. Next is perpetuation of market. Green entrepreneurs have to make the business sustain in the market. The distribution of the products and services should reach the customer in a feasible way. As it is green business, the green entrepreneurs have to give more importance to the packing and transporting the products, such as improving packing procedures without using the plastics, such as to another place, and also the wastage of the materials should be highly reduced. Charms of green entrepreneurship. Environment prosperity. It directly gives its benefit to the environment. Also, they implement new and different ideas to the customers and run the business. Benefit for the business. Public support is high for green entrepreneurship. Green entrepreneurs can directly develop the public relations to execute new ideas to the customers. Green products do not contain much waste or materials in the production process. Opportunities for improving business. Green entrepreneurs enjoys the support of non-profitable organizations, NGOs, government agencies, etc. To opportunity to get sponsorship will be increased for them. Government incentives. Environmental Protection Agency is strict with the business organizations to reduce the pollution in the manufacturing process of the industry. In green business, there is no pollution in the process and there will be less waste materials, so that the government can provide incentives to the green entrepreneurs to highlight the business in the society and can also provide the benefit for the people. Customer satisfaction. The local customer will have the better perception about the company as the surroundings are not highly affected. What are the challenges of green entrepreneurship? Expenses. The investment costs and as well as the value creation costs are very high for green entrepreneurship. There will be only a little savings for them, and the time factor is very higher. Process will consume much time in the business. The entrepreneur has to consider that his products should not contain any environmental impact. In ordinary business, the decision-making process will be quite fast, but in green business, it takes much time to take the decision. It is a challenge that lack of awareness about eco-friendly products and the investment in the community. There is only a limited existing green infrastructure, especially in India. There is only limited knowledge of green technology. Low demand for green products as the cost is high. The people perceive that the cost is high for green products. Limited knowledge of green entrepreneurship. So this, from my study, the suggestions in my paper are enhancing green skills. We should increase the green skills of our entrepreneurs, training and knowledge and experience that can be utilized in adapting technology or materials that minimize environmental hazard. There should be incubators of innovation. There should be a platform for incubation of innovative ideas before they are set in motion, need to be established. There should be public-private community partnership. A symbiotic relationship is the cornerstone of sustainability of green enterprises. The triad can provide the required mechanism for leveraging innovation, technological adaptation, and scalability to reach the bottom of the pyramid. Policy designing. The government should make policy initiatives go a long way in generating confidence and potential to initiate into green venture. There will be more jobs also in this process. The government has to conduct mass communication more vigorously and raise public awareness about the green products, its importance and its advantages to the society and environmental protection. Government has to establish a green society corporation and develop the appropriate institutional factor in order to encourage the entrepreneurs for green business. Financial support and absence of mortgage-free loans. This factor deters a lot of young entrepreneurs from undertaking a risk in the uncharted territories. By this, the end of the presentation. Thank you, sir.
Thank you, ma'am. That was a wonderful topic you have chosen.
Thank you, sir.
Green entrepreneurship. I have one question for you. You mentioned about the policy initiatives which government should initiate some policies regarding green entrepreneurship. Are you aware of any recent steps which were taken by the government regarding the same issue?
Sir, government through their new skill development programs giving importance to green innovation technologies, but the reachability of that programs is very poor in our country.
Right.
That is the problem.
Correct. But definitely the people are now preferring green products, and the paradigm is shifting gradually, but it
Yes.
will happen. That was a very good topic. Thank you, ma'am.
And thank you, sir.
Thank you, ma'am.
Thank you, sir.
For next, Manish Kumar. Manish Kumar, please present your PPT.
Yes, sir. I am hearing. Uh, Due to some, I'm at home. I'm in the office because and some noise are coming from there. So let me share my screen.
Yes, please. Yes, Manish, please start.
Sir. Wait. Due to heavy rainfall, some internet connection is problem coming is from there. Uh, Very good afternoon to all of you. And today's my topic is an empirical study on health insurance emerging sector of Bihar. As it is known to all of us that Bihar is very much uh, backwarded state in India, not only in education but also in health. So let's talk on introduction. The most hazardous COVID pandemic has been proven all over the world that healthy people have been the first and crucial need for development. So the popular saying health is wealth should be changed as health is everything. Health contains physical as well as mental accuracy of an individual. Every time we need to handle numerous situations willingly or unwillingly, which critically affect our mental and physical health. Sometimes these health threats has become very dangerous and capable to collapse our any types of any family member financially, physically, and economically too. Such as coronavirus has exposed the changed the phenomena of the world. In order to reduce the health care burden and save the citizen life, the state have to one the state have only one option to take a health insurance policy and live tension-free life. For this, along with insurance companies, the government still need to introduce some hard measure to enforce some mandatory or universal health insurance scheme for every citizen to live healthy and prosperous life. Under the National Health Insurance and National Health Index report, Niti Aayog 2019, Bihar as the least healthy performing state in India. The union government launched a healthcare scheme called PMJ or Ayushman Bharat Yojana. It is estimated to prove a milestone for the family belonging to living under BPL. And the government is also expecting to build a history in the field of health. According to Health Minister of Bihar, about 2,83,143 people have been gotten the treatment under Ayushman Bharat. About 272 crores money spent on it till June 2021. Despite middle class is not very much excited because they are not they are excluded from the scheme. Therefore, both lower class and middle class immediately need health insurance policy to establish Bihar as a healthy state. The objective of this study is to appraise from every section of household about the awareness, challenges, and preferences of health insurance in the state. To evaluate the various methods of awareness, buying pattern, and willingness to invest money on health insurance in Bihar. To justify the several terms and conditions and claim settlement process of health insurance providing companies on behalf of customers. To ponder how to provide the efficient and effective health insurance services through various companies and governments. To discover appropriate methods to improve and encourage the citizens' buying pattern of health insurance in Bihar. My hypothesis of the study is null is level of awareness among the people is very high in Bihar, and alternative hypothesis is level of awareness among the people is very low in Bihar. These are the literature review, research gap, because some errors may be found in my presentation. Research methodology has been adopted as empirical research. 250 respondents were there. This is the important thing, that awareness level of the health insurance should be improved in Bihar. So these are the points we can go through the system to improve the health insurance awareness level in all over the world, not only in India, because one is advertisement. Advertisement is most important thing for each and every citizen to get anything about any type of knowledge through TV, radio, newspaper, journal, magazine, banner, poster, citation, movie, etc. Social media is also important because it can also increase the health insurance awareness level, and there may be as conference, seminar, road show, human chain, fair and festival, street shows, and schools and colleges.
Manish Kumar, sir,
Sir.
please conclude your topic because the time is.
We have 5 minutes now, sir. Okay, so let's talk on the main point. There is a question that, do you know about the Ayushman Bharat Pradhan Mantri Yojana? It has been taken from Bihar. 72% people are not aware, they are completely neglected that we are not aware about the Ayushman Bharat Yojana. And 63% are aware, but they are not benefited from these schemes. And only 17% people are benefited at the time of 2020. We have adopted to a study, an empirical study through Henry Garrett ranking method. This is the method, the Henry Garrett ranking technique has been applied in the respondents. There is a question. Let's talk there. We can apply through to get at first percent position. The formula is there, and the question was why you have not taken health insurance policy. Please give your response rank wise, from 1 is most important and 10 is least important. The 10 factors which has been taken from the respondents, and respondents answer have been conducted after getting all these proceedings. We can see the formula have been applied, Garrett ranking methods, and the score value has been taken, and average ranking scores findings. So this is the actual finding, which so if you see in the rank, the first rank has been given by the respondents. One rank is unaware about it, means people are completely unaware about the health insurance in Bihar. And second rank has been given by the people low salary or non-availability of funds. They are not able to take health insurance. Third is difficulty to approach the agents, and fourth is no one suggested about it. 5 is too costly and not refundable. This is very important questions, because people always think to whatever we invest, we must get something from in lieu of that. But in health insurance, we cannot get anything if we have not occurred any type of health issues. So let's talk in conclusion. We have taken any other questions and graphs. Do you have any health insurance policies? 81.5% have no any health insurance policies in Bihar, and this is the most important questions for all of the world. Only because do you think that health insurance should be mandatory by the government? So most of the people, 87.5% people have been agree that it must be mandatory, it must be imposed on each and every citizen of the people who are living in Bihar or outside of the state. Because if government apply any type of act, any type of offenses law, then people are bound to follow them. And in this, because health is most important thing, and here government is not taking any type of strict action for this. So let's stop on findings. A very long finding, but I'll conclude my topic. In this period, we must consider that in our life trade, health is an investment, while health insurance is a return on investment. It is providing shelter to all over the world, but people are not very much attentive to in Bihar. Hence, experience feeble economic disorder and not willing to spend on health insurance are most accountable reason to obstructing health perception in the state. Education, income, and methodology adopted are very useful to increase the level of awareness. Health insurance providers required to improve their services and spread their branches around the state. They must present some inexpensive, convenient, and affordable health insurance plan for deprived society. The government ought to make a universal health insurance scheme or mandatory for all. The whole BPL family must be facilitated from Ayushman Bharat scheme introduced by the central government. The undeprived village population unable to afford the health insurance policy, it should also be patronized by the government to avail the health insurance policy by rest of pay. This is bibliography, and thank you. Thank you so much for this.
Thank you, Mr. Manish Kumar. Bihar, considering one of the largest populated states of the country, you have raised a very good issue, and which is
Yes.
also of greater importance considering the current situation. My one question is that when you talk about providing health insurance to all the marginalized and poor persons, do you think
Yes.
private healthcare providers, which are
Sir.
there in the rest part of the country, are they
Sir.
ready to invest in Bihar? Because when it comes to the affordability, the government health services are not adequate, to be very honest. Considering that we need private healthcare sector, are they are investing in Bihar? Do you think?
Sir, actually, most of the investors are very much interested to come at this state, but some issues are coming from very long time, because we think that most of the town in Bihar are very not very much in gathered people, not populated, but all the companies are targeted to invest and target only town areas people, because they are not think to invest in remote areas, and therefore we think that remote areas are mostly inadequate to take these type of things.
Right, right. May I know from which city you are, Mr. Manish Kumar?
Sir, I'm from Arwal district. My district is very small district, second smallest district in Bihar.
All right.
Sir,
All right. Nice. It was a nice presentation. Great to have you.
sir, thank you, sir.
Thank you.
Thank you.
Thank you so much, Manish Kumar.
Thank you, sir.
Our next participant is Dr. Jyoti Bhatia. Are you there with us, ma'am? Dr. Jyoti Bhatia.
Yes, she has raised her hand, sir. Ma'am, can you unmute yourself? You can start your presentation, and also you will have to unmute yourself. All right. And you have to check for the device you are using. You'll find the button, or if you are using a laptop, you can press Control plus D. Control plus D. It's key to unmute yourself.
Okay, now move forward.
Okay.
Dr. Binu C. Kurian. Dr. Binu C. Kurian, sir, are you there with us?
Yes, I can see him. He's there.
So please start your presentation, Dr. Binu C. Kurian.
I believe he is not able to hear us, or Might be he's not there. Although he has joined, he is in the session. Dr. Binu C. Kurian, can you please start your presentation if you can hear us?
Okay, some technical issues with Dr. Binu C. Kurian. Now our participants are finished.
Dr.
All the
Jyoti
participants.
is rejoining again. She has just messaged. Okay. To check the audio, Dr. Jyoti is rejoining again. All right. We'll wait for it.
Abhiyas Singh Chauhan, sir.
Yes, sir.
After Dr. Jyoti Bhatia, ma'am, please go for vote of thanks and complete this national conference.
Right, sir. I guess she has joined again. Dr. Jyoti has joined again. Yes, ma'am, please. You can start.
Yeah, good afternoon, everyone. Can I get the rights to share the screen?
The rights have already been provided, ma'am. If
1
you
minute,
can...
I'll just check. 1 minute. I'll
Yes, yes, yes.
Um,
Rights have already
is
been...
this,
Yes, ma'am.
is the screen visible,
Yes.
please?
Yes, it is visible.
Okay. The topic for today is COVID-19 pandemic and reliefs under Income Tax Act and GST Act. This is Dr. Jyoti Bhatia from St. Andrews College. With reference to my topic, let me make a basic idea over here is that because of the pandemic situation that arose, many deadlines under the Income Tax Act and GST Act have been changed. And what is the relief, whether it's the actual relief to the taxpayers or whether it's a relief for the government authorities, that has been analyzed. The objectives of my study is to first understand the regulatory relaxations to the taxpayers in taxpayers during pandemic situation and to review the impact of these reliefs on various stakeholders. Now, in the literature review, I have included Zulkarian study, wherein he had told, he had done a study stating that in the Asian countries, it would be preferable that, the income tax policies be framed as per the economic crisis, current economic crisis going on or which may be going on because of the COVID-19 pandemic. Gordon in his paper stated that the personal income tax losses, have stemmed from the filing of deadlines in India. And he has also made a study of different states that how the change in the fiscal year to July 2020 may have an impact on taxation policy. With reference to findings, in the phased manner, the rules have been changed. The regulatory details have been changed even during the Atmanirbhar measures that have been framed by the government. Some income tax relief measures were relaxed, and then again later on another measures were relaxed. I mean, it was a phased manner to inform the public that yes, you are getting some measures or you're getting some advantages, some reliefs with reference to taxation matters. Along with that, also some of the litigations which were earlier locked up, okay, have been tried to be released in two areas. One is by releasing the litigation aspects with reference to speeding up of the redressal issues, and second one with reference to asking the taxpayers themselves to come up upfrontly and clarify your dues using Vivad
Dr.
Se
Dr. Jyoti, sorry for the interruption, but I guess you haven't changed your slide, or we are not able to see the next slide. Only the first slide is visible.
Wait. 1 minute. I'll just try it again.
Right.
Yeah, I think. Am I supposed to change it again and again in this presentation slide? Is it so? 1 minute.
Yes, ma'am.
No, 1 minute. But let me try it again now.
Have you logged in from a laptop?
Yeah. 1 minute. I'll just try out.
Yes.
Sure. I think this will work. Is it working? Is this the introduction?
Yes.
Then the objectives?
Yes.
Then the
Now.
literature review?
Yes.
Okay, I think it's working. Thank you.
Right.
The findings are there. Okay. With reference to income tax relief measures, okay, there has been extension. First of all, they started with the belated income tax return. Okay. Then the extension went to the income tax rate applicable earlier. Okay, relaxation started when the pandemic started, this was the situation. Over a period, they started saying that the due date to make the investments also they are extending, because it's a funding issue for many taxpayers, how they will make investments. Over a period, they also started changing the deadlines, that that the deadlines will be again delayed, okay, extended. Now after that, the next issue came with the reference to the employer. So again, TDS certificate and again due date for filing the TDS return started extending. Okay, over a period, you might be observing within this relief measures, they stated that any income tax refund up to rupees 5 lakhs will be issued to the public. Now, also observing till now, if you observe still, the income tax return for the assessment year 2021 will be delayed, and late payment and its penalty. Now, this is again important because the late payment has been there and penalty is there because of the extended deadlines, but nobody is going to get any relief from that. Okay, for that you have to pay your interest on late payment and penalty. So for that, for those taxpayers, it's not any advantage. Faceless assessment has been incorporated now. You can see that till now, in spite of the deadline being considered, more taxpayers have started paying income tax. So why this has happened and how this has been analyzed? Okay, now for here they have also tried to lock up the revenue. Remove the locked revenue which was there in litigation by introducing Vivad Se Vishwas scheme. What is this scheme? This scheme was, in case if you all have any pending income tax litigations, you have to come upfrontly and pay a particular amount as per the interest and the penalty and get your disputes resolved fastest. So here this will be a fast track dispute litigation, but the problem is the taxpayers have to come. Now it was observed that because of this scheme, many companies had come up here to get free themselves from their litigations, so that that particular dispute is permanently resolved. Now, apart from that, even the settling of disputes under the income tax has been entered up, so that now more confidence has been put up among the taxpayers. Okay, now analysis. Here also, if you observe since past 2 years, the government has been trying to remove, the earlier it was like, you go for the first stage, second stage, third stage, and then you finally reach the authorities, and then you get your disputes, settled. But here, when it comes to this pandemic situation, within 2 years, they have made the entire procedure digitalized, and because of that, it is easy for the taxpayers also to get their disputes sorted and to get their refunds made. Now, analysis. It was observed that the taxpayers were really struggling to comply with the deadlines. Professionals stated that everything is a lockdowns. It's difficult for them to function. Okay. After a huge suspense, I would say, authorities started extending the deadlines. And you can say that the measures to extend the deadlines have, of course, assisted the small and middle class assessees to pay the income tax. And they are assessing themselves and they are paying it. Non-corporates, non-auditable taxpayers also experienced a great relief for chartered accountants and other professionals also when the timeline was delayed, etc. But however, if you observe, these deadlines were announced at the dead end or last minute. So till the dead end, you are at a fix whether you are supposed to pay the income tax return or not. So finally, people had continued. They had paid it and then again revised return, and it was observed that the duration of normal returns and the refunds were comparatively in such a slow process earlier that 3 months, 4 months, even 5 months used to take for a refund generation. But now it was observed that within 15 days you will get your refunds back. So what happened is people were not even able to file their revised returns. Okay, so this extension was given at the last minute. So it was applicable mostly for whom? It was applicable only for those people who were mostly last minute fillers. That means my data cannot be filled. So fine, let us keep it. And all of a sudden, the income tax website is stating that yes, your deadlines are extended. So fine, more dates are given. Another thing is faceless assessment, which is now started. Okay, you put your PAN, you put your details, you put your PAN and Aadhaar, and it goes very fast. All your all your data is already there on the website, and it becomes easy and it becomes speedy method to file the income tax returns. And of course, disposal of cases are also very quick comparatively because now the online system has started. Okay, and of course there is a speedy settlement of disputed cases. Conclusion, though we are expecting that there is a lockdown situation, but still the officials are looking at the possibilities to still redesign for some schemes here with reference to income tax. The extension of due date have given sufficient time to regulators to arrive at the schemes for speedy disposal of cases along with the additional compliance, bringing efficiency. And the relief measures of relaxing the timelines for tax filings announced by the government has been a comprehensive measure, at least to deal with the present pandemic situation. But however, it could have been much better if these timelines, would have been announced a bit earlier so that, it becomes easy for people to, study their tax structure. Okay, these are the references, and thank you.
Thank you so much, ma'am. That was a very wonderful presentation from your side. And considering the situation, it was quite important to understand that how this income tax and GST regulations are taking place in the current scenario. But I have one question for you that there were various schemes, as you mentioned in your PPT also, which were provided by the central government for different sectors, especially focusing on the MSME sectors. But again, the salaried class had to suffer the most crucial impact, we can say. They had because of the pandemic, and we have also seen a rise in the number of income taxpayers in this NDA government, and then suddenly after this COVID, a serious contraction in the number of income taxpayers. So, what do you feel? How much time it will take to again normalize the things get normalized again? When do you think this is going to happen, and how these schemes from the government are benefiting those who are seriously impacted by the pandemic?
See, if I'm being asked, let me be very frank here. Point number one, there are many of them whose actually jobs have been who are out from the jobs.
Right,
So as far
right.
as salaried employees you are telling me, let me tell you very frankly, it has been a big hit. Salaried people, so of course taxation goes down. Point number one is that. But
Right.
here, because of additional disclosure, the
Right.
manner in which now the government has come up with the additional disclosure, the moment I put my PAN and my Aadhaar, all my details are coming up directly on the income tax website. So
Right.
automatically it is tracked how many bank accounts I have, how many interest informations I have, how many dividends I have. It is an automatic thing. If I am a director, it is already coming up that I am the director. So now
Right.
there is, earlier it was, people used to feel that should we pay or should we not pay? Can we hide it? But now everything comes clear. That is point number one. So additional disclosure has been major impact in these 2 years, I would say. Second thing, when they are saying to link the PAN and Aadhaar, they are trying to link additionally everything. If you see, the Companies Act has come into joining hands with these people, this income tax authorities. So if you see, whatever is the employee of the company has directly or indirectly been reflected over here on the income tax website, whether you agree it or not. So point number one, with reference to our salaried class, it is reduced. Point number two, with reference to your disclosures have increased. That is why you can see that, the taxpayers have increased. And over a period, it will increase as the disclosures start increasing, the taxpayers increase. Third, but yes, now the confidence has been generated among people, because earlier it was not digital. It was very difficult for any salaried person or any tax assessee to get income tax returns. Refunds from income tax. Okay, around 1 year, 2 year, it was taking. We used to, ask our own financial experts, even we as chartered accountants or company secretaries will be pulled up. Okay, bhai, what about our refunds? But now speedy disposal of cases have come up. So immediately I'm filing my return within 15 days. I'm getting my refunds, etc. Whatever may be there. Okay, even with reference to the query that I have. So it is digital. So since it is digital, it is going faster. So I think, the measures are proper. Plus, it is not like other acts, what I was observing since morning. People are aware of the income tax laws because it is pinching their pockets, maybe, but they are aware. They are, that is why they are making proper investments.
Right.
And with reference to income tax act, I would say the only thing is, certain regulatory measures need to be there only with reference to, if you're making an extension of the deadline, please inform it prior, or take a bit of things so that it gives the sigh of relief. Of course, they have done a lot with reference to the COVID pandemic situation by delaying the deadlines to a major extent, but it would have been quite better if they would have announced this prior.
Exactly.
That is the thing that I feel from my paper. It is.
That was a very wonderful observation from your side, Dr. Jyoti Bhatia, and it was great to listen to you and your presentation. Thank you so much.
Thank you.
All right, then I will once again ask Dr. Kurian if he is able to. Dr. Binu C. Kurian, if you are there. All right, I guess maybe we are not able to reach up to Dr. Kurian, but all right. It was quite a long day, and you all were there from the start till the end, and being such a nice audience, I am definitely ready to give you a vote of thanks, which you deserve. And with that, firstly, I am deeply grateful to all the dignitaries who were present there in this national conference, which was organized by SNS Law College in association with RFI and IMIRC. And they have provided a wonderful opportunity, not only for the participants, but also for all those who are interested in research. Definitely, these small steps are going to take a big leap in future. And with that, I'm grateful to my management, my honorable director, Mrs. Ankita Gupta ma'am, respected management head, Nikita Pandey ma'am, VP Academic Affairs, Ayushi Gupta ma'am, Principal IMIRC, Dr. Sanjay Sharma sir. Your encouragement, support is very valuable for us, and that has made this day possible for SNS Law College. And with that, I would also like to thank the Research Foundation of India, its chairman, Dr. Saurabh Jain, its chief managing director, Professor Dr. Ashok Kumar Gupta sir, and all the respected dignitaries of the Research Foundation of India, with a special mention of the organizing secretary of RFI for this conference and our HOD from the management department, Dr. Parul Sharda. Along with that, I'm also grateful to HOD Commerce, Dr. Reena Gupta, HOD Law, Professor Rahul Joshi, SNS Law College, for their contribution in amplifying our knowledge and for letting us connect to the world of knowledge through the stalwarts of the academic field and with those who have joined us from all the corners of the country, and they have presented their papers in a wonderful manner. It was a lot of learning, a lot of new things which came out, and all those positive discussions will definitely lead us to a better path from day onward. And I'm really very thankful to the team IMI for all your contributions for making this event successful. I'm thankful to coordinators, Professor Aditya Narayan Mishra sir, and Assistant Professor Mr. Keshav Negi sir, Assistant Professor Mrs. Urvashi Sharma ma'am from the SNS Law College for providing their important support and coordination. And all of you, all the students who have participated, once again, thank you for being a wonderful audience. Take care of yourself. We'll hope to have such conferences once again in future whenever the time will allow us. Till then, take care of yourself. Jai Hind.